Audio will on it. Quota
ಪೂರ್ಣಿಮಾ ಮೇಡಮ್ ಕ್ಲಿಯರ್ ಆಗಿದೆಯಲ್ಲ?
ಎಸ್ ಸರ್, ಕ್ಲಿಯರ್ ಇದೆ ಸರ್.
ಓಕೆ, ಆಯ್ತಾ? ಓಕೆ ಮೇಡಮ್, ಒಂದೇ ನಿಮಿಷ.
ಸರ್ ಸರ್ ಸರ್
ಮೇಡಮ್ ಹೇಳಿ ಮೇಡಮ್.
ಆನಲ್ಲಿ ಇದೆ ಅಲ್ಲ?
ಆನ್ ಮಾಡಿದ್ದೀನಿ, ಸಾಹೇಬ್ ಬಂದ ತಕ್ಷಣ ಸ್ಟಾರ್ಟ್ ಕೊಡ್ತೀನಿ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ.
ಸಾಹೇಬ್ರು ಬಂದಿದಾರ? ಅದೇ ನಮ್ಗೆ ಇಲ್ಲಿ ಡಿಸ್ಪ್ಲೇ ಅಲ್ಲಿ ಏನು ಕಾಣ್ತಾ ಇಲ್ಲ.
ಇಲ್ಲ ಸರ್, ಕಾಣ್ತಾ ಇಲ್ವಾ ನಿಮ್ಗೆ?
ಅಂದ್ರೆ ಬೇರೆ ಯಾರೋ ಡೇಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ, ನಮ್ ಸಾಹೇಬ್ರನ್ನ ಅಂತ.
ಸರ್ ಇಲ್ಲ ಬರ್ತಾರೆ, ನಾನು ತೊಂದಿದ್ದೀನಿ, ನೀವು ಒಳಗಡೆ ಇದ್ದೀರಿ.
ಅದ್ರ ಅಡಿಷನಲ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ರೆ 230 ಸರ್, ಮತ್ತೆ ಅದನ್ನ ಹಾಕಲ್ಲ. My lord, cooperative matter, my lord. Cooperative matter, ಅಲ್ಲಿ ಪಕ್ಕದ ಕೋರ್ಟ್
Memo for being spoken, man. Being spoken.
2:30. ಮಾಡಿಸ್ಬಿಟ್ರಾ PDO ಕೈಯಲ್ಲಿ ಮಾಡಿಸ್ಬಿಟ್ರಿ ಕೊಡಿ ನಿಮ್ PDO ಯಾರ ಕೈಯಲ್ಲಿ ಮಾಡಿಸಿದ್ರು ಅವ್ನ ಜೈಲಿಗೆ ಕಳ್ಸೋಣ ಅಷ್ಟೇ.
One matter,
ನಿಮ್ಮ ಹತ್ರನೇ ಬಂದು ಕೇಳ್ತಾನೆ.
mandamus for non-payment of the advocate fees by the corporation. SDMC.
ಏನ್ ಅರ್ಜೆನ್ಸಿ
ನಾಳೆ ಬರ್ಲಿ.
ಸೋಮವಾರ
Monday, okay.
With my lordship's kind permission.
ದಿನೋ ಕಾಯ್ದಿದ್ರು. Yes, Mr. Bhushan Kulkarni.
With my lord's kind permission. My lords, serial number 16, my lords, and serial number 123. My
Serial
lords.
number wait ಮಾಡಿ.
Adjournment.
My lords, I am seeking adjournment.
Adjournments.
ಎಲ್ಲ ಅದೇ ಅಡ್ಜರ್ನ್ಮೆಂಟ್.
Next one, page 19, 88, page 20, 89 to 92.
Page 19, my lord, serial number 85. Needful has been done, my lords. Kindly.
That counsel for the petitioners 85. Counsel for the petitioner submit the needful has been done. Registry is directed to verify and issue notice to respond number 1 and 2, returnable by 24th April. 92. 92. Yes.
Therefore, I request 1 week's time. My lord.
Petitioner inform ಮಾಡಿದ್ದೀರಾ?
92, my lord.
Petitioner inform ಮಾಡಿದ್ದೀರಾ?
ಮಾಡ್ತೇನೆ ಇವರು.
ಬೇಡ ಅವ್ರಿಗೇನು ಅರ್ಜೆಂಟ್ 17 ಮ್ಯಾಟ್ರ್ 92 learned counsel for respond number 1 seeks fund is granted 10 days time to file a statement of objection if any to be filed on or before 25th February, failing which it will be taken as not filed and matter proceeded. Relist on 4th March.
Yes.
These all matters seeking a writ of mandamus by the petitioner. They have to consider the representation. Astay the prayer.
No, my lord. No, perhaps the government council has not read. Already writ petition, writ appeal. Yeah.
Bharat.
Page 21, 93 to 98.
My lord, serial number 95, interim order to be extended, my lord.
Argument ಮಾಡಿ
2 weeks for times.
95 at the request of counsel for the petitioner relist on 11th March, interim order earlier granted is extended till next day.
Page 22, 99 to 101. Page 23, 102 to 105. Page 24, 106 to 111.
Serial number 106. It may be taken on Monday, my lord. And for respondent, I have informed the other side of petitioner.
106 at the request of counsel for respondent relist on 17th. Please.
It's 110 minutes. I appear for the petitioner.
Yes.
Kindly have it on next week notes.
Interim order ಇದೆಯಾ?
Next week. Short.
110 at the request of counsel for the petitioner released on 20th.
No, it's interim order.
Interim order earlier granted is extended till next date.
Page 25, 112 to 115.
13. Inform ಮಾಡಿದ್ದೀರಾ ರೆಸ್ಪಾಂಡ್ಗೆ? And 13 at the request of counsel for the petitioner released on 11th March.
Page 26, 116 to 122.
Serial number 121, Your Lordship. On behalf of petitioner, may I request next week, Your Lordship?
LBUC report filed.
I appear
at the request of counsel for the petitioner released on 20th.
On 19th, Your Lordship. May I request on 19th or 21st, Your Lordship?
21st.
There is an interim order, Your Lordship.
Interim order earlier granted is extended till next day.
Much obliged, Your Lordship.
Adena.
Page 27, 123 to 125.
Minutes. 123.
Milord, serial number 123, Milords.
He wanted that.
Milords, I have to file my.
He wants to file statement of objection. Milords.
Why do you want to file, Mr. Kulkarni? It may be allowed and third.
Milords, I have filed. Milords.
123 at the counsel for respond number.
Sorry, Milords.
Shri Bhushan B. Kulkarni has appeared for respond number 2. Registry is direct. Lead the name of Shri Yogesh Manohar
Milords,
Desai.
both have filed separate wakalats.
Both have filed wakalat. Desai or argument ready both.
Please, Milords. I have filed on 11th. Milords, I will be ready for arguments. Milords.
At the request of counsel for respond number 2. Interim order idya?
Yes, Milord.
Released on 11th March. Interim order earlier granted is extended till next date.
Please, Milords.
Lord, may I make one submission?
Yes, Mr. Naik.
Lord, serial 15. I was supposed to file an amendment application.
50 na?
1515. And I have filed a separate writ petition, Lord, yesterday. That writ petition may be connected along with this matter, Lord. WP.
Connect with WP number?
FR 101254.
And released on 20th.
My lord, apologies, my lord. Serial number 85, my lord. We assert that WP copy for the counsel appearing for respondents in trial court, my lord. It may be posted for preliminary B group, my lord.
ಇವಾಗ ನೀವು process fee ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ notice ಮಾಡಿದ್ವಲ್ಲಪ್ಪ 85.
We also furnish acknowledgement.
Nobody has filed ವಕಾಲತ್. Let us select.
My lord, kind permission. Kind. Seal number 78, my lord. It's a fresh matter, my lord. It's a posted. It's a posted for counsel submission, my lord. It's my post. It's my post. Film hearing ಆಗಿತ್ತು.
ನೀವು submission ಇದ್ರೆ ಹಂಗೆ ಆಗೋದು. ಅಲ್ಲೇ ಆಗುತ್ತೆ orders. It will come. It can't come in preliminary hearing without the clearance.
With my lord's kind permission.
Yes, Mr. Kulkarni.
With my lord's kind permission. My lord's serial number 16, fresh matter, my lords. Recently, my lords have directed me to take notice, my lords. I will buy statement, my lords. I have informed the petitioner, my lords.
LB matter statement.
Correction of a date of birth.
My lords, I am at Gulbarga High Court, my lords. I may be on next week, any date, my lord. I will be ready, my lords.
For the respondent, released on 20th, it is made clear that no further adjournment would be granted.
Please, my lord. Grateful.
Preliminary hearing 1, Girish Dharwad.
May I seek for passover?
Passover.
Please. Learned age appearing in this case.
Either the works executed.
Yes.
2, C.R. Hiremat.
It's a very peculiar case, my lords, wherein, see, one, my lords, the deceased is a mandamus seeking for mandamus. The one, my lords, Channappa Arijan.
Against mandamus.
It's against the, my lords, respondent number.
Prior to the
Two, my
agreement,
lords.
your lordship.
Respondent
Prior to
number
the registration of said date, he died.
That is what, my
No,
lords.
your last, your lordship, the executant. On that basis, your lordship, he made the application for change of name in the entries, your lordship.
Page
but it
31,
was
my lords.
rejected.
Agreement of sale.
Howದು.
Agreement of
Page
sale.
31, my lords, he was my lords, issued within a form of 15. His name was appear. Only thing is, my lords, the further action has not been taken.
Sale deed ಆಗ್ಬೇಕಲ್ಲಪ್ಪ.
ಹೌದು. That is, my lords, the
to execute the sale deed.
That's the person who is died, my lords, Channappa, who is died, my lords, now he is no more. And LRs are no, my lords, there is no LRs.
You have to file a suit for specific performance and then come. Until then,
That will, my lords, again.
agreement of sale, there can't be any entry made.
For that is only annexary issued, your lordship.
ಮಾಡಕ್ಕಾಗಲ್ಲ.
Against, my lords, whom, my lords, that is the.
Or property did sold on the agreement.
ಅಲ್ಲ, the specific performance, my lords.
Half share, Mr. M.M. Kannur, half share, V.S. Talsur Mat. You file a suit for specific.
That, my lords, if it is a, my lords, a person who is, my lords, enter, if he live, my lords, I will, my lords, right to, having the right to, my lords, claim.
Notice
But
for respond number 1 to 3. Petitioner is before this court seeking for the following reliefs. The contention of the petitioner.
May I, my lords, make some, my lords, important points, my lords, because, my lords, it is land which is, my lords, granted under the, my lords, the SC/ST quota. He was, my lords,
Have you got a sale deed?
sale deed, my lords, it is
It cannot-
pending for.
It cannot come in
No.
your name.
That, my lords.
Without a sale deed, it cannot come in your name.
On the basis of agreement of sale, my lords, my
Cannot
name
come.
was, my lords, entered.
ಅದಕ್ಕೆ ಹೇಳಿದೆ ಎರಡು ಅಗ್ರಿಮೆಂಟ್ ಹಾಫ್ ಶೇರ್ ಒಂದ್ ಪೈಸಾನು ಕೊಡಲ್ಲ ನಿಮ್ಗೆ. The contention of the petitioner is that the petitioner had entered into an agreement of sale with one Mr. Chennappa for purchase of land in survey number 4B/18 for a consideration of rupees 4,60,000 on 5/4/2019. Subsequently, the said Chennappa has expired. On the basis of the agreement of sale, the petitioner had approached the respondent authorities requesting for the entry of the name of the petitioner in the revenue records. The same came to be rejected by order dated 14/3/2024 of respondent number 2 Tahsildar. It is challenging the same. The petitioner is before this court. The submission of the learned counsel for the petitioner is that the petitioner has paid most of the consideration and has been put in possession.
Please.
And therefore the entries in the revenue records have to be made. Irrespective of the said submission of the counsel for the petitioner, the fact remains that there is only an agreement of sale in favor of the petitioner and the vendor has expired. It is for the petitioner to get a sale deed executed in favor of the petitioner and only thereafter approach the respondent number 2 as rightly held by respondent number 2 in its order dated, impugned order dated 14/3/2024. Without a sale deed being executed in favor of the petitioner, petitioner cannot claim entry of the name of the petitioner in the revenue records. No grounds being made out, the petition stands dismissed at the stage of admission itself. IA1 is allowed.
3. SK Kaikmat.
My lord, the present writ petition has been filed for not developing the CDP road and also the being agreed by the act of the KSRTC in blocking the CDP road, which is being used by the petitioner and other owners of the Jangamarakopa village, my lord.
In a road form agilla.
Road is the form ಮಾಡಲಿಲ್ಲ, but the road is there. It is being
Road
used.
is shown in the map.
Map, my lord.
But road is not formed.
Not reformed.
Lord AG accepts notice for respondent number 1. SDUDA.
B. Sharanabaswa.
B. Sharanabaswa accepts notice for respondent number 2.
3. Gurudev Gachinmat.
Gurudev Gachinmat for respondent number 3. NWKSRTC.
SC Bhuti. Or Hukkeri adara.
Hukkeri Bhuti.
MC Hukkeri accepts notice for respondent number 4. Counsel for the petitioner to furnish 2 sets of the petition along with annexure on the said counsels. They are directed to get instruction, make their submission if there's any proposal to form a road as per the CDP or not. Released on 24th February.
Macham.
Number 2, my lord, may I request regarding, my lords, approaching of civil court, my lords, at liberty, my lords, because, my lords, no, but
After getting ಅಂತ ಅಷ್ಟೇ. So get this one in ಅವ್ರನ್ನೇ ಕರೆದು ಮಾಡಿ ಇಲ್ಲ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ನಿಮ್ಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ.
ಅವ್ರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಅಷ್ಟೇ. ಅದರ್ವೈಸ್,
ಲೀಗಲ್ ಏರ್ಸ್ ಹತ್ರ ತಗೊಳ್ರಿ.
there is no legal airs as such, my lords. He has also, my lords, made a representation while he was, my lords, live before the, my lords, authority saying that, my lords, there is no legal airs as such. He has also, my lords, made it. He himself.
All options are open to you. Civil court ಅಂತ ಹೇಳಿದ್ರೆ ಆಮೇಲೆ
please
be restricted.
Please.
4. MC Hukkeri.
My lord, petitioner is here and challenging the annexure M, which is issued by respondent number 2. Respondent number 2 is. My lord, the petition number 1 here in the son of deceased one Tulgappa Timmanna, who is the owner of
You
the.
are challenging an order of 22.
Please.
2022 you are challenging.
Yes.
Yes, ma'am. Correspondence is going on, my lord.
Notice for respondent number 1. Respondent number 2 ಯಾರು?
Respondent number 2, Sharanabaswa.
B. Sharanabaswa.
B. Sharanabaswa.
For respondent number 2, issue emergent notice to respondent number 3 returnable by 26th March.
Please.
5, Siddhappa Sajjan.
6, 1 week time, Your Lordship. I seek 1 week time, Your Lordship.
ಮತ್ತೆ ಏನಕ್ಕೆ
To seek instructions.
ನೀವು ಸೀಕ್ ಮಾಡಿ ಅವ್ರು ಕೊಟ್ಟಿಲ್ವಾ, ನೀವು ಸೀಕೆ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ, ಲೆಟರ್ ಹಾಕಿದೆ. I sought to Your Lordship, it was sent on 31 itself.
CCMS ಅಲ್ಲಿ ಕಳ್ಸಿದ್ರೆ ತಾನೆ?
ಕಳಿಸಿರ್ತಾರೆ. Yes, Your Lordship.
ಅಪ್ಲೋಡ್ ಆಗಿದೆ.
Yes, Your Lordship.
ಮತ್ತೆ ಇನ್ನೇನು ಅವ್ರು ಯಾಕೆ ಕೊಡ್ತಾ ಇಲ್ಲ? Learned AGA once again seeks for a short accommodation to obtain instructions. He submits that the above petition has been uploaded onto CCMS and a mail has also been sent on
3/2/2025, Your Lordship.
3/2/2025, despite which no instructions have been received. ಯಾರು ಕೊಡಬೇಕು?
The Tahsildar, Your Lordship.
Respond number 3 is directed to appear before, would be required to appear before this court in person on 20th February if instructions are not received by then. Yes.
6, NR Kuppelur.
The last occasion, my lord,
I was ready to take notice, my lord. I filed Wakat for respond number 1 and 3. Second respondent died, my lord, in the month of January.
Yes.
Not received instructions, but the allegations are made against the respondents saying that they are the reason for the delay. It is not correct, but I will produce the order sheet. I requested the parties to send the order sheet.
The only relief sought, my lord, is to dispose of the suit within 6 months. On the last occasion, in the earlier proceedings, my lord, this honorable court was pleased to direct the trial court to, my lord, dispose of the suit within 6 months. That is in 2022.
Page?
My lord, page 31, my lord. Para 5 and 6, my lord, in para 6, my lord, since there was already an order of status quo, my lord.
They have to dispose it of.
That is true, my lord, but allegations are made against the respondents. It is the petitioner who is responsible for the delay, and secondly, there was a vacancy. The learned presiding officer had gone on this leave for more than 10 months or like that, my lord. For that reason, there is delay, but the allegations are made against the respondent. They can't get away with making allegations, my lord.
Petitioner is before this court. Though allegations have been made by the petitioner against the respondent, contending that the respondents are cause for the delay, Sri P.G. Mowgli, learned counsel for respondents, submit that respondents are not responsible for the delay. Be that as it may, without going into the controversy of who was responsible, taking into consideration that this court, by order dated 23rd May 2022, in WP number 110075 of 2019, had directed the trial court to dispose of the matter expeditiously, preferably within a period of 6 months. The said suit has still remained undisposed. In that view of the matter, the petition is allowed. A mandamus is issued. The mandamus is allowed. The senior civil judge and JMF Siriya Karur seized of OS number 331 of 2017. He is directed to comply with the order dated 23rd May 2022 in WP number 110075 of 2019 with the period mentioned therein extended by a further period of 3 months. Yen stage anide?
Stage cross of PW1.
After 7 years, my lord, they filed
Stage anide?
for cross of PW1, my lord.
Within a period of 4 months from today, the submission of Sri Nagangowda R. Kuppelur and Sri P.G. Mowgli, the respective counsels for the parties on their own behalf and on behalf of the counsels appearing for the parties before the trial court, that they will cooperate with the trial court for disposal of the above matter and would not seek for any unnecessary adjournments, is placed on record. The trial court would be free to deal with any application filed for adjournment or request made for adjournment in the strictest terms, since the submission made by both the counsels is that they would cooperate for expeditious disposal.
Much appreciated.
Third and fourth respondent.
And the AG accepts notice for respondent number 3 and
In earlier petition, C number 5. Third and fourth respondent.
What?
Third and Tahsildar and ADA.
ಇದ್ರಲ್ಲಿ ಇದಾರಾ?
Middle.
AG accepts notice for respond number 3 and 4.
And you also directed Tahsildar to be present. Third and fourth respondent has to furnish the information.
ಇದ್ರಲ್ಲಿ ಏನಕ್ಕೆ ಪ್ರೆಸೆಂಟ್ ಇರಬೇಕು?
Fifth matter.
ಹಾ, ಓ ಇದ ಫಿಫ್ತ್ ಮ್ಯಾಟರ್. ತಹಸೀಲ್ದಾರ್ ಅಲ್ಲ, ತಹಸೀಲ್ದಾರ್ ಅಂಡ್ ADLR. ಫಿಫ್ತ್ ಮ್ಯಾಟರ್.
7 KL party. This is Petturmat.
Case of defection, my lord, wherein, my lord, the councillor is disqualified.
ನೀವು ರೆಡಿನಾ?
Yes.
ಪಾಸು.
Eight Rajshekhar Burji.
Lord, in this case, my lord, a direction was sought, my lord, to the chief officer. Now that, my lord, the chief officer has passed an interim temporary order, my lord, under section 187 plus 9 of the Municipalities Act, my lord. Now I am required to file my objections, my lord, to the said.
Taken under subsection 9 of section 187.
Yesterday, my lord, they have served me the copy of the interim order, temporary order, my lord.
So they have taken action.
Yes. So I'll file my objections, my lord, to that effect, my lord. And
Impugned order.
kindly was it to the.
There is a time bound which has been fixed by the authority. Within 7 days, if you want to suo motu clear the illegal construction, otherwise we will take action. A 7 days last paradalli helidare. An opportunity is given to them to vacate the premises.
Setback violation ಇದೆ.
Yes, ma'am. Lord, in page second, my lord, page 2 of the order, my lord.
ಎಷ್ಟು ಸೈಟ್ ಮೆಜರ್ಮೆಂಟ್ ಎಷ್ಟು?
Total, my lord, sanction, my lord, was 446.94 square meters.
Site measurement ಎಷ್ಟು?
Yes, yes.
60 into 40.
60/40.
Yes.
You reply to this.
Yes, I'll file my reply, my lord.
We'll dispose of
Week's
the
time
matter.
may be granted so that, my lord, after considering my reply, my lord,
They'll pass orders.
let them pass an order. And, my lord, there is a provision, my lord, for regularization of the.
You file an application for that.
Yes, in the reply, my lord.
ನಿಮ್ ಸೆಟ್ ಬ್ಯಾಕ್ ಬರಲ್ಲ, ಎಕ್ಸೆಸ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಬರುತ್ತೆ.
My lord, the even, my lord, in the para 4 schedule, the column ಅಲ್ಲಿ, the extent of, my lord, setback is 0.03. So that can be regularized, my lord, because
setback ಬರಲ್ಲ, Mr. Burji, only construction. Setback, what they had brought about amendment to the Municipal Corporation Supreme Court has stated, that ಬರಲ್ಲ.
I'll file my objections to the.
File your objection, and if you are entitled for regularization, you file an application, they'll consider it.
Please.
Petitioner is before this court.
But that observation may be made, my lord, as per provision 187A, my lord.
Looking for the following reliefs. The conditional learned counsel for the petitioner is, despite the petitioner having complied with all the requisite requirements under law, the completion certificate has not been issued by the respondent. And it is in that background that the aforesaid reliefs were sought for. On appearance, learned counsel for respondent has filed a memo enclosing a notice issued by the respondent under subsection 9 of section 187 of the Karnataka Municipalities Act 1964, contending that there being a violation of setback and the constructed area, the completion certificate could not be issued. If the violations are removed, the application would be considered and necessary completion certificate issued. In view of a notice having been issued under subsection 9 of section 187
Clause.
of the Act of 1964, it would be for the petitioner to either comply with or reply to the said notice, providing necessary explanation for the allegations made. And if the explanation is acceptable to the respondent, the notice would be withdrawn. If not, the petitioner would have to comply with the same. At this stage, Shri Rajshekhar Burji, learned counsel for the petitioner, submit that there is also a scope for regularization
Under 187 EM.
of any excess construction, regularization of the violations pointed out in the notice. If that be so, it would be for the petitioner to file necessary applications, which would have to be considered by the respondents in accordance with law and disposed of as expeditiously as possible within a period of 15 days.
15 days.
The date of reply.
From the date of the reply.
15 days from the date on which the said reply stroke application is made by the petitioner.
Please.
Much.
Petition is accordingly disposed.
9. Sabil Ahmed.
Sabil.
In VC, my lordships. I appear for the petitioner in VC, my lordships.
Yes, Abrar.
Lordships, in this case, Annexure C was my representation dated 4/9/2019, seeking for change of mutation pursuant to a decree of declaration passed in my favor, my lords. That application was kept in abeyance, and on 30/8/2019, the defendant's name was entered in the RTC of survey number 378/1, and the RTC is subdivided into 4 parts, 26 cents each. Thereafter, again, I have submitted a representation on 15/3/2023.
You have not made them parties here.
I have made them. Pursuant to this Honorable Court's direction, I have already made them as a parties, my lords.
Where have you made? You filed an application.
No, my lords. I had added in the cost title of the petition itself.
Yeno Akirla. There's only State of Karnataka Deputy Commissioner and Tahsildar. You can't add. You will have to file an application for impleading.
Sorry, my lords.
And RSA is also pending.
In that RSA, it is dismissed with a punitive order, my lords. I'll seek for a week's accommodation, my lords. I'm extremely sorry.
For the petitioner seeks for and is granted a week's time to file necessary application to bring on record the persons in whose name entries have been made in the RTC.
Sorry.
Yavaga?
20th.
20th.
Much obliged.
10. B. Sharanabasava.
Sharanabasava.
Filed an application for framing additional issues, my lords, and the plaintiffs have also, my lords, stated they have no objection.
You are the defendant.
I am for the defendant.
Suits for?
Suit for injunction, permanent injunction. That claiming the title, my lords, based on the grant made by the land tribunal, that itself I am disputing. And I have sought for
Averment in the written statement.
Averment, my lords, para number 5 has stated the, my lords, true facts, my lords. Param 5A. That's the plaintiff's father was merely an archak in the Anjaneya Swami temple to which the plaintiff scheduled property rightfully belonged. The plaintiff's father cunningly, without the knowledge of the committee of the temple, wrongly applied for grant of occupancy rights under
So you have to challenge the land tribunal's order.
Yes, that is not challengeable. That is not challenged.
How can the civil court frame a issue on that? They are barred from considering this.
Yes, because, my lords, he claims, my lords, that title. Based on that, my lords, I do.
Can the civil court decide it?
Yes, I do admit, my lord, but
cannot decide.
Even the plaintiffs have not stated, my lords, any objection. Allah, that cannot be a ground.
The bar on jurisdiction.
Yes.
Notice to the respondents is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. The respondents had filed a suit in OS number 95 of 2015, seeking for injunction against the defendant therein from interfering with the possession of the petitioner or plaintiffs and or dispossessing the plaintiffs. In the said suit, the defendant filed a written statement contending that the basis of the claim of the petitioner being the land tribunal order, the said order of the land tribunal was passed beyond the period of limitation, has fraudulently been obtained, and is void in law,
And without jurisdiction.
as also without jurisdiction. And in that background, an application and order 14 Rule 5 of the Code of Civil Procedure was filed seeking for framing of additional issues as under page 24. The said application, though not opposed by the plaintiff, came to be dismissed by the impugned order dated 28/10/2024 on the ground that the issues framed cover the issues sought for also. It is challenging the same, the petitioner is before this court. Shri Sharan Basava, learned counsel for the petitioner, submit that the additional issues which are sought to be framed, which are requested to be framed by the defendant, are required to effectively decide the list between the parties. Having gone through the plain written statement and the application and order, Rule 5 of Order 14 of the Code of Civil Procedure, it is seen that what is essentially sought to be contended is that the land tribunal has wrongly granted the occupancy right, and on that basis, the additional issues have been sought for. The civil court, in my considered opinion, would not have any jurisdiction to decide on the orders passed by land tribunal, more so in particular in view of section Bar of Civil Land Reforms and Reforms. More so in view of Section 132 of the Karnataka Land Reforms Act 1961, which bars the jurisdiction of the civil court to decide or deal with any question which is by or under the act required to be settled, decided, or dealt with by the authorities constituted thereunder. If at all the petitioner were to challenge, were to contend that the order of the land tribunal was not binding and or was void and non-est, it is for the petitioner to have challenged the said order of the land tribunal. The petitioner cannot seek for framing of issue in respect of the validity of the order of the land tribunal in a civil suit, the said civil court being jurisdiction being barred in that regard. In view of the above, though not for the reasons stated by the trial court, for the reasons aforesaid, I am of the considered opinion that the additional issues which are requested to be framed cannot be framed in a civil suit relating to injunction. As such, no grounds being made out, petition stands dismissed.
11, Vijay Nayak.
Lords, the petitioner is seeking mandamus, Lords, seeking direction to the senior civil judge to pass early orders on my compromise petition, Lords. Compromise petition has been filed, Lords.
Respond counsel.
Lords, Santosh B. Rawat may be directed to take notice, Lords. He is appearing before the trial court, Lords.
Santosh B. Rawat, submit that he will accept notice.
Please.
For respondent. Registry is direct print his name as such. Where is Rawat? ಕರ್ಕೊಂಡು ಬಂದ್ಬಿಟ್ಟಿದ್ರೆ ಒಂದು ನಿಮಿಷದಲ್ಲಿ ಮುಗಿಯುತ್ತೆ ಮ್ಯಾಟ್ರು.
Lords, he is in another. I will bring him, Lords.
ಎಲ್ಲೋಗಿದ್ದಾರೆ?
Lords, he is held up in another court, Lords.
Paso.
Please.
12, H.M. Dharigon.
For the petitioner.
Yes.
Sincere apologies. I did not inform them.
That is your problem, not our problem. We have informed you.
Because ultimately not 67 acquisition proceedings, 67 acquisition proceedings.
Have you acquired and acquisition
There is no acquisition proceeding.
ಅವ್ರು ಇಲ್ಲ ಅಂತಾರೆ, ನೀವು 67 ಅಂತೀರಾ, ನೋಟಿಫಿಕೇಶನ್ ಇಲ್ಲ ಅಂತಾರೆ.
What has happened, not to kindly see, page 30 minutes, 30.
Yes.
ಈ ಕೊಟ್ಟ ಕಾಗದ ಪತ್ರಗಳ ಪ್ರಕಾರ ಜಾಗೆಯು ಅಜಮಾಸು 1965-66ರಲ್ಲಿ ರಸ್ತೆ ಕೂಡಿದ್ದಾಗಿ ತಿಳಿದು ಬಂದಿದೆ. ಆಗಿನ ದರಗಳ ಪ್ರಕಾರ ನಿಮ್ಮ ಜಾಗೆ ಒಟ್ಟು ಮೊತ್ತ 32 ವರ್ಷಗಳವರೆಗೆ ಸರಳ ಬಡ್ಡಿಯನ್ನು ಆಕರ್ಷಿದಲ್ಲಿ
How can you issue something like this without acquiring?
11,672 minutes was given.
House number ಹೇಳಿ.
Then thereafterwards, what has happened?
State ಹೇಳ್ಬಿಡೋಣ, ಸುಮ್ಮನೆ ಒಂದು 10,000 rupees ಕೊಟ್ಬಿಡೋಣ ಅಂತ.
ಆದ್ಮೇಲೆ what has happened? Contempt proceedings, this was produced. The contempt proceedings and contempt was dropped, accepting it. In view of the letter, proceedings are dropped. However,
Challenging the letter.
Will not bar the complainant from challenging his letter if he feels aggrieved at the matter. Then he changed his version and started claiming that he needs the alternate site instead of compensation. That
Is there an acquisition? Is there an acquisition? ಇದರಲ್ಲೂ PWD ಮಾಡಿದ್ದು ಅಂತ ಹೇಳ್ತೀರಾ ರೋಡು, ಇಲ್ಲ ನೀವೇ ಮಾಡಿದ್ದ? You can't be doing this. You acquire the land, pay the compensation, follow the procedure and do it.
Then I will.
If you have not done it, 67 ಅಲ್ಲಿ ಯಾರು ಮಾಡಿದ್ರು ಅವ್ರಂತೂ ಸಿಗಲ್ಲ ಇವಾಗ.
ಸಿಗೋದಿಲ್ಲ. ಅಲ್ಲ, ಆಮೇಲೆ he started claiming alternate site instead of compensation. That proceedings went on. ಅದು compensation ಅವ್ರು ಬೇಡ ಅಂತ ಹೇಳಿದ್ರು. That is the.
ಇವಾಗ ಅವ್ರಿಗೆ ಲ್ಯಾಂಡ್ ವಾಪಸ್ ಕೊಡ್ಬೇಕಾಗತ್ತೆ without acquiring.
I'll take necessary measures. 10 days.
Shri Gurudev Gachanmat, Learned Counsel for Respond number 2, once again seeks for a week's time to comply with the order dated 4/2/2025.
10 days.
Relist on 24th February. If necessary document relating to acquisition of the property of the petitioner is not placed on record, adverse inference would have to be drawn and the matter proceeded with.
Great.
13.
ಗುಂಟೆ 26 ಗುಂಟೆ ಎಕ್ವೈರ್ ಆಗಿದೆ ಬೈ ಮಿಸ್ಟೇಕ್. 5 ಗುಂಟೆ ಇದು ಫಾರ್ 2B ದೊಳಗೆ ಬರೀ ಬದಲಿ ಇವ್ರದ್ರ ಬರ್ದಿದ್ದಾರೆ.
Your Lordship may.
Take ಹೆಂಗ ಆಗತ್ತೆ Mr.
ಅಲ್ಲ award is passed on the 16/2B only.
This is taking over the land.
For a moment, Your
No,
Lordship may
Not by
peruse the.
mistakes in this.
I produced the sketch map along with the.
Who made the request for entry of the name of NHA, or did the Tahsildar make the entry without a request? If you have made a request, action will be taken against you.
But so many.
If you have not made a request, Tahsildar.
But so many potisas are there, and that.
For a moment, my
There
lords.
could be thousands. It doesn't matter.
As per the ratification, we can write a letter to the AC on 7/2. It is produced with
What basis was
statement
the
of
entry
objection.
made, Mr. Kunur? At the request of NHA, or the Tahsildar on his own made the entry?
Regarding that, Your Lordship, I have no instructions regarding that as well.
Please get that instruction.
And Deputy Commissioner also, Your Lordship, written letter annexer K to the Tahsildar also to take action to change the name.
My lords, in annexure E may kindly be seen, my lords.
Shri B.P. Mathpati, Learned Counsel for Respond number 1 and 2, NHAI, submits that the name of NHAI has been added in column number 9 of the RTC relating to survey number 116, capital A stroke 2 capital A stroke 1B, measuring 5 guntas, situated at Potagondana, Unasi village of Hubbali Taluka, Dharwad district. And as such, which came to the knowledge of the NHA on the representation submitted by the petitioner. The NHA, the SLAO NHA has thereafter written a letter to the Tahsildar seeking for deletion of the name of NHA and adding the Learned AGA submits that the Deputy Commissioner has also made a similar recommendation.
Sir, K, Your Lordship.
If that required to be verified as to on what basis the name of NHA was entered into in column number 9 by deleting the name of the petitioner without the land having been acquired for NHAI. And AGA is directed to place on record the basis on which the third respondent Tahsildar caused such entry in the RTC. If the same is based on any application submitted by the SLAO NHA or NHAI to place the same on record. Relist on 20th February.
Please, my lord.
14, Srinivas Nadmani.
Last time directed the government to get the instruction. Regarding whether any other way.
But as per the instructions given by the Forest Department, my lord, except the present road, there is no other access roads. And since the said road is existing for the last 40 to 50 years, a 3-foot road ashte ide. It cannot be either way expanded or that can be done. That cannot be done since the entire comes under the forest area.
Tender work is only for 20,000 for patch-up work. ಅದು stay ಆಗಿದೆ by the
panchayat. ಹೆಂಗಪ್ಪ access ಮಾಡಬೇಕು ಅವರು?
Please.
3 feet ಅಲ್ಲಿ ಹೆಂಗೆ access ಮಾಡ್ತಾರೆ?
ಅಲ್ಲ ಅದು it is only for the purpose of further after the certain particular area there is a land. Since there is a dispute between the private parties, my lord, we are unable to one or the other way they will object with regarding to constructions or repairing of that work is concerned.
Is it a private land or is it a public?
Private land. That road is only for the purpose of utilization to that private land which is in. Now the person who is the brother of that land, he is objecting for utilization of that road to the present petitioner.
This is an access to the village.
Village illa idu.
One property.
Ashte.
Property ಅಂದ್ರೆ civil dispute. You fight it.
That is the instructions given by the officers.
ತರದಲ್ಲಿ access to the village ಅಂತ ಹೇಳಿದ್ರಿ.
Kindly pass on Gopal Krishna appears. Pass.
15, 16 Arjun, 17 Jagdish Patil. Petition.
Connected with the earlier matter. Another matter is connected with this.
Last date of it, one more matter.
ಯಾವತ್ತಿದೆ ಅದು?
ಅಲ್ಲ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ, ಇಟ್ ಇಸ್ ಲಿಸ್ಟ್
ಇವತ್ತಾಗಿದೆಯಾ? ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ?
ಲಿಸ್ಟ್
ಆಗಿಲ್ಲ
ಕನೆಕ್ಟ್ ವಿತ್ ಸೋ ಅಂಡ್ ಸೋ ಅಂಡ್ ರೀಲಿಸ್ಟ್ ಆನ್ ಅದು
ಯಾವ್ದು
ಯಾವ್ದಿದೆ?
ನಂಬರ್ 2 ನಿಮಿಷದಲ್ಲಿ ಕೊಡ್ತೀನಿ.
ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಡೇಟ್ ಇದೆಯಾ?
40 in the month of March,
listed on
18/3.
interim order.
Interim order earlier granted is extended. IA1 is allowed. Production of certified copy of annexure K is dispensed with.
18 B Sharanabasava.
(2022) order. APMC. And AG accepts notice for respond number 1 and 2, 3 and 4. Shri PNRT accepts notice for respond number 3 and 4. Counsel for the petitioner to furnish 2 sets of the petition along with annexure of the said counsel. We list on 24th February.
19 Sangmesh Gulapnawar.
Number 4 writ petition, my lords. Defend number 4 writ petition, my lords.
Where is Raghavendra Purohit?
My lords, it does not tally with the names, my lords, hence it is not put up. Challenging.
Name may not.
Challenging annexure X, my lords.
He has said
Suit is for partition and separate possession, my lords.
RSA 100408. Lakshman Mulwade is here. His children are here. They are there. The same family, same suit.
Same.
Same RSA.
Now, my lords, during the pendency of the
Satyava yaridu.
plaintiff.
He'll have to be heard. Registry is that print the name of Sri Raghavendra Purohit as that appearing for the caveat and put up the caveat. Since there's only a spelling mistake in the name of the caveat.
Please.
In the caveat, it is being mentioned as SATYAVVA, and in the petition, it being mentioned as SATTEVVA. The register ಈ basis will not put up ಅಂದ್ರೆ ಒಬ್ಬೊಬ್ಬರು ಒಂದೊಂದು ಸ್ಪೆಲ್ಲಿಂಗ್ ಬರೀತೀರಾ? Relist on 17th. Counsel for the petitioner is also directed to serve a copy of the petition along with annexures on the caveat counsel.
Lords, in the preliminary.
In preliminary.
20 Mallikarjun Swamy Kiriyamma. Mallikarjun Swamy.
Tax matter, Lord. Serial number 2021.
Accept notice for respond number 1. HDMC.
HDMC Gurudev Gachinmat.
Gurudev Gachinmat for respond number 2. Petitioner is before this court seeking for the following reliefs. ಅದು ಪೂರ್ಣಿಮಾ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಇಲ್ಲ.
ಕೇಳಿಸ್ತಾ ಇದೆ ಮೇಡಮ್.
ಫ್ರೀಸ್ ಆಗಿದಾರಲ್ಲಪ್ಪ.
94. They are not conducting any education other than that because it is difficult to conduct ಆಗಿದೆ and impose computer ನೋಡಿದಲ್ಲಿ ಯಾರಿಗಪ್ಪ ಅಂತೇಳಿ ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿ ನೀವು ಹೇಳ್ಬೇಕಂದ್ರೆ ನೋಡು ಸೀರಿಯಲ್ ನಂಬರ್ 20, 21, 23, 24, 26, 27. In two matters, my lord, Ballari Corporation are there. Standing counsel is Ballari City.
I have received repetition copy today. 23 minutes and accept notice. 23 ದಲ್ಲಿ
ಬಾಕಿ ಎಲ್ಲ ಉಳಿದರ್ದು ಇವ್ರದೇ ಇದ್ದಾರೆ. ಆಮೇಲೆ ಒಂದೆರಡರಲ್ಲಿ ಪಂಚಾಯತ್ ಇದ್ದಾರೆ.
Serial number 20.
ಯಾರು?
That's serial number 20, 21 and 27. No, Millards, Bhushan Kulkarni. In similar matters here it appeared. We have already served copy.
STMC ಅಲ್ವಾ?
We have already served copy on Bhushan Kulkarni.
ಭೂಷಣ್ ಕುಲಕರ್ಣಿ
20, 21, 27. 21 also Bhushan Kulkarni for R2.
27
Bhushan Kulkarni for R2.
23
23 Millards, Sharnu sir appears.
SS Chalwadi.
Let's
24
24 Millards, it's until we verified we couldn't get the council.
Panchayat. Gram Panchayat Haveri. You will accept. MM Kannur. 26. 26. Madam. 26.
Kajri Millards.
26.
Haveri.
ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಇದು ಕಜ್ರಿ 24.
ಮೇಡಮ್
ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಇಲ್ಲ.
26 Kajri.
ಮ್ಯೂಟ್ ಇದೆಯಾ ನೋಡಿ. 26 ಯಾರು?
26 Kajri Millards.
ರಾಜಿರೆಮಠ್ ಹೌದು. 26 ಮದಮೋಹನ್ ಕನ್ನೂರ್.
ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
27 ಭೂಷಣ್ ಕುಲಕರ್ಣಿ ಇಲ್ಲ. ಆಯ್ತು ಬಿಡ ನಿಮ್ದು.
ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ?
ಇಲ್ಲ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ನೀವು ಒಳ್ಳೆ ನೆಗೆಟಿವ್ ಫ್ಯಾಕ್ಟ್ ಪ್ರೂವ್ ಮಾಡ್ತೀರಾ ನೀವು. ಯಾಕೆ ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ ಬರ್ತಾ ಇದೆಯಾ? ಲೈವ್ ಸ್ಟ್ರೀಮ್ ಮಾಡ್ತೀವಿ ಎಲ್ಲಿ?
ಸರ್ ಕ್ಲಾರಿಟಿ ಇಲ್ಲ ಸರ್ ವಾಯ್ಸ್ ಅಲ್ಲಿ.
ಕ್ಲಾರಿಟಿ ಇಲ್ವಾ? ಇವಾಗ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಇಲ್ಲ. ಯೂಟ್ಯೂಬ್ ಇವಾಗ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಸ್ಟ್ರಕ್ ಆಗ್ತಾ ಇದೆ ಸರ್, ಸ್ವಲ್ಪ ಕೇಳಿಸುತ್ತೆ ಸ್ವಲ್ಪ ಕೇಳಿಸಲ್ಲ.
ಆಯ್ತೇನೋ ಮಾಡ್ತಾ ಇದಾರೆ, ಮಾಡ್ಲಿ ಬಿಡಿ. 20 Shri Bhushan Kulkarni is directed learn AG accepts notice for respond number 1. Shri Bhushan Kulkarni accepts notice for respond number 2. Petitioner is before this court seeking for the following reliefs: the education property tax, reserving liberty for commercial education. 21 Shri learned AG accepts notice for respond number 1. Bhushan Kulkarni for respond number 2. Yes. 24
23 Uncle Millards.
23 AGA accepts notice for petitioner
and
SS Chalwadi also accepts notice for SS
Chalwadi.
SS Chalwadi for respond number 2 to 4. 24.
24.
AGA for respond number 1.
Shivraj Hiremat.
Shivraj Hiremat for respond number 2. Only 2.
Yes, my lords, only 2.
26.
R1 state.
AGA for respond number 1. Shri MM Kannur for respond number 2. 27. AGA for respond number 1.
Bhushan Kulkarni for
Bhushan
auto.
Kulkarni for respond number 2. Ella.
Please.
Yes. We have not served copy on Shivraj Hiremat.
Kodi.
That's one submission.
Liberty liberty fresh water liberty is to the authority if they are functioning other than education they are under survey and liberty there.
Great.
25,
22.
22 KL Patil.
Yes.
Kindly kept Monday, my lord. Some instruction is necessary. But I have given to respondent plot.
CPC lane instruction. An application.
An application under 539 rule 1 and 2 initially.
39 1 and 2. At the request of council for the caveat relist on 17th.
On one submission. Yes. Since we are in possession of the suit property since
1973. We'll give them time. The other things we would not.
Please.
Oblige.
25, Mahesh Kulkarni.
Dependent petitioner, my lords, against the order of issuing order annexure F, my lords, passed by the
39 1 and 2.
Yes, my lords. There is a dispute between the plaintiff and dependent to identification of the plot, my lords. The plaintiff is claiming their property is plot number 64.
So there is an injunction order operating against you from 28/6/23.
My lords, that is true, my lords. But recently,
we won't disturb after 2 years.
My lords, they
We'll
are
issue notice. Let them come.
They are trying to demolish the portion of constructed, my lords.
Issue
In
notice
view of this order, my lords.
to respond number 1 to 5, returnable by 25th March.
My lords.
Both the petitioner and the respondents are restrained from any manner demolishing any portion of the construction put up on property bearing number.
Plot number 16, my lords. In the plot number 16.
Plot number 64.
64 claiming to plaintiffs are claiming plot number 64, but it is actually plot number 16, my lords.
Plot number 16.
Yes, my lords.
In RS number 54/2A.
Yes, my lord.
Azam Nagar, Kangrali, BK village, Belgavi Taluka and district.
Yes,
it is however made clear that the said above order will not apply in respect of plot number 64.
Yes, ma'am.
Process fees and copies to be furnished by end of day 15th February. Acknowledgement for service on the respective council for respondents to be filed on or before 19th February.
Please, ma'am.
Failing either of which, the interim order will stand automatically vacated.
Please, ma'am.
28, Jagdish Patil.
Petitioner.
Yes.
From the date of disposition till 4/1 year also that I am entitled as a interest from the date
Interest.
of yes, sir.
Interest ಕೊಟ್ಟಿಲ್ವಾ?
Interest ಕೊಡಬೇಕಾಗಿತ್ತು from the date of disposition till 4/1.
ಹೌದು.
Only to writ of mandamus.
My lord, KBJNL Mallikarjun S. Hiremat appears.
KBJNL.
Please.
Shri
Mallikarjun S. Hiremat.
Mallikarjun S. Hiremat is directed to accept notice for respond number 1.
2 and 3 GK Hiregaud.
GK Hiregaud is directed to accept notice for respond number 2 and 3. Counsel for the petitioner serve 2 sets of the petition along with annexure on the said counsel. Both the counsels are directed to obtain instruction, make the submission as to whether any interest has been paid on the compensation amount awarded from the date of the notification till the date.
No, from the date of disposition also.
From the
date of disposition till 4/1.
Yes, sir. From the date of disposition till the preliminary notification issued under subsection 1 of section 4 of the Land Acquisition Act 1894. Since the contention of Shri Jagdish Patil and counsel is that the disposition occurred prior to the preliminary notification.
Short, my lords. Any next date because it's
on
only writ of mandate.
24th.
29 GI Gachirmat.
Petitioner, my lords, has lost his land. Petitioner has lost his land, my lords, in road expense.
Good to hear you make this submission. ನೀವು ಯಾವಾಗಲೂ ತಗೊಂಡವರು.
Page 26, my lords.
Yes.
The committee has unanimously decided to allot the plot and a shop as shown below. So, my lord, serial number 8 is the name of the petitioner. Then, my lords, I filed a representation. They did not give me, my lords, any shop. Then a writ of mandamus, my lords, was issued to consider the representation. My lords, they did not consider it. Then I filed a contempt petition. In the contempt proceedings, my lords, page 30 is the endorsement that was produced before the court. May read, my lords, ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಪಿರಾಜಿ ಕಲ್ಲಪ್ಪ ಪಾಟೀಲ್ ಇವರು CTS ನಂಬರ್ ಸೋನ್ಸೋ ಇಲ್ಲಿ ಅಂಗಡಿಯು ರಸ್ತೆ ಅಗಲೀಕರಣ ಸಮಯದಲ್ಲಿ ತೆರವುಗೊಳಿಸಲಾಗಿದ್ದು ಅದರ ಪ್ರಯುಕ್ತ ದಿನಾಂಕ 16/11/2020 ಪಾಲಿಕೆಯ ಪರಿಷತ್ ಸಭಾಂಗಣದಲ್ಲಿ ಜರುಗಿದ ಸಭೆಯ ನಡವಳಿಯಲ್ಲಿ ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ ಕಮಿಟಿ ತೀರ್ಮಾನದ ಪ್ರಕಾರ ಸದರಿ ಅರ್ಜಿದಾರರಿಗೆ APMC ಹತ್ತಿರ ಒಂದು ಮಳಿಗೆ ಮಂಜೂರು ಮಾಡಲು ಕಮಿಟಿ ಈಗಾಗಲೇ ಆದೇಶ ಮಾಡಲಾಗಿದ್ದು ಅದರಂತೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ಪ್ರಕಾರ ಸದರಿ APMC ರಸ್ತೆ ಹತ್ತಿರ ಹೊಸದಾಗಿ ಮಳಿಗೆಗಳನ್ನು ನಿರ್ಮಾಣ ಮಾಡಲಾಗುತ್ತದೆ. ಅರ್ಜಿದಾರರಿಗೆ ಸರ್ದಾರ್ ಹೈಸ್ಕೂಲ್ ಮೈದಾನದಲ್ಲಿ ಹೊಸದಾಗಿ ನಿರ್ಮಿಸಿರುವ ಮಳಿಗೆ ಸಂಖ್ಯೆ 2 ತಾತ್ಕಾಲಿಕವಾಗಿ ಹಂಚಿಕೆ ಮಾಡಲಾಗಿದೆ. ಸದರಿ ಹಂಚಿಕೆ ಶ್ರೀ ಪಿರಾಜಿ ಕಲ್ಲಪ್ಪ ಪಾಟೀಲ್ ಇವರು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. APMC ರಸ್ತೆ ಹತ್ತಿರ ಇರುವ ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಳು ನಿರ್ಮಾಣವಾದ ನಂತರ ಅರ್ಜಿದಾರರಿಗೆ ಒಂದು ಮಳಿಗೆಯನ್ನು ಹಂಚಿಕೆ ಮಾಡಲಾಗುವುದು. This was the endorsement, my lords. Based upon which, my lords, the contempt was dropped. Now, after lapse of 3 years, my lords, they issue an endorsement asking me to pay the rent, my lords, which is at Annexure E. After lapse of 3
allotment
years.
letter.
No, this is the allotment letter, my lords.
This is the allotment.
This is the allotment letter. Kachari Adesha.
Kachari Adesha is the allotment letter.
Allotment letter. Atara our kottu they dropped the contempt. Even in the contempt proceedings, my lords may kindly see paragraph 3, page 33. Learned counsel for the accused number 1 respondent corporation submits that the office order dated 27/7/2022 is passed considering the representation of the petitioner, and endorsement is issued stating that after the construction of a commercial complex, the complainant could be allotted one shop. It also states that shop number 2 is temporarily allotted to the complainant at Sardar High School ground.
So the rental is now sought for shop number 2.
2, my lords, which has been temporarily given to me. So I've lost my land, my lords. They have given me the alternate land, and that too,
number 1
they
yaru Belgavi.
My lords, Arvind Kulkarni. Arvind Kulkarni.
Shri Arvind Kulkarni is directed to accept notice for respond number 1 and 2. The operation of the demand notice dated 16/10/2024 bearing number so and so at Annexure E issued by respond number 2 is stayed till the next date of hearing.
Grateful.
Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the opposite counsel relist on 25th.
Grateful.
30 Kushal NK. Please.
I'm seeking mandamus directing the third respondent to consider my representation.
Yen representation.
Annexure D, page 20, my lords. The earlier, my lordship, the land was re-granted way back in the year 1959, my lordship, to the members of the petitioner, family members of the petitioner.
Consider the representation.
Petitioner is before this court seeking learned AGA accepts notice for respond number 1 to 3. Petitioner is before this court seeking for the following leaves. The contention of the petitioner is that in terms of the Bombay, Paragana and Kulkarni Watans Abolition Act 1950, this is an order of 1959 they want. Please get instruction. You are claiming for implementation of order dated 2011-1959.
Yes, my lord. As per that order, my lord.
From 1959 till now.
No, my lord. As per that order, my lord, the third respondent.
The AGI get instructed. Learn AGI accepts notice for respondent number 1 to 3. The claim of the petitioner is in terms of an order dated 2011-1959 as regards survey number 87 of Siddhapura village, Bilagi Taluk, Bagalkot district. Learned AGI is directed to secure instruction, make a submission as regards the action taken pursuant to the order dated 2011-1959 and whether the petitioner still continues to have any interest in the property or not.
My lord, one submission, my lord.
Released on 24th February.
One submission. In pursuance to the said order, my lordship, my name was entered in the RTC.
Let us get the information.
31 Vivek Mehta.
Suit is for partition and separate possession.
Hmm.
Petitioners are the plaintiffs, my lord.
Hmm.
They moved an application to abandon their claim in respect of Schedule A properties. There are agricultural lands, my lord. In all, it measures, it comes to 39 guntas eno bartide. In that, my father-in-law and their brothers have a share in it. And I will not get 1 or 2 guntas of land that, my lord, they abandoned that claim. That application has been rejected.
You can abandon, but the others don't want to abandon.
My lord, at least, my lord, her husband, she lost her husband. Her daughter is.
It's a joint family property, Mr. Mehta.
Yeah, my lord.
Your abandonment can only be taken on record. And while allotting the share in the preliminary decree, the trial court will say we won't allot anything to the plaintiff. But if the others want any share,
They can take them at melody, excluding my power. It will not disentitle from them getting the share in that property. I only relinquish abandon my claim.
that is taken on record.
Well, for that, my lord, I have to make the parties, my father-in-law and his brothers and all those things. Takes another. If I come out, my lord, the remaining will remain jointly if they don't want to get separated.
Your father-in-law is not a party to the suit.
He is no more, my lord.
So his legal heirs are on record. His legal heirs are on record.
They are my husband's brothers and sisters, my lord.
Huh.
He sued properties solagaste. My father-in-law and his brothers are there.
So, but the rights of others have to be determined.
My lord, when I abandon my claim, my lord, still the other family properties, they remain joint.
Yes.
They can have a claim over that, right?
Even A schedule item 1 to 5, they have a right.
Definitely, my lord.
So that will have to be determined in the preliminary decree.
In those properties, they haven't since I have abandoned the claim. That can be done, my lord. My rejection of my application, that again I have to lead evidence, my lord. They have to be also necessary.
Not necessary. Dismiss it against that the 23 rule 1. What do you say? That property cannot be deleted, Antaste.
Oh, that property cannot be deleted.
That continues. This won't affect you in any manner. Petitioner is before this court seeking for the following reliefs. Notice to the respondents is dispensed with in view of the proposed order to be passed. The petitioners had filed a suit in OS number 121 of 2019 for the senior civil judge at Averi, seeking for partition and separate possession. In the said suit, 2 sets of properties were described in A schedule and B schedule separately. A schedule having 5 items. The petitioner, the plaintiffs had filed an application in order 23 rule 1, read with section 151 of the Code of Civil Procedure, abandoning their claim over the item 1 to 5 properties described in the schedule A. The said application has been dismissed by the trial court on the ground that the other parties to the suit are sharers entitled to a share in the properties. It is challenging the same that the petitioner is before this court. NP Vivek Mehta, learned counsel for the petitioner, submits that the plaintiffs having abandoned their share on their claim in the A schedule property, the trial court could consider the partition of the B schedule properties and partition A schedule properties among the other sharers. And as such, the application could not have been entirely dismissed, but the submission of the plaintiffs ought to have been taken on record. Having heard Shri NP Vivek Mehta, learned counsel for the petitioner, peruse papers. Having gone through the order passed by a trial court, what the trial court has essentially held is that the abandonment of the plaintiff's claim over item number 1 to 5 properties described in A schedule cannot deprive the other sharers of their rights. And it is on that basis that the application has been dismissed. The application, the order does not in any manner indicate that the abandonment of the plaintiffs has not been considered. The plaintiffs having unconditionally abandoned their right in item number 1 to 5 properties of the A schedule, said abandonment would have to be considered at the time of drawing up of the preliminary decree and cannot be considered at the stage of the filing of the application. While drawing up of the preliminary decree, the trial court would naturally look into the aspect of the sharers who are entitled to the share in item number 1 to 5 properties of A schedule, take into consideration the abandonment made by the plaintiff. As such, I am of the considered opinion that there is no grievance which could be made out by the plaintiff in respect of the said impugned order. With the above observation, the petition stands dismissed.
Not dissented from the other defendants claiming right over that property.
Whatever their rights.
Because my lord, otherwise it is 2019, we are in 2025. Making all the brothers of my father-in-law, it takes another 5 to 10 years, my lord. Because her child is Spartic, my lord, that is, she wanted early disposal.
Yes, but it's a suit for partition. All rights have to be determined. It can't be partial partition.
Rajshekhar Burji.
That the order passed by the court below my lord under 21 rule 54 for attachment of warrant my lord.
54.
Yes. Sir, A my lord is the order my lord. Lord, initially my lord, the petitioner borrowed my lord a sum of rupees 12 lakh my lord from the respondent bank my lord, cooperative society. Wherein my lord an ex parte award is passed my lord. Wherein my lord an amount of rupees 14 lakh my lord was to be paid by the petitioner hearing.
Yes.
Now my lord, after the interest and other things my lord, the accrued amount to be paid my lord is 22 lakh my lord 54,000. Now my lord, the petitioner was not served with the award, the proceedings before the arbitrator my lord.
You have not challenged it.
I have advised my lord to challenge that order also my lord.
My
lord, I'll undertake to pay the entire amount my lord. Some breathing time.
How much will you pay now?
My lord, total as per the award my lord 14 lakh 17,000 is the amount. The amount due my lord as per the award. And additional interest at the rate of 17% is charged my lord 8 lakh rupees. So overall my lord 22 lakh is the amount.
54,000.
54,000. 25% my lord, I'll 25% of the amount my lord.
So you'll pay 7.5 lakhs now.
Yes, yes. Some breathing time may be given. The property sought to be attached my lord is 10 acres my lord.
Is 1 crore rupees valuation. Our prakaran 7,50,000 within
2 weeks.
2 weeks. Amele?
Amele 20 remaining another 25%.
By?
Another 2 weeks.
2 weeks. Standing counsel error idara?
Illa.
Issue notice to respond number 1 to 3, returnable by 19th March. Counsel for the petitioner is
may be dispensed because they
also
are the guarantors.
issue notice to respond number 1 returnable by 12th March. Notice to respond number 2 and 3 is dispensed with since they are co-judgment debtors. Learned counsel for the petitioner submit that the award which is sought to be executed in execution number 8138 of 2024 before the 12th Additional District and Session Court Belgavi is an ex parte order. The petitioner was not aware of the said ex parte award, was not aware of the said award, and as such could not make arrangements for payment of the due amounts. The award now having been passed for an amount of rupees 22,54,033.39. The petitioner is willing to make payment of a sum of rupees 7,50,000 given 2 weeks time, that is on or before 27th February, and a further amount of 7,50,000 within 2 weeks thereafter, that is by 14th March 2025. Taking into consideration the said submission, the operation of the impugned order dated 17/1/25 passed by the 12th Additional District and Session Court Belgavi sitting at Gokak in execution case number 8138 of 2024 at Annexure A is suspended. In the event of any default in making payment of the amounts as aforesaid undertaken, by the petitioner, the said order, the suspension would be lifted and the said order would come back into force. Relist on 4th March to ascertain if the first payment has been made.
33, G.A. Gichinmat.
The petitioners, my lords, are the students of Ayurvedic Medical College, different colleges, my lords. My lords, this is for the academic year 2021 and 22. This academic year, my lords, commenced with effect from 11/4/2022, my lords.
Yes.
11/4/2022, my lords, till 3rd of September 2022, the old syllabus, my lords, was taught. The old syllabus, my lords, earlier was only for a period of 1 year. And my lords, on 3/9/2022, they introduced, my lords, a new pattern and new syllabus altogether, which was for a period of 18 months. So, my lords, for a period of 5 months from 11/4/2022, from the date, my lords, on which the academic year has commenced, till September, my lords, the old syllabus, my lords, was taught. Suddenly, my lords, during the mid-year, they introduced this new syllabus. And my lords, the students, my lords, who could have the benefit of, my lords, studying this syllabus, my lords, for a period of 18 months.
The rules were also changed.
Rules were also changed. Then, my lords, the students, my lords, started to face the
Avinash
difficulty.
Angadi accepts notice for respond number 1 to 3. Shri Avinash Bankar accepts notice for respond number 4 and 5.
Yes.
6 to 10 error.
6 to 10, my lords, all the private colleges, my lords, in where the students are studying. Principal.
Standing council.
Standing council, you have to issue notice. They have to take out notice.
Issue notice to respond number 6 to 10. Returnable by 6th March. Counsel for the petitioner is also permitted to take out hand summons on respond number 6 to 10. Considering that the syllabi as also the rules have been changed midway, the respondents are directed to accept respond number.
The examination fees insofar as petitioners are concerned, my lords, before, by virtue of
Respond number 5 is directed to accept the examination fees to be paid by the petitioner and permit the petitioner to take up the exams pertaining to second year BAMS examination, subject to the outcome of the above writ petition. The respondents are directed to file detailed explanation and objection as to how both the syllabi and the rules could be changed after the course had commenced within 2 weeks from today.
Great. May I request for hand delivery because the
Hand delivery ordered.
34, V.V. Somapur.
RP 2023. Yes. Yes, Mr. Somapur.
Please, Mala.
this case, the earlier, the RSA
RP
number,
in RSA.
RSA has been disposed of by this honorable court.
Michael Matadi, ಕೇಳಿಸ್ಬೇಕು.
Earlier, my lord, RSA number 100424 of 2019 has been disposed of by this honorable court.
Yes.
And it was disposed at the stage of admission itself. It was not admitted, the RSA was not admitted and dismissed. And agreed by the said order, the present petitioners had filed review that SLP before the Honorable Supreme Court. And during at the time of hearing, the Honorable Court has opined that on the basis of the opinion that the SLP was withdrawn with liberty to file a review petition before this Honorable Court, my lord. Therefore, the petitioners have filed a review petition before this Honorable Court. The only question is that whether that at the time of hearing of the RSA, the petitioners have produced one document said to have been that family arrangement deed, and it was not admitted by this Honorable Court. That therefore, the RSA has been dismissed. Your Honor, please to see the Honorable Supreme Court has opined that in the case of that reported in AR 2018 Supreme Court 1930, my lord. Para 20. In para 20, it is observed that
one ನಿಮಿಷ. Yes.
In para 20 of this said, your my lord, the lordships have observed that the following substantial questions of law arise in the second appeal within the meaning of section 100 of the code of its decision. Whether the findings recorded by the first appellate court on exhibit A for allowing the defendant's first appeal and in consequence reversing the judgment or decree of the trial court is legally and factually sustainable. Second, what is the true nature of exhibit A? Can it be termed as partition deed or a document recognizing a factum of partition already effected between the parties in relation to the suit? In our case also, we have taken the contention in our written statement itself.
The document.
That in RFA, I have produced that document.
Page.
In RFA, I have produced that.
ಇಲ್ಲಿ produce ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲಿ ಮಾಡಿಲ್ಲ.
Your only ground is that document has to be considered.
Yes.
And you have not produced that document.
RSA.
RSA, you are now in RP. You have to give us the document. Give us the document if you have it. Or copy ಕೊಡಿ. Copy.
That document also was not part of record before the trial court or first appellate court. 4127, they filed it here.
So whether it would have to be remanded, for that we'll have to look at whether it's a partition affected in presenti or it's a recordal of a partition made earlier.
Yes.
Because it's not registered.
It is not registered.
Yes. Partition was affected under that document.
Yes. We have taken the contention in we have taken a contention in the written statement also.
Document kodi, let us see the document.
Wasn't right.
ಏನು ಕಾಣಿಸಲ್ಲ ಇದು.
Because it was not traced out at the time of trial. It was not produced before the trial court or in the first appellate court, my lord. During pendency of this RSA.
Typed copy of this. Admittedly, it is not registered. Typed idea.
Typed copy.
ಅವರು
ಕೊಟ್ಟಿದ್ದೇನೆ
ಟ್ರಾನ್ಸ್ಲೇಟೆಡ್ ಅದ ಇರ್ಲಿ ಬಿಡ್ರಿ, ಓದ್ರಿ ನಿಮ್ದ್ರಾಗ ಓದ್ರಿ.
ಎಸ್ ಓದಿ.
ಟ್ರಾನ್ಸ್ಲೇಟೆಡ್
ಓದಿ ಏನಂತ ಹೇಳುತ್ತೆ.
It is translated copy is there, my lord. ಆಪ್ಸಾತ್ ವಾಟ್ನಿ ಪತ್ರ 1 ಸಿದ್ದಪ್ಪ ಕೆಂಚಪ್ಪ ಹಲಗತ್ತಿ, 2 ಲಕ್ಷ್ಮಪ್ಪ ಕೆಂಚಪ್ಪ ಹಲಗತ್ತಿ ಮೇಲೆ ಸಾಕಿನ್ ಬೆಳ್ಳಿಕಿಂಡಿ. ನಾವಿಬ್ಬರು ಆಪ್ಸಾತ್ನಲ್ಲಿ ಮಾಡಿಕೊಂಡು ವಾಟ್ನಿ ಪತ್ರ ಏನಂದ್ರೆ, ಮೈತ ನಮ್ಮ ತಾಯಿಯ ಹೊಟ್ಟಿಲೆ ನಾವಿಬ್ಬರು ಗಂಡು ಮಕ್ಕಳು ಇರುತ್ತೇವೆ.
ಯಾವ್ದು ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು?
ವಾಟ್ನಿ ಆಪ್ಸಾತ್ ವಾಟ್ನಿ ಪತ್ರ.
ಟೈಪ್ ಕಾಪಿ ಆಫ್ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಯು ಗಿವನ್ ಅಸ್. ನಮ್ಮ ತಂದೆಯ ಅಂತ ಶುರು ಆಗದು ಇದು.
ಅದು ಕಾಪಿ ಅದ ಕೊಟ್ಟೆ, ಒರಿಜಿನಲ್ ಕೊಟ್ಟಿದ್ದೇವೆ.
ಅದು ಕಾಣಿಸಲ್ಲ, ಅದಕ್ಕೆ ಟೈಪ್ ಕಾಪಿ ಅಂದ್ರು. ವಾಟ್ ಯು ಆರ್ ರೀಡಿಂಗ್ ಇಸ್ ಡಿಫರೆಂಟ್ ಫ್ರಮ್ ವಾಟ್ ಯು ಗಿವನ್ ಅಸ್.
ಪ್ಲೀಸ್ ಪಾಸ್ವರ್ಡ್ ಮೇಲೆ
ಕೊಡಿ ಅವ್ರಿಗೆ. ಇದಂತೂ ಏನು ಕಾಣಿಸಲ್ಲ. ನಮ್ಮ ತಂದೆಯ ದಿಸ್ ಇಸ್ ಟೈಪ್ ಕಾಪಿ ಆಫ್ ದಿಸ್.
ಇದು ಬೇರೆ ಇದೆ, ಇದೊಂದು ಸ್ವಲ್ಪ ಬೇರೆ ಇದೆ ನೋಡಿ.
ಮೈತಾ ನಮ್ಮ ತಂದೆಯ
ಟೈಪ್
ಶುರುವಾಗದಿಲ್ಲ.
ಹೌದು,
ನೀವು ಓದ್ತಾ ಇರೋದು ಬೇರೆ ಏನೋ ಓದ್ತಾ ಇದ್ದೀರಾ.
ಇದ್ರೊಳಗ ಇದು ವರದಿ, ಇದು ಎಸ್ ಮಿಲಾಡ್. ನಮ್ಮ ತಂದೆ ಹೊಟ್ಟಿಲೆ ಅಂತ, ನಮ್ಮ ತಂದೆ ಹೊಟ್ಟಿಲೆ ನಾವಿಬ್ರು ಗಂಡು ಮಕ್ಕಳು ಇರ್ತೇವೆ. ಇದುವರೆಗೂ ನಾವಿಬ್ರು ಏಕತ್ರ ಆಸ್ತಿಯಲ್ಲಿ ವಿಭಾಗ ಮಾಡಿಕೊಳ್ಳದೆ ಸಾಮೂಹಿಕ ಹಕ್ಕಿನಿಂದ ಉಪಭೋಗ ಮಾಡುತ್ತೇವೆ. ನಮ್ಮಿಬ್ಬರಲ್ಲಿ ಆಸ್ತಿ ಬಗ್ಗೆ ತಕರಾರು ಉದ್ಭವಿಸಿದ್ದು, ಈಗ ನಮ್ಮ ಏಕತ್ರ ಆಸ್ತಿ ಹೊಲಮನೆಗಳಲ್ಲಿ ಸರಿಯಾಗಿ ವಿಭಾಗ ಮಾಡಿಕೊಂಡು ನಮ್ಮ ವಾಟ್ನಿ ನಿಕಾಲಿ ಮಾಡಿಕೊಂಡಿದ್ದು, ನಮ್ಮ ಆಸ್ತಿ ಆಪ್ಸಾತ್ ವಾಟ್ನಿ ಬೇಸ್ಮಿ ನಮ್ಮಲ್ಲಿ ವಿಭಾಗ ಮಾಡಿಕೊಂಡು ನಮ್ಮ ವಾಟ್ನಿ ನಿಕಾಲಿ ಮಾಡಿಕೊಂಡಿದ್ದೇವೆ ಆಲ್ರೆಡಿ. ನಮ್ಮ ಆಸ್ತಿ ಆಪ್ಸಾತ್ ವಾಟ್ನಿ ಬೇಸ್ಮಿ ಜಮೀನು ರಿಜಿಸ್ಟರ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಇವೆಲ್ಲ ಜಮೀನು ಹಾಜರು ಮಾಡಿದೆ. ಇದಲ್ಲದೆ ಮನಿ ಇಮ್ಲಾ ಇದರ ಅಳತಿ ಪೂರ್ವ ಪಶ್ಚಿಮ 26 ಫೂಟು, ಉತ್ತರ ದಕ್ಷಿಣ 25. ಇದರ ಹೊರತಾಗಿ ಸಾಲ 3500 ರೂಪಾಯಿ ಇರುತ್ತಿದ್ದು, ಇವುಗಳಲ್ಲಿ ಈ ಕೆಳಗೆ ನಮೂದಿಸಿದ ಪ್ರಕಾರ ಹಂಚಿಕೊಂಡಿವಿ. ತಪ್ಸೀಲು ಸೇಜ್ ನಂಬರ್ 1 ಶ್ರೀ ಸಿದ್ದಪ್ಪ ಕೆಂಚಪ್ಪ ಹಲಗತ್ತಿ ಇವರ ಹಿಸ್ಸಾಕ್ಕೆ ಬಂದ ತಪ್ಸೀಲು. ಇಮ್ಲಾದಲ್ಲಿ ಪೂರ್ವ ಪಶ್ಚಿಮ ಭಾಗ ಮಾಡಿ ದಕ್ಷಿಣ ದಿಕ್ಕಿನ ಅರ್ಧ ಹಿಸ್ಸಾ ದಕ್ಷಿಣ ದಿಕ್ಕಿನ ಅರ್ಧ ಹಿಸ್ಸಾ ಹಂಚಿಕೊಟ್ಟಿದೆ. ಜಮೀನದಲ್ಲಿ ರೀಸ ನಂಬರ್ 16 ಎಕರೆ 10 ಈ ನಂಬರ್ ಪೂರ್ಣ ರೀಸ ನಂಬರ್ 17 ಪೈಕಿ 10 ಎಕರೆ. ಇನ್ನುಳಿದ ಸರ್ವೆ ನಂಬರ್ಗಳಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ನೇತ್ರದಲ್ಲಿ ಉಳಿದ 10, 35 ಎಕರೆ ಇದರಲ್ಲಿ ಅರ್ಧ ಹಿಸ್ಸಾದಂತೆ ಹಂಚಿಕೊಟ್ಟಿದೆ. ಸಾಲ ಪೂರ್ಣ 3500.
ನೀವು ನಮ್ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ, ನೀವು ನಮ್ ಕಾಪಿ.
ಇದ್ರೊಳಗೆ ಸಾಲ ಒಬ್ಬರಿಗೆ ಕೊಟ್ಟಿದೆ, ಹಿರಿಯವನಿದ್ದು ಅವನಿಗೆ.
ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ ಇಲ್ವಾ?
ಕಾಪಿ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ.
ನಿಮ್ಗೂ ಕಾಪಿ ಇಲ್ವಾ?
ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ.
ಮೇಕ್ ಎ ಕಾಪಿ ಅಂಡ್ ಗಿವ್ ಇಟ್, ವಿಲ್ ಪಾಸ್ ಓವರ್.
ಪ್ಲೀಸ್
ಇದು ಕೊಡಿ, ಒರಿಜಿನಲ್ ಅವ್ರಿಗೆ ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ. ಪಾಸ್ ಓವರ್.
May I rather request tomorrow, Millards?
ಕೊಡಿ ಕಾಪಿ. Let him also go through it, get instructions.
Tuesday.
Counsel for the petitioner is directed to furnish a type copy of the partition deed to the counsel for the respondent, as also produce the same before this court. Relist on 18th at 2:30 p.m.
Please.
35 Ravi Kumar Bokakkar. For the respondent.
Last occasion, my lord, I sought time, my lord, I appear for the only respondent number 3, my lords. Now, my lords, undertake to all the respondents, my lords.
All the respondents.
Out of that, my lord, 3 respondents were dead, my lord. I filed a memo for reporting death of those respondents, my lords.
Shri A.S. Patil, who has appeared for respondent number 3, submit that you would also be appearing for
4 to 10.
Who is expired?
My lords, respondent number 3, 6 and 7. I filed memo, my lord, to that.
ಯಾವಾಗ ಫೈಲ್ ಮಾಡಿದಿರಪ್ಪ?
ನಿನ್ನೆ ಫೈಲ್ ಮಾಡಿದೆ lords.
ನಿನ್ನೆ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಬರಲ್ವಾ? How can it come in one day?
Please, your lordship.
So first ಯಾರು who is expired 3?
Respondent number 3, my lords.
ಆಮೇಲೆ
Respondent number 6 and respondent number 7.
So you can't appear for them.
Yes, please, your lordship.
Shri A.S. Patil submitted that you would be appearing for respondent number 4, 5, 8 to 10.
Please.
Registry is directed to print his name as such. His further submission is that respondent number 3, 6 and 7
please
have expired. None appears for the petitioner. 2 weeks time is granted to file necessary application to bring the legal representative deceased respondent number 6, 3, 6 and 7 on record. The details of legal heirs
please
to be furnished by Shri A.S. Patil to Mr. Ravi Kumar D. Gokakkar within a week from today.
Please, your lordship.
Released on 3rd March.
Published.
36 J. Shetty.
For the petitioner, the impleading application filed by the other side, my lord, in fact, my lord, I requested for time last occasion. My lord,
Requested time last time.
Yes, last
given.
time, my lord,
This time no time.
on Monday, my lord, I will file. My lord, so far as the objections is concerned, objections to the impleading application, they are no way concerned to.
7 matter, Mr.
Yes, my
Shetty.
lord. Now the
Probably most of the matters before this court which are old are yours.
yes.
ಎಲ್ಲರಲ್ಲೂ ಟೈಮ್ ಕೇಳ್ತೀರಾ ನೀವು?
ಅಲ್ಲ, ಇದರಲ್ಲಿ application has been filed on 20th January. In fact, ಅಲ್ಲ, they are no way.
20th February.
ಅಲ್ಲ, oral objection may kindly.
Oral objection ಹೇಳಿ.
They were no way concerned to this pap. How they are?
You are appearing for here.
They are LRs of the min pro.
Ready na? ಅವ್ರ ಮೇಲೆ ಫ್ಲಾಟ್ ಮಾಡಿ ನೀವೇ ರೆಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಪ್ರಶ್ನೆ. Are you ready?
No, well.
Where's Shriyas? ಎಲ್ಲಿ ನಿಮ್ ಸೀನಿಯರ್?
He is held up in another court.
Pass over. Call him.
Monday, my lord. I'll in meantime.
ಅದಕ್ಕೆ ಅರ್ಜೆಂಟ್ಮೆಂಟ್ ಬೇಡ.
ಅಲ್ಲ, so they are no way concerned. My lord, that's part of your say.
We may accept your submission or reject your submission, but let's do that. It's a 2011 matter.
Yes.
We don't know what we are, after hearing both we'll pass.
Yes, ma'am.
37 Shivkumar Badwadgi.
For respondent. Respondent has filed the applications claiming 17 beverages.
I am for the Vina agreement. Kindly next week, my lord. Ma'am will not feeling well.
17
They
we
wanted
pay.
to.
Yes. No, next week. Already you have taken time.
At least tomorrow, my lord.
Pass over. Or we'll direct you to. You are challenged that you have to pay
Madam
17.
wanted to appear in VC, my lord, but
Let her
throat
appear in
infection
VC.
is.
Pass over.
This.
38 Prithvi KS.
Petition number 4 has expired, my lords, on 28/1/21. 4A to 4E, my lords, are the
28/1?
28/1/2021.
28/1?
2021.
25.
21.
21.
Please.
Application filed on?
My lords, 11/2/20. 928 days delay.
Petition number 4 is stated to have expired on 28/1/2021. Hence, IA 1 of 25 has been filed on 11/2/2025 to bring the legal heirs of the deceased petition number 4 on record. Accepting the reasons stated in support of IA 1 of 25, the delay of 928 days is condoned, subject to payment of cost of rupees 2,000 to the advocate's clerks, so and so fund. The abatement in respect of respondent number 4 is set aside by allowing the said application, petition number, the person named therein are brought on record as petition number 4A to 4E, taking into consideration that the right to sue survives, more particularly when the above matter is relating to a land reforms proceedings. Counsel for the petitioner to carry out necessary amendment and file amended cost title within 2 weeks from today.
Short matter, your lordship. The owner, your lordship, now claiming that I am the one of the owner on Thursday. Earlier owner, your lordship, has accepted our tenancy. Now the one of the branch, your lordship, that the
So you are now
Tuesday.
appearing for
No, but
8 and
I'm
9.
for the tenant, your lordship. The tenancy has been granted to me.
So TM Nadaf and Bhaskar Patel delete ಮಾಡ್ಬೇಕಾ?
Yes, ಅಲ್ಲಲ್ಲ.
He is, yes, my lords.
ನೀವು appear ಆಗಿದ್ದೀರಲ್ಲ?
ನಾನು appear ಆಗಿದ್ದೀನಿ. ಇವ್ರದ್ದು delete ಮಾಡು.
Shri Jagdish Patil has appeared for respond number 8A and B, 8C 1 to 3 and R9. Hence delete the name of TM Nadaf and Bhaskar L Patil as appearing for them. Relist on 24th February.
Please.
For auto, you will also file for respond number 2.
ಆಗಿದ್ದೀನಿ.
AGA for 1 and 2 ಆಗಿದೆ.
Please.
Parts ಏನಾದ್ರು ಬೇಕಾ ಬೇಡವಾ?
ಬೇಡ.
ಬೇಡ. The submission of both the council that records are not required is placed on record.
Yes.
ಆಮೇಲೆ ಶುರು ಆದ್ಮೇಲೆ ಬೇಡ.
ಇಲ್ಲ ಇಲ್ಲ.
39 Sunanda P. Patil.
My lord,
For response.
the petitioner has filed this petition for quash of annexure G and F, that is the orders passed by the respond number 1 and 2, your lordship. That is the name of the petitioner came to be entered in the revenue record of the petition property on the string after the death of his father as a legal representative, your lordship. And the same was challenged by the respondents 4 to 8 by filing an appeal before the respond number 2, your lordship. And that appeal was, and there was a delay of 12 years. They have filed an application at annexure D, your lordship. And in the application affidavit, they have contended that they were under the impression that the name of their father was entered in the revenue record of the suit property, petition property, and they have not preferred an appeal within a limitation period, your lordship. And they are contended that the sale deed was executed by the father of the petitioner in the year 1960, your lordship. And the name of their father was not at all entered in the revenue records of the suit property, petition property till 2022. That appeal was filed in the year 2022, your lordship. And the respond number 2, without giving an opportunity to the petitioner, has allowed the application, and thereafter the notice was issued to the petitioner.
Allowed and then notice.
Then notice was
Where is
issued. Annexure F, your lordship.
Page.
Page number 34, your lordship.
ಮನ್ನಾ ಮಾಡಿ.
Please, my lord. Without issuance of notice, they have.
And then thereafter notice.
They have issued notice, your lordship.
Lord, may I make submission, my lord, on this? My lord, in their written argument, my lord, they have not taken any contention regarding the delay, my lord. And
in the face of the order, it is bad. How can condemnation of delay be granted without notice? Opportunity has to be given to both.
Please.
We'll remand it, let them consider.
Please.
The petitioner is before this court seeking for the following reliefs. Though various grounds have been urged in the above petition challenging the order dated 21/9/2023 in RB/RTA 289/2022-23 passed by respond number 1 at annexure G, and the order dated 29/2020 passed in RA 86/2022 by respond number 2. What can be seen from the order dated 29/2022 passed by respond number 2 is that the respond number 2 had condoned the delay by allowing the application filed under section 5 of the Limitation Act and thereafter issued notice to the respondents. Such a procedure is unknown to law. Whenever any proceedings are filed, and in those proceedings, the delay is sought to be condoned, the notice would have to be essentially issued to the opposite party. Thereafter, the application for condonation would have to be considered on the basis of the submission made by both the councils, both the parties. In the present matter, the petitioners have been deprived of objecting to the application for condonation of delay. The delay having been condoned ex parte in their absence. In that view of the matter, I pass the following order. Writ petition allowed, so and so are quashed. The matter is remitted to respond number 2 for fresh consideration by permitting the petitioner to file objection to the application under Section 5 of the Limitation Act and affording an opportunity to the petitioner to address, to both the parties to address their arguments on the said applications.
Lord, within a specific time, Lord, it may be disposed of.
The objections to Section 5 application would have to be filed by the petitioner within 10 days from today.
Please.
That is on or before 25th February. The said application would have to be considered and necessary orders passed by 26th March.
Please. Please.
40, Lingaraj Maradi.
Seek for a week's time.
Some
Some documents are
submission, my
not
lord.
produced before this honorable court. Some documents are not produced. James
Submission.
said,
There is a consideration of interim prayer, my lord. Without considering my objection, my lord, they have passed a final notification. As per the section 3C of the National Highway Act, they have to conduct an inquiry and issue notice to the petitioner, my lord. And even the joint measurement survey is also not conducted, and they are trying to purchase the petitioner from the property, my lord. As per Annexure A photographs, my lord, there is a structures of Kalyan Mandap and all are there. Without evaluating those properties also, they were now they are ready to.
Is there award passed, Mr.
yes,
Mardi?
yes, my lord. Award is passed, my lord. So those documents I want to produce before. Please.
Put your one copy.
Please.
Have you taken into account the
I have not
developments?
produced along with the statement of objection, so I want to, I produce them as additional documents, my lord.
Installments.
That they have already filed a statement of objection.
This award has been passed on 25/8/23.
And till today, they have not served the award to me, my lord.
One by one,
Please,
as I
ma'am.
considered, let us see.
Please, please,
You also see whether they have given you the money that you want.
please.
Your only this one is that the valuation of the building has not been done, is not going to be done.
Please.
Check if it has been done. In the survey number?
8/4, my lord.
Survey number 8/4.
Land dry. L 8/4, L 8/4. Award is passed.
Is in the
Value of
page number
structure
13, my
zero.
lord. At the value of the structure is 0 anta ಮಾಡಿದ್ದಾರೆ.
Where is the photographs of the structure?
It is annexure A, my lord. These are the photographs, my lord. At annexure B, my lord, annexure B in the page number 15. These are the structures are situated in that land.
Where is the plan sanction for the structure?
And even in the preliminary notification, my lord.
Plan sanction, ಅದಕ್ಕೆ
ಅದಕ್ಕೆ
notification before preliminary or after preliminary? Where is the plan sanction?
That copy has been not heard to me, my lord. And till today, we have filed a RTA application to record the.
Already ನಿಮ್ಮ plan. You have built the structure. You should have obtained a plan sanction.
Plan sanction.
When did you obtain the plan sanction?
The records I have not produced, my lord.
So you produce that.
Please,
is it prior to the preliminary notification or after?
It is admittedly, it is held to the notification, my lord. Because last 20 years we have.
You produce a model admission.
Please, in the last 20 years we have constructed that building, my lord, and there is a regional community activities has been conducted.
20 years. It doesn't look 20 years.
Please,
but if it is 20 years,
please, my lord.
You will have to produce the plan sanction.
Please, my lord.
Taxes paid on the
please
constructed area.
Please.
As commercial
Because you are saying it's a community center.
And to conversion
produce
order
that.
also.
Then we'll ask Mr. Patil what he did with those documents.
Please, Milord.
Mr.
Lord, till that they are trying to.
Mr. Patil, learned counsel for respond number 2, NHA, submit that an award has been passed on 25/8/2023, considering all the relevant aspects. Sri Lingaraj Mardi, learned counsel for the petitioner, would however submit that the petitioner, having put up construction of a community hall for 20 years ago,
20.
there is no valuation which has been made in respect of the said constructed area.
Please.
He seeks for and is granted a week's time to place on record the plan sanction obtained from the concerned authority as regards the said construction, as also the necessary documents relating to property tax, electricity connection, and or the like, to evidence the date of construction and extent of construction, so as to ascertain if the same was prior to the preliminary notification under section 3A1 of the NHA Act or subsequent. Relist on
In the next week, Milord.
Relist on 20th.
Please. Lord, till that date, Milord, they are trying to this possesses, Milord.
You will get your money, Ashta.
No.
The acquisition is complete. Your only issue is that the valuation has not been done.
In this case, Milord, joint measurement survey till today has been not happened.
James has been done.
James is not
James has
happened.
been done. So all those documents I'm
is
producing.
also directed to place on record the joint measurement report.
Please.
Respect to the
I
property.
will produce it.
Please.
41 Srivatsa Hegde.
Yes.
Yes.
Here.
Lord, petition is by judgment debtor number 4. She is the niece of the decree holder's first respondent, Lord.
Niece of. She is not a decree holder. She is a judgment debtor.
No, it's a suit for partition, Lord. And it turns out that I made an application in the regular appeal to carve out my 1/9 share. I was not initially added as a party. I was added subsequently, but nevertheless, I did not contest the suit or any other proceeding, Lord. In regular appeal, for the first time, I made an application for carving out my share. This first respondent, Irana, is, my lord, my maternal uncle. So he is entitled to 1/6 share in his maternal uncle, my mother's brother, my lord. Now, what I made, I requested was to carve out my share. The appellate court rejected my application because I did not
How
contest.
are you entitled for any share in your maternal uncle's property?
No, my property is my grandmother's property, my lord.
Grandmother's property?
Yes.
Self-property under section 14?
Yes.
So you are claiming through your mother?
Yes, my lord. And the first appellate court rejected my application. Then I came up with this application under section 47 in the executing court, saying that my right is also recognized once if the decree holder is granted a right. My right is also recognized because I am his sister's son, a daughter. Therefore, carve out my 1/9 share. I also made 2 other applications, my lord, either to purchase my share or to sell his share at the prevailing market rate. All the applications came to be rejected, my lord. Now, what I'm left with is only to file a fresh suit for partition in the share allotted to this first respondent. Now, only to avoid all this, I made all possible alternatives. I tried everything. I made a proposal to buy out his share at the prevailing market rate. I made a proposal to, sell my share.
They are not even recognizing your share.
There is no such thing.
You want to buy the entire property, including your so-called share, they'll be agreeable.
Hardly, my lord. It's the 1/3 share comes to 10/90. So making
Not capable of paying party.
Yes.
My respectful submission, my lord. She is the party to the before this proceedings of partition as the 1989, my lord. In that suit also she is party. She not claimed her share. That is still Supreme Court, the trial court judgment and confirmed, my lord. They have prepared the FDP array against the FDP. What the allotted the share in that FDP proceedings, they have prepared the appeal. In that appeal also, she is the party, my lord. She not claimed any share in that district.
Even though in all proceedings.
Yes, my lord. Still SLP also, my lord, she not claimed any share, my lord.
Why were you keeping quiet for this 25 years?
My lord,
My lord, I am a married woman, my lord, and I did not even contest the original suit. I was not even initially made a party.
Yes, then you came on record.
I came on record,
You
my
were
lord.
brought on record.
I was brought on record.
Where is that application to bring you on record? What is the contention there?
No, I mean, that is not part of the record.
In all,
The admission that you have a right in that application.
Perhaps it will come out, my lord. I may require some time to get those
Who
documents.
filed the application to bring you on record?
This first respondent, my lord, he was the
Maternal-
plaintiff.
Your
Yes.
maternal uncle.
Yes.
What is the admission made by him?
I will have to find out. No.
Find out and place it on record.
Yes. Monday or Tuesday, my lord.
Sigata astrologe.
My lord.
You'll get the application by then?
Maybe, my lord, or a week's time, my lord.
Lord, counsel for the petitioner seeks for and is granted a week's time to place on record the impleading application filed by respondent number 1 to implead the petitioner in RA number 303 of 2019.
Yes.
Released on 20th February.
please, ma'am.
If you have made a assertion there that she has a right,
I will.
then you better settle.
Yes, ma'am.
If you have not made, then you file a separate suit.
Yes. Interim order.
Interim order earlier granted is extended till next date.
HM Dharwad.
Lord, this matter was heard and dictated. Thereafter, a submission was made by the respondent that there is a connected writ petition filed by them. So, my lord, the lordship's adjourned.
Yes.
Please.
Early dictated, early.
Lordship, in this case, I have filed a
By the 74, 65, 64.
please.
Yes.
Lordship, they have
The next one, Dharwad.
and the non-compliance.
Non-compliance.
Please. Lordship, I have challenged the Annex A wherein Annex J in the connected petition. Order passed by the Tahsildar dated 16/5/24. Now they want to sort for implementation of this order. Now the petition in the first petition sought to implement this order.
The challenge, we'll have to hear the second matter before we come to your matter.
Last occasion, your lordship, my lord, already dictated the judgment.
Yeah, but now that there's a challenge.
No, my lord, the
My submission.
urgency is, my lord, the entire road is, my lord, collapsed by the, my lord, the response
This order has
7 to
been
9.
passed without intimation to the present petitioners, without inquiry, only on the basis of the representation submitted by the present respondents. Passed an
Not
order.
made them a party.
Yes, Lord.
Knowing fully well that they have filed a petition.
They are
earlier.
already party in.
In the your
I
petition.
am
you are
challenging
not-
only government order, therefore I am not made as a
Who
party.
is going to get affected?
Lord,
Who is going to get affected?
if order is set aside, the and one more submission,
If order is set aside, who is going to get affected?
then I will implement them also a party to the proceedings, Lord.
Why are you doing like this, suppressing the?
I am not suppressing.
ಅವತ್ತು argument ಆಯ್ತು ಅಂತ ಇದು ಬಂತು.
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಇಲ್ಲಾಂದ್ರೆ
ನಾನು
this would have come separately.
ಅರ್ಲಿಯರ್ಲೆ ಕನೆಕ್ಟ್ ಮಾಡಿಸಿದ್ದೆ, ಅದು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಇರೋದ್ರಿಂದ ವಿತ್ ಕಾಸ್ಟ್ ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್
Dharwad,
ಡೀಲಿಂಗ್.
you appeared in that petition.
Then only I came to know that this order has been passed. Thereafter I have filed a writ petition.
So that is why you have to make them a party.
ಅಲ್ಲ ಯಾರು ಇಲ್ಲಿ
On
ರಿಪ್ರೆಸೆಂಟೇಷನ್
that ground only we'll dismiss this.
ನೋ ಅವ್ರು ಯಾರು ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಅಂತೇಳಿ ಬರ್ದೇ ಇದ್ದಾರೆ, ಅರಿಶಿನಾಳ ಜನ ಅಂತ ಬರ್ದಿದ್ದಕ್ಕೆ ನಾನು ಐ ಆಮ್ ನಾಟ್ ಮೇಡ್ ಎಸ್ ಎ ಪಾರ್ಟಿ ದಮ್. Now
Submission ಏನು?
I will implement, Lord. I will implement
When
them.
you appeared in 103805,
Please,
you came to know about this order.
please, Lord, please,
So you should know who has filed this petition.
please. I will implement them also
This
party.
is a deliberate suppression.
No.
Deliberate.
And then one
There
more,
is
one more submission. It is not required to one person or two person. It is a general public. The road is used by not only one person or two person, it is used by entire village.
You should have at
And
least
after
made these
filing
people a party.
wakalat in this petition, malad they file a writ petition.
Yes, ನಾನು admit ಮಾಡ್ಕೋತೀನಿ ಅದನ್ನ. I came to know that.
Ground will be held against you because we'll be noticing that now. Yeah.
I will implement them as a party.
42.1. Learned AGA accepts notice for respond number 1 to 5. The petitioners in WP number 103805 of 2024, though not brought on record in these proceedings, would be entitled to file their objections in the matter. This being so, for the simple reason that WP number 104698 of 2024 was filed on 22/7/2024 after the petitioner in the said matter had entered appearance in WP number 103805 of 2024. And at this stage, I am of the considered opinion that the petitioners therein have been purposely not made a party
That's one submission.
to the present writ petition,
Before going to
knowing fully well
before going to that,
of the filing in WP number 103805 of 2024.
one submission. In the last hearing date,
Address arguments on merits, any legal argument. Don't try to do this.
please. Then one more submission.
This is all abuse of the procedure.
And one day submission. In the last hearing, after hearing the matter, I have produced one order passed by the
We'll
Tahsildar.
hear you. Let them file their objection to
Tahsildar.
this. Next week,
Please,
we'll take it.
please.
And pass orders on both. Serve copies on everybody.
Now only I will comply in the
Comply
past.
with the office objection.
Please.
Counsel for the petitioner is directed to furnish copies of the petitioner along with all annexures.
Please.
On the learned AGA and Shri H.M. Darigaon, who seek for and are granted a week's time to file their objections and get ready to address arguments. In the meanwhile, office objections to be complied with by 19th February, failing which the petition would be liable to be dismissed for non-prosecution. Released on 20th February.
I will implement them as a party to the person.
We have permitted them whether you make them a party or not.
For technical purpose, I will implement them also.
Anyway, a common order will be passed, so it doesn't.
Please.
Don't do this trying to take advantage.
No. ನನ್ನ specific ground ಇರೋದೇನೆ.
Nim ground ಏನಿದ್ರೇನು, once you know that there's a petition filed by them, it was your duty to make them parties.
Please.
This leaves a wrong impression. Please don't do this.
Please.
43, Prithvi case.
Last date of hearing, my lords was directed AGA, my lords, to secure instruction whether notice was issued, my lords, prior to passing of the order, my lords.
Annexure E.
Page 59, my lord.
Yes.
Please. My lord, as per the instructions and the documents which have been furnished, since from 1965 itself, the property which the petitioner is claiming title is a Ber-Karab land, and in the Akaraband it is classified as a Ber-Karab land. So my lord, my lord, my lord, the grievance of the petitioner is that at annexure E, page 59, we have specifically stated that at page 60, my lord, ಬಳ್ಳಾರಿ ತಾಲೂಕು ಬೆಳಗಳಿ ಗ್ರಾಮದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 14/10/96 ಮಂಜೂರಾತಿ ಆಗಿರುತ್ತದೆ. 96 ನಿಂದ 65 ಸದರಿ ಜಮೀನು ಸರ್ವೆ ಮಾಡಲಾಗಿ ಕಾಲುವೆ ಜಮೀನು ಬ-ಖರಾಬ್ ಜಮೀನು ಎಂದು ವರ್ಗೀಕರಣ ಆಗಿ ಆಕಾರ ಬಂದಿನಲ್ಲಿ ಬ-ಖರಾಬ್ ಎಂದು ನಮೂದಾಗಿರುತ್ತೆ. 70 ಕೈ ಬರ ಪಹಣಿಯಲ್ಲಿ ಕಾಲವೆ ಪರಂಪೋಕ್ ಎಂದು ನಮೂದು 1975 ಕೈ ಬರಹ ಪಹಣಿಯಲ್ಲಿ ಮಂಜೂರಾತಿ ಅದರ ಹೆಸರು ನಮೂದಾಗಿದ್ದರೂ ನಂತರ ಪಹಣಿಯಲ್ಲಿ ಕಾಲುವೆ ಪರಂಪೋಕ್ ಎಂದು ನಮೂದು ಇರುವುದು ಸರಿ ಇರುತ್ತದೆ. ಒಂದು ಬಾರಿ ಜಮೀನು ಬ-ಖರಾಬ್ ಜಮೀನು ಎಂದು ಕಾಲುವೆ ವರ್ಗೀಕರಣ ಮಾಡಿದ ನಂತರ ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ ಸೋ ಅಂಡ್ ಸೋ ಮಂಜೂರಾತಿ ನೀಡಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ. So my lord, since in 1965 itself, my lord, in the Akaraband it has been treated as a Ber-Karab land and his name does not enter there.
How can his name not be entered? It is entered into survey number RTCLE.
My lords, page 35.
Number ಏನಿದು?
Page 35. 273.
35.
ಹೌದು.
ಎಸ್ ಯಾರ ಹೆಸರು ಇದೆ?
ಅಲ್ಲಿ
Well,
ಸರ್ಕಾರ
the
ಅಂತಾನೆ ಇದೆ ಕಾಲಮ್
grand-
ನಂಬರ್ 9 ದಲ್ಲಿ.
ಬಕರಾಬೇ ಇಲ್ಲ.
ಬರ್ಕರಾಬ್ ಇದೆ ಎಕ್ಸ್ಟೆಂಟ್ 5.39 and 2.49 entire thing is treated as a ಬರ್ಕರಾಬ್.
Page 35.
Page
ಹೌದು
no, ma'am.
37 B1.
35, my lords, it is the entry of the year 65, 69, 70 to 81. Thereafter, my lords, without any, my lords, intimation, it has been, my lords, converted to Barkara. Earlier, my lords, it was not in Barkara, my lords. My lords. In annexure D, my lords, B
Till
page,
81.
please, my lords, till the year 8. Thereafter, my lords, it has been, my lords, converted Barkara. That is part of the extent, my lords, have been converted Barkara, my lords. And remaining, my lords, 2 acre 14 guntas have been acquired by, my lords, by the National Highway.
And what is happening on this 5 acre 31 guntas?
That is part of the, my lords, survey number, my lords.
That is ಬರ್ಕರಾಬ್.
ಇದೆ ಅದ್ರಲ್ಲಿ?
Earlier, it was not Barkara, my lords.
ಏನಿದೆ ಅದು 5 acres
It is,
31?
my lords, land of the petitioner, my lords.
What is it being used for?
My lords, earlier, my lord, up to 2021-22, we have been using for the agriculture. Now, my lords, in the mid of the, my lords, land, highway have acquired to an extent of 2 acre 14.
14.
Please, my lords.
Apart
Now,
from
by
that,
virtue of passing of order, my lords, they are not, my lords,
why was it classified as Bakarab?
that, my
Where's
lords,
the order of the classification?
Please.
no, no order, my lords, no separate order is.
When was it classified and for what purpose? What is the reservation?
Regarding to that classification order, I will produce by tomorrow. It's classification order. But ಆಕಾರ ಬಂದಲ್ಲಿ ಎಂಟೈರ್ ಎಕ್ಸ್ಟೆಂಟ್ ಬ ಅಂತಾನೆ ಬರೆದು ಬಿಟ್ಟಿದ್ದಾರೆ.
ಯಾವ ಇಯರ್ ಅಲ್ಲಿ?
ಇದು ಸಿನ್ಸ್ 1965 ದಲ್ಲಿ ಆಕಾರ ಬಂದ ಮೇನ್ ಮೂಲ ಇದರಲ್ಲೇನೆ ಇದೆ ಬರ್ಕರಾಬ್ ಅಂತ ಹೇಳಿ.
81 ವರೆಗೂ Bakarab ಇಲ್ಲ.
ಅಲ್ಲ ಅದು ಫಾರ್ that reason in the year 2023, my lord, the petitioner herein has requested to produce the grant order to him, wherein, my lord, when endorsement was issued on 20th 11 2020, stating that in the grant register there is no such grant order insofar as the present petitioner is concerned. In the 23 itself, it has been intimated to him.
But his name is there in the RTC.
ಅಲ್ಲ ಅದು ಕೈ ಬರ ಪಣಿಯಲ್ಲಿ we also admit that that has been ಇದು ಅಂತ ಹೇಳಿ since for the 3 to 4 years his names have been entered.
3 to 4 years ಅಲ್ಲಪ್ಪ.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ the endorsement which he has challenged, we have specifically stated
This is from 69 to 81.
69 to 81, my lord. But in the endorsement we have stated that at page 60, 65 to 70 ವರೆಗೆ ಕೈ ಬರ ಪಣಿಯಲ್ಲಿ ಕಾಲುವೆ ಪುರಂಬಕ್ಕೆ ಎಂದು ನಮೂದಿದ್ದು 70 to 75 ಕೈ ಬರ ಪಣಿಯಲ್ಲಿ ಮಂಜೂರಾತಿ ಆದ ಅಂತಾನೆ ಬರೆದಿದೆ. ಬಟ್ ಆಗಿದ್ದರೂ ನಂತರ ಪಹಣಿಯಲ್ಲಿ ಕಾಲುವೆ ಪುರಂಪೋರ್ಕೆಂದು it has been rectified.
Going to change it once it is there.
Yes.
You have to issue him notice. You can't delete his name just like that.
But prior to that also it was Purampur B Garab land antane ittu before entering his name.
Today we'll have AGS name. ನಾಳೆಯಿಂದ ಎಲ್ಲ AGS name delete ಮಾಡಿ. No appearance on part of the state. Once there's a name, how can you do that? You cannot ignore.
Well, we cannot state away that cannot be.
Earlier, 12 years earlier.
That cannot be done. I will ascertain insofar as
classification.
Yes, I will. Yes.
Learned AGA is called upon to obtain instruction, make a submission as to when 5 acres 31 guntas in survey number 273 of Belagal village, Bellary Taluka and district were classified as B Karab, and for what purpose was the reservation made in pursuance thereof. He is also directed to place on record as to on what basis the name of the petitioner's father,
yes,
petitioner's father came to be deleted from the RTC in relation to the above land, which on the basis of Annexure B is seen to have been in existence from 1969 to 1981. Relist on 17th.
Yes.
At 2:30 PM.
Please.
44 Rajshekhar Halli.
Lords, may I request on 18th, my lords?
18th.
Please.
In this, I have to get records, Your Lordship, next week, Your Lordship.
Records.
Next week, Your Lordship.
You have to get it. Bandidya Barbak.
No, ಬಂದಿದೆ.
And AG has submitted that the records are yet to be secured. He seeks for 2 weeks' time. He seeks for and is granted 2 weeks' time. If records are not secured by 5th, the
Before that, my lord, because of impugnator order itself speaks that, my lord, land tribunal order, my lord, meanwhile that property is belonging to the god, that is Hanuman temple, my lord. He is absolute owner.
ನಿಮ್ಗೆ ಒಂದು ವಾರದಲ್ಲಿ ಬಂದ್ಬಿಡತ್ತ ಇವು 2 ವಾರದಲ್ಲಿ ಬಂದ್ರೆ ನಮ್ಗೆ ಲಕ್.
Last time ತಾವು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ರಿ.
If records are not secured by 5th March, the Assistant Commissioner
Hadagli
would have to be present before this court.
The interesting point, my lord, in the death person, my lord, tribunal.
On 11th March. Records ನೋಡೋವರೆಗೂ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
Property is belonging to Hanuman temple, that is.
Records ಬೇಕಲ್ಲ.
Please, my lord.
Anyway, this is a 2024 matter only, not old.
Lord, my lord, interim order extension.
Interim order earlier granted is extended till next date of hearing.
Please, my lord.
Accepting reasons stated in support of IA 1 of 24, production of certified copy of Annexure D is dispensed with.
45 Santosh Mane.
CPCL additional documents, ಇವಾಗ.
Only to say that, my lords, in the very same my lords, suit is for the partition and separate possession. The blame is that, my lords, I am trying to change the, my lords, nature of the suit property by constructing, my lords, a residential house for the portion of the property. In the very same land, my lords, they have constructed their residential house and they are residing there. Only to show that, my lords, they are residing in a very same property, by constructing their residential house, my lords, an application is filed. Subsequently, my lords, they have intimated it to me, lords.
Sorry, Lordship, we have not constructed any house. It is old, 35 to 40 years old house. My ancestral house, Lordship.
They are residing there, my lords.
They are residing, constructed, bada difference ಇದೆ. This house looks like it is 60, 70 years old.
Lords, lordship, I kindly see, my lords.
They are not
The very case is, my lords, that, my lords, in the year 1965, there was, my lords, a partition between, my lords, the two brothers. Their portion, my lords, they have constructed their house, my lords, we have not obstructed it. In our portion, my lords,
They have not constructed anything.
No, Lordship.
They are residing in your old family house.
even, my lords, they have the residential house, and, my lords, my client, my lords,
And if you construct mada, it will be without any
Like, even
equities,
lords-
everything will go amale.
80% of, my lords, construction is completed.
Oh,
Then, my
lordship,
lords, the suit is
where is
filed.
your construction?
My lords, annexure C may kindly be seen, my lords. ಬರೀ ಪ್ಲಾಸ್ಟರಿಂಗ್ ಒಳಗಡೆ ಇಂಟೀರಿಯರ್ ಮಾಡ್ಬೇಕು.
Lordship, when we
And
filed
even,
the
my
suit,
lords,
it
I am
was at
ready to-
advanced stage. After obtaining a TI interim, they have constructed, Lordship. We had given also police complaint. Dates also is mentioned. Suit was filed on 31/2023, Lordship.
As per my instruction, my lords,
Your
at the,
instruction from your counterpart
at
is
the
always-
advanced stage, my lords, they have filed suit and obtained, my lords, injunction
the-
order, my lords.
That's the problem. You don't get instruction from your
Please.
client directly. The counterpart instructs what
Please,
he
please.
wants to instruct. ಅದಕ್ಕೆ
Both
facts,
court have denied them
And even
on
worse,
the
they are
ground
not-
that they have not produced the compromise decree, Lordship.
Okay, a counterpart may be referring matters to you, but you should also speak to the party.
ಅದು difficult.
Understand? ಅವ್ರು ಬಿಡಲ್ಲ ನಿಮ್ಮನ್ನ. ಹಿಂಗೆ they'll mislead you. You will face the.
Please, please.
When we pass orders,
Lords,
it will
even the
reflect.
photograph
with
was, my
burning.
lords, photograph was furnished after filing of the, my lords, writ petition, saying that, my lords, they have constructed their house and now they are obstructing.
Because you are making your submission on the basis of your counterpart submission.
Please, please.
Instruction, we are not saying anything much.
But this kind of thing would require us to take action.
Please.
Don't get into this.
I'm sorry.
ನಾಳೆ ಯಾರಾದ್ರ ಮೇಲೆ action ತಗೊಂಡ್ರೆ you'll don't rely blindly on what your counterpart counsel is saying.
Please.
Document ಕೊಟ್ಟಾಗ it is clearly seen to be false.
What they have stated is, my lords, at the advanced stage, they have filed the suit and they have obtained, my lords.
It is clearly false. The petitioner is before this court seeking for the following reliefs. Respondent number 1 to 5 herein had filed a suit for partition and separate possession. Wherein the petitioners were arrayed as defendant number 5 to 19. In the said suit, the plaintiffs had filed an application for injunction. In the application,
Annexure D, page 37, my lords.
only 19th defendant here.
Please.
Seeking for injunction against 19th defendant from putting up any construction on suit schedule item 2A property. The trial court wide order dated 27th September 2023 allowed the said application and restrained defendant number 19 from putting up any construction as sought for. Defendant number, the petitioners herein filed an appeal in miscellaneous appeal number 6 of 2023 before the additional senior civil judge in JMFC Angal, the first appellate court, wide impugned order dated 24th October 2024, dismissed the miscellaneous appeal. It is challenging the same. The petitioners are before this court. The submission of Shri Santosh B. Mane, learned counsel for the petitioner, is that the plaintiffs have put up construction on the very same property, subject matter of partition. And as such, the petitioners also would have to be permitted to put up construction, to complete the construction on the said property. Admittedly, the properties being joint family properties. He submits that there could not have been an injunction order passed against the petitioners who are also joint owners of the property. Sri Gauri Shankar Mot, learned counsel appearing for KVT respond number 1 to 5 plaintiffs would submit that even during the pendency of the matter before the trial court, the petitioners have gone ahead with putting up construction. 39(2)A ಹಾಕಿದ್ದೀರಾ?
Yes, Lords. No, we are not. We are given police complaint, Lords.
Even during the pendency of the matter before the first appellate court, the petitioners have gone ahead with the construction, as regards which the plaintiff have filed a complaint with the jurisdiction police on
On 11/9/2023.
11/9/2023. He has produced photographs.
Yes, Lordship.
And the complaint along with the memo, which I have gone through. A perusal of the photographs would indicate that there is no the construction was at the initial stage when the suit in OS number
30/2023.
30
of 23
of 23 was filed, where the photographs which are now being produced by the petitioner in this petition shows much more construction than that shown at the time when the suit was filed, when the injunction order was passed. That being so, clearly the petitioners have, even during the during the operation of the injunction order, gone ahead with the construction, which would have to be dealt with in appropriate proceedings as and when filed by the respondents. Be that as it may, the construction having commenced during the pendency, having commenced during the pendency of the suit and proceeded with thereafter, I have the considered opinion that no purpose would be served by allowing the petitioner to go ahead with the construction in the event of, more so when in the event of the land on which the construction being situate were to fall to the share of any other joint family member, the construction would either have to be demolished and/or the petitioner cannot claim any equities on the said construction. No submission having been made by the petitioner that the petitioner would not claim any equities, I have the considered opinion that the said construction cannot proceed. In that view of the matter, the orders passed by the trial court as confirmed by the first appellate court being proper and correct, I do not find any reason to interfere with the same.
Please.
46.
Non-matter words out of. Into and rule 97 came to be rejected. They have changed the order.
How really new? Yes, madam.
Application filed by the respondent is not.
Application filed by the respondent? Yes?
Is not maintainable, my lord. As rule of nace is not maintainable.
You're ready?
Rule of nace not maintainable, my lord.
Not maintainable. What are the facts? What are you saying? Clearly.
Respondent number 2 filed suit against respondent number 1, my lord, specific performance of contract. Suit is decreed, my lord. For the respondent number 2 filed executing petition against respondent number 1, my lord. There is a pendency of suit. Petitioner came to know about the filing of suit, my lord. Petitioner, there are not parties in this suit, my lord.
Yes.
That prosecute deceased Basurajappa and Parvatama had 9 children, my lord, 3 daughters and 6 sons. Petitioner and respondent number 1 are members of the said joint family, my lord. The prosecute had left several properties, my lord. Petitioner filed suit for the partition and claiming 1/9 share in the suit schedule property, my lord, in OS number 88/2021 on the file of Civil Judge JMFC Court, Huvinahadagali. And petitioner have filed application order 39 rule 1 and 2, my lord. IA number 2, my lord.
Yes.
During the pendency of the suit, petitioner to know about the suit filed by the respondent number 2, my lord, against the respondent number 1. Where the appellant court is RA pleased to grant the relief of specific performance of the contract in respect of the one item which is subject of the suit filed by the petitioner in OS number 88/2001, my lord. And the confirmed by this honorable court in RSA number 10089/2019, for which is the petitioner are not parties in the said suit, my lord, hence are unaware of the proceedings, my lord. The respondent number 2 filed execution petition number 22/2019. It is submitted that when the petitioner came to know about the said fact, the petitioner filed application under rule 1 Order 1, Rule 10 of CPC for the implementing of
First
respondent
suit
number
ಯಾವಾಗ
2.
ಫೈಲ್ ಮಾಡಿರೋದು ಪಾರ್ಟಿಷನ್ ಸೂಟ್
Partition suit 2021, my lord.
2021
Not confirm about date, my lord.
after the execution petition was filed. Yes, you have put to notice of their right. Nale, if they succeed in the partition suit,
They have already filed this suit, your lordship. They have already filed this suit.
if they
That is
succeed,
pending, your lordship.
if they succeed, you can't claim any equity.
Yes, your lordship. Yes, your lordship. But already the court, this honorable court and the Supreme Court has held, your lordship. It has been paragraph number 16, your lordship.
Paragraph
Of the-
number 16.
Of page number 39.
Hmm.
On provisional of the order date 12/11/2020 of the Honorable High Court of Karnataka, the order which the Honorable High Court has directed to consider the application. Earlier to this, your lordship, they have filed an application, your lordship. Filed the application. On going through the entire order sheet and entire file of this execution petition, nowhere it is found that the applicant has filed the application under Order 1 Rule 10 of CPC at annexure. On asking for clarification regarding to this, to learn counsel for the applicants, the counsel states that
You can't claim any equities.
yes, sir.
The petitioner is before this court seeking for the following leaves.
And also the paragraph number 17, your lordship.
Hmm.
To comply the order of the Honorable High Court of Karnataka bench of 12/11/2021, the applicants have not filed any application before this court under Order 1 Rule 10 of CPC. After the orders from the Honorable High Court of Karnataka, instead this application is filed under Section 115 of CPC. Again, on seeking the clarification, the learned counsel for the applicants state that there is typographical error in the order of the Honorable High Court of Karnataka instead of Order 21 Rule 97 of CPC. In the order of question, it is mentioned as Order 1 Rule 10 of CPC.
Yes. Respondent number 1 had filed a suit against respondent number 2 for specific performance of an agreement of sale in OS number 8 of 2013, where the suit was partly decreed directing the refund of the earnest money. Respondent number 1 challenged this said judgment in OS number 8 of 2013 in RA number 60 of 2018, which came to be allowed and a decree of specific performance was ordered in favor of respondent number 1. The respondent number 2 preferred an appeal in RSA number 10089 of 2019, which came to be dismissed on 13/9/2021. Respondent number 2 having filed a SLP in SLP specially petition in SLP number 12593 of 2021. That petition also was dismissed on 13/9/2021. It is thereafter that the petitioners filed a suit in OS number 88 of 2021, seeking for partition in respect of various properties, including the property subject matter of the specific performance decree. The execution petition having been filed in EP number 23 of 2019, the petitioners filed an application under Rule 97 of Order 21 of the Code of Civil Procedure, claiming that they have an interest in the property and the execution proceedings cannot be proceeded with without hearing their objections. The said application having been dismissed by the impugned order dated 28/10/2024, the petitioners are before this court. Senior Esra Nimesra. Mr. Sharad Magdum, learned counsel for the petitioner, would submit that a suit having been filed by the petitioners for partition, the petitioners being members of the family, being the sisters of respondent number 2, judgment debtor, the property in which they have an interest has been made a part of the specific performance suit, and if a sale deed is executed in respect to the said property, the interest of the petitioner would be adversely affected, and as such, the trial court ought to have considered their rights while considering an application under Rule 97 of Order 21, and as such it's submitted that the order passed by a trial court is required to be set aside and the application under Rule 97 of Order 21 be allowed. Learned counsel for respond number 1, decree holder would however submit that the said application has been filed. The suit for partition has been filed after the disposal of the special leave petition and 2 years after the execution petition was filed, and the application is completely bereft of merits, mala fide, and abuse of the process of court, inasmuch as the application was filed only to delay the execution of a decree which has been confirmed up to the Honorable Supreme Court of India. Heard so and so, peruse papers. The sequence of events have been laid out here and above, which would categorically indicate and support the submission of respond number 1 decree holder that the defense set up by respond number 2 judgment debtor had been rejected. Thereafter, a suit for partition had been filed, and subsequently an application in Rule 97 of Order 21 has been filed. Though in a proceedings under Rule 97 of Order 21, in terms of Rule 100 thereof, it is required for all the issues to be determined in the said application under Rule 97 of Order 21. The fact remains that the petitioner have filed a suit for partition, and it is for the petitioner to establish their right in the said suit before seeking for any right in the property subject matter of the specific performance decree. In that view of the matter, I do not find any infirmity in the orders passed by a trial court. It would, however, have to be observed that in the event of the petitioner succeeding in the said suit for partition, the respond number 1 decree holder cannot claim any equities. Petition stands dismissed.
Much obliged.
47.
1 of 25 stands dismissed.
47. Sunita P. Kalsur.
Lords, I'm appearing for the respondent 1, my lords.
Hmm.
Lords, I seek a weak accommodation, my lords.
Why?
I have to take the instruction from the authority, my lords. On the last occasion, the court has directed to take notice.
And counsel for respond number 1 seeks for and is granted 2 weeks' time to obtain instruction and make a submission. Since the request for adjournment is made by respond number 1 is restrained from taking any action in pursuance of the impugned order dated 1/10/2024 at Annexure M till the next date of hearing.
Apply.
Relist on 11th March. A 1 of 25 is allowed.
Forty-eight. L. Patil.
Non-filing of amended cost title.
It's being filed now.
Counsel for the petitioner has filed the amended cost title. The same is taken on record. What is IA 1 of 21?
21 and injunct stay order, my lord.
1 of 21.
1 of 21.
In objection is at 21 up.
And subsequently 1 of 23 is filed for the stay.
So 1 of 21 you don't press. And counsel
Only-
for the petitioner submit that he does not press IA 1 of 21. As such, IA 1 of 21 stands dismissed.
Short point is involved, my lord.
Kunde, you are there? Yes. Ready?
Tuesday.
Okay.
I mean, lords, I will give some detailed synopsis are required because since 1972 the litigation is on. Lords. I will
Short-
prepare a short synopsis.
Let him submit on Tuesday only, but only short point involved is.
We'll see that on that day, Mr.
What time, Lords, I will.
At the request of counsel for respond number 4 to 7 and 5A to D, released on 18th.
Great.
49. Shivraj Balloli.
My lord, amended cost title is ready. During the course, I will amend the amended cost title is ready, my lord. Typed copy of the amended cost.
49, counsel for the petitioner submit that during the course, he would carry out the amendment, file amended cost title during the course of the day, and make payment of process fee in respect of unserved respondents. 49.1, if needful is done, Registry is directed to issue notice on unserved respondent written by 28th April. 49.1. Counsel for the petitioner seeks for and submit that you would make payment of process fee in respect to unserved respondent during the course of the day. If needful is done, registry is directed to issue notice to unserved respondent written by so and so. He seeks for and is granted 4 weeks time to file necessary application to bring the legal representative deceased respondent number 2 on record. Relist on 28th.
Please.
50, Sharmila M. Patil.
This, my lords, a review petition, I have paid PF on the last time, my lords. I have paid
R11.
PF for 50.1 and 50.2, my lords. I have taken steps
50
in,
LE R11 is dead.
I have taken steps, my lords.
You have taken steps on the application file madidira.
Application deceased.
On that, my lords, the problem is the legal heirs also are dead, my lords. We got the list of legal heirs and 3 of the legal heirs are dead, my lords.
Legal heirs of legal heirs.
Please, my lords. So another 8 days, my lords, we are on the way.
50, learned counsel for the petitioner submit that on securing the details of the legal heirs of deceased respondent number 11, she has come to know of some of the legal heirs also having expired. As such, she seeks for and is granted 3 weeks time to obtain the details of the legal heirs and file necessary application.
Please, my lords. And in 50.1, my lords,
1.
I have taken steps, my lords.
Counsel for the petitioner submit that process fee has been paid in respect to unserved respondents.
And in
If registry to
50.2, my
verify,
lord.
if needful has been done, issue notice to unserved respondent returnable by 16th April. 50.2.
That could be disposed of, my lords, because it's covered by judgment, my lords.
Jagdish Patil, yes.
I served the copy. Similar notification, my lords.
Demand ಆಗಿತ್ತಲ್ಲ.
The adjacent landowners had filed the writ petition, my lords, challenging the same notification.
This is RP, 50.2.
Please, my lords. In those matters also, the adjacent landowners also had filed RP, and that came to be disposed of, and later writ appeal was filed, my lords. Writ appeal was allowed, my lords. And the landowners challenged before the Supreme Court, my lords. There, it was dismissed, my lords.
Writ petition is remitted to single judge.
Please, my lords, restored.
In a writ appeal, remand order.
The adjacent landowners, my lords, surrounding landowners had filed similar writ petitions, my lords. Those writ petitions also were allowed, my lords. And the board filed review petition, my lords. Review petition were disposed of, and later writ appeal was filed, my lords. Writ appeal are allowed, my lords. At para number 6, my lords. Para number 6 of the writ appeal order, my lords. At page 11.
Avinash Angri, 1, 2, 3. 1, 2, 3. Avinash Bankar, 4 and 5.
This is an order on merits. That was an order on concession.
Pardon, my lords?
The order subject matter in writ appeal 100266
Please, my lords.
was on concession.
No, my lords.
This order in WP 109564 of 2014 is on merits.
Even the review petition which I have challenged also was on merits only, my lords.
ಇಲ್ಲ ಇದರಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳ್ತಾರಲ್ಲ. Where is that order?
Writ appeal order. Review order.
That was on merits only, my lords. In WP
Para
109564.
6 this court is of the considered opinion that since the writ petition was disposed on recording the concession made by learned counsel who appeared for KHP, the matter requires reconsideration. That is what para
No,
6
my lords.
says.
That also was challenging the review petition only, my lords.
Because it was on concession. Writ petition was disposed on the basis of concession. Idral writ petition order of 5th June is a detailed order on merits after hearing everybody.
No, my lords, in those writ petitions also, they were disposed on final orders only.
Para 6.
I will
ನೀವು ಹೇಳಿದ
verify.
ಪ್ಯಾರಾ 6 ಅಂತ ಅದೇ ಪ್ಯಾರಾ 6 ಅಲ್ಲೇ ಹಂಗಿದೆ.
Because they had challenged, writ appeal was challenged the writ petition order, my lords.
Yes.
That was allowed, my lords.
That was allowed because the writ petition order was on concession.
It was
Para
with regard to
6,
the
line
same
6.
notification. It was with regard to the same notification.
It may be, madam,
Please,
with
ma'am.
regard to
I
same
will verify, my
notification.
lords, because my colleague had appeared in that writ
This
petition.
is a detailed order which has been passed by the single judge.
I will verify that, my lords.
Way back on 5th June 2017. This is not a concession order.
I will verify the order passed in
50.2. Learned counsel for the petitioner submits that a similar revision petition having been filed earlier in another proceedings. The same revision petition having been dismissed in a writ appeal filed by the order dated 26th May 2023 in WA number 100266 of 2021. The writ petition has been remitted to the single judge for fresh consideration. A perusal of para 6 of the said order indicates that the reason for remittal of the matter was that the writ petition were disposed of recording the concession made by a learned counsel who appeared on behalf of the KHB. And as such, the Honorable Division Bench of this court was of the opinion that opportunity has to be provided to KHB to agitate all the issues that they wish to agitate. A perusal of the order under review dated 5th June 2017 in WP number 109564 of 2014 indicates that the matter was argued by all the counsels and those arguments had been considered on merits by the coordinate bench of this court. And finally, the order dated 5th June 2017 was passed. And the same cannot be said to be on the basis of a concession
I'll get the certified
of
copy
the
of
counsel for the petitioner, for KHB. Faced with the above situation, learned counsel for the petitioner seeks for and is granted a week's time to place on record the order passed in WP number 64471 to 64477 of 2012.
Please, ma'am.
Released on 20th February. 50.2 D-link.
Please, Lord, this is with regarding to compliance report.
In compliance.
My Lord, there was a direction with regarding to condition number 6 is concerned. That is towards necessary information technology infrastructure to be established by the state at each of the department, and a detailed project report to be submitted in this court, which would require to be complied with by all such departments. Insofar other directions have been complied, only insofar E is concerned, my lord. Now, as per the communication sent by the principal secretary, my lord, it is the department, principal secretary of the government, Department of Personal and Administrative Reforms, DPAR, e-government, e-governance. Yes, that our direction kotrandre within 15-20 days that process will be completed and
you have received instructions.
Yes. I will place along with the memo the communication sent by the state.
And AGA submit that he has received communication from the Secretary E-Governance Department that the direction in para 16 bracket small e of the order dated 4th January 2024 would be implemented within 15 days.
15-20 days. But
within
yes,
within
please.
4 weeks from today.
Please.
Released on
But
17th March.
This direction shall be given to this department itself. ಯಾಕಂದ್ರೆ ಈ ನಮ್ಗೆ ಕೊಟ್ಟಂತ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವ್ರಿಗೆ ಬಂದಿಲ್ಲ ಅದು. E-government department was not party in the present writ petition. So we are facing difficulty. This letter is sent by the ನಗರಾಭಿವೃದ್ಧಿ ಇಲಾಖೆ.
ಹೊಡೆದಾಕಿ ಅದನ್ನ. Learned AGA submit that the Principal Secretary, Urban Development Department has written to him by letter date 7/2/2025, stating that if directions are issued to
Principal Secretary, Department of Personal and Administrative Reforms.
E-Governance Department.
Please, DPAR.
The Urban Development Department will cooperate with the E-Governance Department for implementation of direction at para 16E.
Please.
Of the order dated 4 January 2024. In that view of the matter, the Principal Secretary E-Governance Department is directed to coordinate with the Principal Secretary Urban Development Department for doing the needful.
Please.
Relist on 17th March for reporting compliance.
Please.
52, Mrutyunjay Tatabangi.
Yes, my lords, cost title is ready, my lords. I will file today in counter and I will amend the.
Carry out the amendment.
Please.
Counsel for the petitioner submit that the amended cost title being ready, he will be filing it during the course of the day in the registry. He also submit that he would carry out the amendment during the course of the day. Relist on 2020. Ella ready, na?
Yes, ma'am. Second matter is ready, so both can be taken together.
No, all of you are ready for argument. Since all the counsels are ready for addressing their arguments, relist on 24th February.
Please.
My lords, 25th.
For hearing.
Senior is not available on 24. My lord, request on 25.
25th, bada. Relist on 11th March for final hearing.
Please.
53, Lingesh Kattimane.
We have filed LR application for R2, my lord.
You have filed?
Yes, ma'am. Today we had 53.
IA number.
IA number?
1, my lord.
1 of 25.
IA 1 of 20, during the pendency of the above matter, respond number 2 has expired. Hence, IA 1 of 25 has been filed. Registry is directed to issue notice on IA 1 of 25, returnable by 23rd April. If process fee is paid.
Yes, ma'am. Paid.
By.
Paid.
Learned counsel for the petitioner submit that process fee in respect of the other unserved response have also been paid.
Yes, ma'am.
Hence, issue notice to unserved response returnable by same date.
54, PG Chikkanargund.
This case, lords, I seek another 10 days time to file affidavit and lords objections. Since lords respondent number 2 has gone to Prayagraj, lords, I was not able to get the affidavit.
Adhe record madana.
10 days time. Lords.
54, it is submitted that respondent number 2 is not in station and as such 10 days time is sought for to file the affidavit directed by order date 31/2020. Avatind Prayagraj alli ideyala.
1 week adu traveling nalli train travel.
Relist on 24th February.
Please.
55, AS
In the meanwhile, office objection in serial number 54.3 shall be complied with. If not complied by that date, petition will be liable to be dismissed for non-compliance.
Please. 55, AS Patil.
Kindly pass over, lordship. Kindly pass over, lordship.
What is this IA pass over?
Please.
56, Rajshekhar Gunjalli.
Permit to withdraw the writ petition. I may permit
Withdraw.
to withdraw the.
Petitioner is before this court seeking for the following relief. A memo dated 13/2/25 has been filed, signed by the counsel for the petitioner, which reads as under.
Oh, okay.
Right.
It is granted.
Accepting the said submission. Petition is accepting the memo and the submission counsel for the petitioner. Petition is dismissed as withdrawn.
Pending consent.
IA stand disposed.
57, VM Shilwan.
But filed wakalat today for respond number 1D, my lords.
1A to E.
1D. Since 1A, B, C and E are awaited, service is awaited, I filed for 1D. I undertake to file for
File for everybody.
Yes, my lords.
In conflict of interest in illala, you'll
No,
file.
no, my lord.
No,
They are
my
the
lords.
legal aids of respond number 1.
Sri Abhishek Kallat submit that he has filed wakalatnama for respond number 1D today
Yes, my lords.
and given 10 days time, you'll file wakalatnama for respond number 1A to C and E.
Yes, my lords.
His submission is placed on record.
Lords may take it for disposal.
IA number?
1, 2, 3.
Please.
Oh. Legal air, application number N.
1, 2, and 3. 1, 2, 3.
During the pendency of the above matter, respond number 1 expired on
Expired on, my lords, 10/10/23.
10/10/23, hence IA 1, 2 and 3 of
24.
23, my
24 was filed on
lords, it was filed on 20th October 2024.
20/10/2024. Accepting the reasons stated in support of IA 1 of 24, delay of
287 days.
287 days is condoned. Accepting the reasons stated in support of IA 2 of 24, the abatement in respect of respond number 1 is set aside. By allowing IA 3 of 24, the person named therein are brought on record as respond number 1A to E. More particularly, since the counsel appearing for them has no objection to be brought on record. Counsel for the petitioner to carry out necessary amendment and file amended cause title. Relist on Vijaya Bank standing counsel.
Vijaya Bank.
No represent. No
Karil
representation.
was standing counsel. Vijaya Bank, your Bank of Baroda.
Bank of Baroda, Mallikarjun Hiremat appears.
Respond number 2 is shown to be Vijaya Bank, which is now the Bank of Baroda. Shri Mallikarjun
Yes, Hiremat.
Hiremat is directed to accept notice for respond number 2.
Serve the copy.
Counsel for the petition served 2 sets of petition along with annexure on the said counsel. Relist on
Lords, I
11th
request to
March.
have it for disposal, my lord. Suit is of the year 2013.
15.
Relist on 24th February.
Interim order, may
Please.
Interim order earlier granted is extended till next.
The preliminary. Please.
Bharat.
Please.
58 Dinesham Kulkarni.
Oblige.
Memo for disposal, dismissal. ಏನ್ ಮೆಮೋ ಆಫ್ ಡಿಸ್ಪೋಸಲ್ ಅಂತ ಹಾಕಿ ಇದು ಮಾಡ್ತೀರಾ?
Dispense, my lord.
Yes.
On last occasion, my lords, I have directed to respond, file a better affidavit, my lord. They have filed the affidavit, my lord. My request is, my lord, in a disputed suit property, my lord, only request is not to put up the windows in that place. Annexure, in page number 19, my lord. In page number 19, my lord. In respect of
Next week, meet and
CDIH, my lord, in that place, my lord, to construct the wall, my lord, but they cannot put up the windows.
Window.
Yes, that is the only my submission and request.
But I have to go through the.
ರೆಕಾರ್ಡ್ ಮಾಡೋಣ ಬೇಡ ಅವ್ರು ಒಪ್ಪೋವರೆಗೂ ಬೇಡ.
Next week, we can leave.
Counsel for the petitioner seeks for and is granted a week's time to obtain instruction and make a submission on the proposal made by the respondent.
Please, my
Relist on 20th.
lord. Please.
59 Santosh Malligawad.
Lord, on the last occasion, we have filed a memo along with the dash board with regarding to the pendency of the cases appeals. However, my lord, the lordship has directed to, though that memo was not accepted, but to file a detailed for having incorporated the direction issued by this court.
Yes.
Now, my lord, steps have been taken throughout the state. And as per the request made by the authority, my lord, another 6 weeks times to file the report.
512 appeals is too less.
ಇಲ್ಲ ಇಲ್ಲ ಅದಕ್ಕೆ ಎಂಟೈರ್ ಸ್ಟೇಟ್ ಅದೇ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Now, DG on instruction submits that the total appeals pending before the authorities in the entire state are being tabulated.
Yes.
And necessary, and they will be tabulated and uploaded onto the system which has been, software system which has been developed. He submit that given 6 weeks time.
Please.
Further progress would be reported. Relist on 27th March.
Please.
60 PN Osmane.
The course, my lord. Make amendment.
Counsel for the petitioner submit that he will carry out the amendment during the course of the day. Relist on 11th March.
Please.
Interim order idea? Bad one. Interim order earlier granted is extended till next date.
61, Mrutyunjay Tata Bangi.
Petition. The respondent have
R1. R1, Mr. Beturmat.
last occasion have taken time to file affidavit.
Who has to file the affidavit?
Mr. Dhananjay Garg.
Where is Mr. Beturmat? Mr. Sondu, pass over.
Please.
Please.
BP Matpati.
Lord, on the last occasion, the Lordship has directed me to whether multiple awards can be passed and to ascertain and to make submissions before this honorable court. Lord, 2 days time, Lord, today morning I have got instructions, but I will place whether that is permissible or not, or whether supplementary award has been passed or two multiple awards have been passed. By Monday, I will place.
AGA 6 fund is granted 2 days time to make a submission as regards para 4 of the order dated 6/2/2025.
May I make one more submission?
Counsels for the petitioner to comply with the remaining of his objections. If not complied with, the petition would be liable to be dismissed for non-prosecution.
As regards in connected writ petition, my lord, the office has raised regarding maintainability. Being a beneficiary, I cannot file a reference, my lord. The office has raised that I have to file a reference against the award.
Deal with it. Rest of it you comply.
Please, my lord. My lord, one more submission.
They are the
62.1, my lord.
The office objection raised as regards the maintainability of the petition is rejected since the petitioner is the beneficiary of the acquisition.
May I request to direct the government to take notice in 62.2, my lord?
Learned AGA accepts notice for respond number 1 and 2.
Please.
Sri BP Matpati accepts
For
notice
other.
respond number
For respondent number 4 to 16, my lord.
4 to 16. Registry direct print their name as such. Released on 17th.
Please. One more submission, if my lord permits. The reference court has already dealt with that issue and passed an award, enhancing that quotient on the damages as interest. So even otherwise, whether award is passed, it would be a negatory. That's the only submission.
Let us see that.
Please.
63, Prakash Javalkar.
Bond corporation
One more memo for disposal.
At the covered agala.
We'll read disposal as dismissal.
I'll file objection or ಸ್ವಲ್ಪ instruction.
An objection.
Covered ಇಲ್ಲ ಅದು. It's not covered.
It is in respect of annexure H, that is the layout approval, and the entire layout conversion fee has been paid. And this, as per annexure H, a new ground has been set up saying that it is, the matter is under, it has been.
Not only delay that.
ಉದ್ದೇಶಕ್ಕಾಗಿ ವಿನ್ಯಾಸವನ್ನು ತಿರಸ್ಕರಿಸ. Annexure H. Last para.
First ಒಂದು 90 days.
ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಪತ್ರದಲ್ಲಿ 9 ದಿನದೊಳಗಾಗಿ ಶುಲ್ಕ ತಿಳಿಸಲಾಗಿತ್ತು. ಆದರೆ ಈವರೆಗೆ ಶುಲ್ಕ ತುಂಬದೆ ಇರುವುದರಿಂದ, as regarding this part, I have already complied. I have fortified with the documents. As regarding the second part, my lord, this particular matter has been decided in writ appeal. So that is why I had moved a memo for disposal.
What is your
I'll seek because as per my telephonic instruction, lordship, that was under the earlier scheme. It was there was 90 days time was given to them. In spite of 90 days time, lordship, they are not paid, and even lordship, the amount paid, it was returned to them that they are collecting documents. That scheme is no more.
You can't have two things. You can't say they have not paid, and two, you can't say we have returned back the money.
In time, because 22 they have taken channel, 24 they said that they have paid by using that old channel. Page number document annexure D, page number 17. Page number 17, lordship.
Your conversion has been allowed.
Please.
Yes.
It's a question of only payment of money.
Payment, lordship.
Even if we accept your submission,
please,
they can make another application today, which in the new law you'll have to do it within 30 days.
ಅದಕ್ಕೆ ನಾನು whether there is any scope ಅದ್ ನೋಡಿ. ಯಾಕಂದ್ರೆ 22 ದಲ್ಲಿ ನಾವು ಚಾನಲ್ ತಗೊಂಡಿದ್ರು. Lordship may kindly peruse.
Unnecessarily make a number of applications. If the process has happened, it's only amount which has to be paid. It is not something, it's a
Lordship,
fee.
as per my instruction, under some other scheme, Lordship, that approval was made. Now, Lordship, that land was,
ಯಾವುದೇ scheme agli, they can file another application in 95(3) tomorrow, today.
ಅದಕ್ಕೆ ನೋಡ್ತೀನಿ ಆತನ ಇಲ್ಲೇ ಮಾಡಿಸ್ಕೊಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ ಅಂತ ಅಷ್ಟೇ
ಇವಾಗಲೇ
ಮಾತೇನಿಲ್ಲ.
ಆನ್ಲೈನ್ ಹೋಗ್ಬಿಟ್ಟು ಅಪ್ಲಿಕೇಶನ್
ಅಲ್ಲ, I'll just seek instruction if that is ಇಲ್ಲೇ ಆಗ್ತಾರೆ ಇಲ್ಲೇ ಕೊಡ್ಸ್ಬಿಡ್ತೇವೆ ಅವ್ರಿಗೆ, ಅದರದ್ದೇನಿಲ್ಲ ಇದೇನಿದೆ ಅಂತ. ಅದಕ್ಕೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೇಳಿದ್ದೇನೆ. ಇಫ್ ವೀಕ್ಸ್ ಅಕಾಮಡೇಷನ್ ವಿದಿನ್ ದಟ್ ಆಗುದಿದ್ರೆ ಇಲ್ಲೇ ಮಾಡಿಸ್ಕೊಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ.
ಮಾಡಿಸ್ಬೇಕು
ಪ್ಲೀಸ್.
ರಿಟರ್ನ್ ಏನಕ್ಕೆ ಮಾಡಿದ್ರಿ?
ಇಲ್ಲ, ಅದು ಇನ್ ಟೈಮಲ್ಲಿ ಏನೋ ತುಂಬಿಲ್ಲ ಅಂತ ರಿಟರ್ನ್ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನೇನೋ ಇದೆ, ಅದು ಎದಕ್ಕೆ ರಿಟರ್ನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಏನ್ ಸ್ಕೋಪ್ ಇದೆ ಅದನ್ನ ಸ್ವಲ್ಪ ನಾನು ಜಸ್ಟ್ ವೆರಿಫೈ.
It is a fee for conversion, Mr. Vanti. It is not something that.
True. That is true. As a matter of fact, they can.
If it is a loan, if it is something, yes, we agree with you. Conversion has been approved, only delay in that. What difference will it make?
ಅದೇ ನೋಡಿ,
You can't even levy
ಅಲ್ಲ, ಮೇ ಬಿ
interest.
ಸಮ್ ರೇಟ್ಸ್ ಗಿಟ್ಸ್ ಏನಾರ ಇದ್ರು ಅದೆಲ್ಲ ನಾನು ಜಸ್ಟ್ ಅಲ್ಲಿ ವೆರಿಫೈ ದೇರ್ ಇಸ್ ಎನಿ ಅಪ್ಲಿಕೇಶನ್, ಫ್ರೆಶ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಎನಿ ಡೇಟ್ ಮೇ ಫಿಕ್ಸ್ ಬೇಕಾದ್ರೆ ಅಷ್ಟಲ್ಲಿ.
Counsel for respondent seeks fund is granted a week's time to obtain instruction, make a submission. Released on 19th February at 2:30 p.m.
Please.
Permission, madam. Serial number 99, Lord. There are 4 connected matters. Those can be disposed of, Lord.
Another connected matter.
3 matters ಇದೆ. Only ಹೊಸ act ಪ್ರಕಾರ they have to pass it.
Number 7, serial number 7 passed. It may be taken next week.
Serial number 7, at the request of counsel for the petitioner, released on 24th.
And serial number 61, I supposed to file affidavit, my lord.
51, yes, you are to file.
61, my lord.
ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ವಿ.
Affidavit ಹಾಕ್ಬೇಕತ್ತೆ. 2 days time affidavit ಬರುತ್ತೆ.
ಇವತ್ತೇ ತಗೊಂಡ್ ಬನ್ನಿ.
ಚಂಡೀಗಢದಿಂದ.
ಎಲ್ಲಿಂದ ತಗೊಂಡು? 49 interim order.
53, my lord. Interim order to be extended.
53 interim order. 101 connect with so and so. ಅದು ಯಾವತ್ತಿದೆ ಡೇಟ್? ಡೇಟ್ ಯಾವತ್ತಿದೆ ಅದು? ಅಲ್ಲಪ್ಪ, ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟ್ರ್ ಯಾವುದು? ಹಾಗಾದ್ರೆ SC/ST. Counsel for the petition submitted process fee has been paid. Registry is directed to issue notice on the unserved respondent written by 23rd April. 101 ಅಲ್ಲ? Interim order earlier granted is extended till next date.
Serial number 70, my lord.
55, my lord, password matter, my lord. Need to furnish death certificate in the matter, my lord. May, my lord, a week's time.
Not required death certificate. Why is it?
Officers raise objection regarding the same.
We will reject the office objection.
Please, your lordship.
IA 1 and 2 ಹಾಕಿದ್ದಾರೆ, 3 ಹಾಕಿಲ್ಲ.
ಇಲ್ಲ, my lord, ಅದು ಒಂದೇ ಹಾಕಿದ್ದೀನಿ. ಅದು ಜಜ್ಮೆಂಟ್ ಪ್ರಕಾರ ಎಲ್ಲ ಡಿಲೇ ಮತ್ತೆ ಇದರದೆಲ್ಲ ಸೇರಿಸಿ ಒಂದೇ.
Who has expired?
The respondent number 9 and 13, my lords.
55 during the pendency of the above matter. Respondent number
9 and 13.
9 and 13 have expired. Hence, IA 1 and 2 of 25 has been filed to bring the legal airs on record. Issue notice on IA 1 and 2 of 2025, returnable by 24th April. Office objection as regard non-production of the death certificate is overruled.
Serial number 99, your lordship. There are 3 other connected matters. They may be posted along with my lord.
19, they have to be posted.
Yes.
99 connect with so and so. And relist on.
Tomorrow, my lord, it may be disposed of.
Relist on 17th.
Please.
My lord, serial number 7.
ಒಂದು ನಿಮಿಷ.
ಅದಕ್ಕೆ ಕೆಲವು IS ಪೆಂಡಿಂಗ್ ಇದೆ.
99.3, accepting the memo. Petition number 2 to 28 are treated as legal representative of deceased petition number 1. Counsel for the petitioner to carry out necessary endorsement in the cause.
Serial number 85. Serial number 85. Morning we have taken adjournment by verse that we have not mentioned interim order extension. Kindly it may be extended.
Allow ಆಗಿದೆ.
Interim order has to be extended.
Mentioned 85 interim order. Check ಮಾಡಿ.
Gratefully, your lords.
Serial number 108.
Serial number 70.
108. At the request of counsel for the petitioner, relist on 11th March, interim order earlier granted is extended till next day.
Lord, 68, my lord. 68.2, my lord, ಅದರಲ್ಲಿ interim order ಇತ್ತು. Lord, last time, my lord, it was listed before the Kotal 7 interim order. Please.
73, my lord. They have filed an affidavit. Point two. In terms of that, affidavit can be disposed of.
ಇವಾಗ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ.
ಸರ್ ಈ ಮೂರು ಮ್ಯಾಟ್ರಸ್ ಅದ ನೋಡಿ ಕರೆಕ್ಟ್ ಮಾಡಿಸಿ ಯಾವ ಡೇಟ್ ಕೊಟ್ಟರು ಸರ್ 17 ಸ್ಟಡಿಪಾ
ಸೀರಿಯಲ್ ನಂಬರ್ 70 ಮೆನ್ಷನಿಂಗ್ ಇದೆ ಕೊಡಪ್ಪ ಸರ್. Court officer, sir.
Matter pertains to Kalburgi bench. 1, Pulleppa Herur.
Mr. Arur?
My lord, I am for petitioner, my lord.
Yes, Mr. Arur.
My lord, I am for petitioner, my lord.
Gottu, ಹೇಳಿ.
My lord, petitioner wants to engage senior counsel, my lord. Kindly grant me time.
In a RP, you can't engage any senior counsel. This is RP. You have to argue.
No, my lord, he
No
has
other counsel can argue.
my lord, I will come physically, my lord. I will come physically and argue, my lord. Kindly grant me 2 weeks time.
ಭಯಪಡಿಸ್ತಾ ಇದೀರಾ ಫಿಸಿಕಲಿ ಬರ್ತೀನಿ. ಯಾವತ್ತು ಬರ್ತೀರಾ ಹೇಳಿ?
ನಾನು ಬರ್ತೀನಿ, ಧಾರವಾಡ ಬರ್ತೀನಿ. ತಾವು 2 ವಾರ ಟೈಮ್ ಕೊಡಿ, ಬರ್ತೀನಿ.
ಯಾವತ್ತು ಹೇಳಿ?
ತಾವು ಬೆಂಗಳೂರಿಗೋ ಅಥವಾ ಗುಲ್ಬರ್ಗೋ ಬಂದಾಗ ಬರ್ತೀನಿ.
ಗುಲ್ಬರ್ಗಾಗೆ ಸದ್ಯದಲ್ಲಿ ಬರಲ್ಲ.
ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬೆಂಗಳೂರಲ್ಲಿ ಇರ್ತೀರಲ್ಲ, ಅಲ್ಲಿ ಬೆಂಗಳೂರು ಬರ್ತೀನಿ ಫಿಸಿಕಲಿ.
ಬೆಂಗಳೂರಿಗೆ ಬರ್ತೀರಾ?
ಫಿಸಿಕಲಿ ಬರ್ತೀನಿ.
ಆಯ್ತು, ಬನ್ನಿ.
First week of March.
At the request of counsel for the petitioner, relist on 5th March.
Grateful.
5th March ಪರವಾಗಿಲ್ವಾ?
ಬರ್ತೀನಿ, ಅವತ್ತು ಬರ್ತೀನಿ.
ಬನ್ನಿ.
Grateful.
ನೀವೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು, ಇನ್ಯಾರು ಮಾಡಕ್ಕಾಗಲ್ಲ.
Grateful.
These are the best principles, Mary.
Mood matter. 1, Arvind D. Kulkarni.
I'm appearing for the respondents.
Petitioner is the admission taken.
End of the list matters, Mr. Shekhar.
First matter, my lord, in the second list is Dharwad bench.
We are in the third list, first matter.
I'm sorry, my lord. There also Arvind Kulkarni is there, my lord, in the first matter.
Arvind Kulkarni is everywhere. Heli.
My lord's petitioner is taking admission
but not before the court. Now he has come. Yeah.
Petitioner is.
Party. Madam.
Petitioner is taking admission in the year for PG course, my lords, Ayurveda PG course, my lords, in the year 2018, 17 and 18, my lords.
Same change in syllabi and change in the.
My lords, this honorable court has granted interim order in the date on.
Taking into consideration that there is a
26/6
change in the syllabus as also in the rules. Ivaga examination beka. And the interim order has already been granted earlier. Respond number 1. He is directed to collect the fees, issue necessary or examination fees from the petitioners, issue necessary all ticket to them to enable them to take up the examination scheduled from
March 3rd, my.
3rd March 2025. Common order. Connect with ಬೆಳಗ್ಗೆ ಒಂದಿತ್ತಲ್ಲ ಯಾವುದು 33. Connect with 33 and relist on same date.
Look, so far as 103518 is concerned, petitioner number 1 has cleared the exam. We are seeking only insofar as petitioner number 2 is concerned.
Petition number 2 in the second matter.
Please, 103518.
Dharwad list. List number 1, 230 matter, 126.
I am for the petition.
Yes, affidavit to be filed by respond number 1 to 3. Yeah, who is appearing for respond number?
GI Gachin.
Gachin Mat. No, relay idralla. No, restrict print agilla. Your name is not printed, but so.
But I have filed affidavits as per the direction. I have filed.
Registry is direct print the name of Shri G.A. Gachinmat as that appearing for respond number 1 to 3. Affidavit ನೋಡಿದ್ದೀರಾ?
He is not served me a copy. ಕೊಟ್ಟಿಲ್ಲ.
ಇದೇನಕ್ಕೆ affidavit ಇದು? Okay, ಅವ್ರಿಗೇನು ಬೇಕಾಗಿಲ್ಲ. An affidavit of the Commissioner, Hubli Dharwad Municipal Corporation has been filed. We are not concerned with him taking charge now. What is the system for appearance?
There are nearly about 4 to 5 matters within this.
Yeah, 4 to 5 or 100. When a service is effected on the corporation, why is no representation being made?
Quite mistake, they were under the impression that it is very interested, but thereafter they found that.
So there is nothing to keep track which is interested, which is not interested.
Therefore, they have sought pardon of dishonorable court, and there is no.
That is okay. We want a system to be in place so that this doesn't happen.
There is I have also made it clear in my affidavit that there's such a mistake.
New CCMS ಅಲ್ಲಿ ಇದೀರಾ?
Yes, yes.
Then everything is available there. Affidavit has been filed by the so and so. The submission made in the affidavit is that the SDMC was under the bona fide belief that the matter had been entrusted to a council and was being represented. It is for that reason that no representation was. On inquiry with Sri Gurudev Gachinmat as to whether the SDMC is now onboarded onto the court case management system, he submits that it has been so done. If that be so, then it would be for the commissioner to instruct all the concerned to upload all the files onto CCMS and keep track of the pendency of the matter by ascertaining if the matter has been entrusted to anyone and if there is appearances being made by keeping track of the order sheets, orders passed in the said matters. Yes.
Not send this. It's only mandamus I'm seeking.
He told me that the matter is listed, but therefore I made appearance.
Only seeking mandamus, my lord.
Against respond number 4.
Against respond.
Yes, Mr. Sadiq, you are constructing illegally.
No, man, there is no illegal construction.
Where is your plan sanction?
My lord, I say kindly. My lord, this honorable court has, my lord, directed. This notice is 22/1/22, and this, my lord, notice was issued on 22/9/22, and this honorable court has directed corporation to take action in accordance with law. And therefore, my lord, this writ does not survive because there is a direction by this honorable court.
So what have you done in respect of this?
Some time may kindly be granted. Because
The J. Gachinmat seeks for and is granted.
This case is concerned, my lords, parties are different.
My lords, that the parties are different in the same, my lord. Here the party is different.
Respondent number 4, my lords, is one Venkatesh, but here the respondent number 4 is
Sridhar Shetty.
Who are you representing?
It is the same property. My lord, kindly see, my lord, the property in question in that writ petition and this.
27, 26 and 27, 30.
2725. Cities number. 2726, 2730. Which one they are?
2725, my lords.
This is 2725.
say that.
Different.
2726.
Around 50 to 60 years old building, my lords.
Petitioner is the owner of that. 2733.
Yes.
Nimdu 2725.
2725. Different property.
Different property.
Say, and everybody around you is constructing illegally.
Please. That has what happened, my lord.
It's a huge property, my lords. Different persons, my lords, 60-year-old building. They have purchased in bits and pieces. Now everybody, my lords, are complaining against each other that there is no proper plan. it is in main market plots like how we find the plots in BVK in that road. They are all common walls plots attached to each other. If at all one common wall is removed plots, the entire structure may come down.
How old are this building?
More than 60 years old.
Then you can't complain about any violation.
Oh, no, my lord. I have only filed a RTI, my lords. If there is any building permission of the same, my lords.
60 years back.
They themselves have sent notice, my lords.
60 years back, do you have a plan sanction?
The current building is not 60 years old, my lords. It's there are buildings that are 60 years old, but the current building that that is not 60 years old.
He's complaining of his building, Lord. His building is of 60 years old. I do not know how old is his building.
Though this building,
How can you complain about 60-year-old building after 60 years that it is not in?
The
it's
sale deed
illegal?
was done in 2000, my lords.
What was your vendor doing till then? See, there may be construction which have been happening before the building bylaws. You can't term them illegal because building bylaws has come now.
My lords, after my representation, they give notice, my lords. On that, they are doing nothing. And my only prayer is that notice was given, my lords. On
demolish everybody's building.
That is different, my lords.
You want to first start with this building.
My building is proper, my lords.
First start with this building.
My in my earlier writ petition, my lords, it was directed. I accepted the direction, my lords.
These are all business ventures, my lords. They have business rivalry.
My property is proper, my lords.
So examine his building. Respond number 2 and 3 are directed to carry out a measurement of the building in CTS number 2726.
2725, my lords. Subject matter of this petition.
2726 and 2725 JC Nagar, Hubballi, to ascertain if the constructions put up are in accordance with law. If any sanction plan was issued, if the construction is in accordance with the sanction plan, the age of the construction, to ascertain if there were any building bylaws which were applicable at that point of time, and submit a report as regards violation, if any, of the building bylaws, if the building bylaws were applicable. The inspection to be conducted commencing from 10:30 a.m. on 21/2/2025. Report to be submitted by 7th March, released on 11th March.
Previous matter, kindly take delivery. Committed to take.
When is the last day?
Last.
And delivery. End of the list matter. Yes.
127, Jagdish Patil.
Petitioner.
Lord, I crave leave, my lord, to appear for my learned colleague, Mr. Jagdish Patil, my lord.
Yes, please.
Please. Lord, the petition, my lord, is challenging the order on a number 14, my lord. Annexure J at page 162, my lord, is the order.
Suit for?
Suit, my lord, is this is not a suit, my lord, as such. This is a petition for revocation of probate granted, my lord. My lord, if you, my lord, what has happened to us, my lord, we are all relations. My lord, the petition number 1 and 2. Petition number 2 is the son of petition number 1. Respond number 1 is the sister of petition number 2 and the daughter of petition number 1. Then respond number 2 and 3, my lord, are the sons of children of petition number 1. Petition number 2, I'm sorry, petition number 2. Petition number 2, my lord, is the son of petition number 1 and one Ramrab Desai. Then respond number 4, my lord, is the wife of petition number 2. This is the relationship between the parties.
Yes.
First respondent is the contesting respondent, my lord, who is the sister of the second petitioner. My lord, there was an earlier suit, my lord, OS number 60 of 1999, where we all, my lord, had a common cause. We filed respond number 2 to 4 filed a suit for partition and separate possession. There is a decree, my lord, in OS number 60 of 1999 on 21/4/2007. OS number 60 of 1999 on the file of my lord Civil Judge Senior Division Dharwad. A decree for partition came to be passed on 21/4/2007. Challenging it, my lord, two first appeals came to be filed before this honorable court, my lord. There is one is RFA 1463 of 2007.
One?
Who are the 1463 of 2007. That was filed, my lord, by the respondent number 2 to 4, who are the plaintiffs in OS number 60 of 1999. And another appeal, my lord, RFA 1782 of 2007. This RFA 1782 of 2007 was filed, my lord, by the present petition number 1, petition number 2, and their father Ramrao, first respondent. All of us were together, my lord, Yalashme. Kindly turn to annexure A at page, my lord, 17.
Yes.
Page 17, my lord, down below, my lord, RFA 1782 of 2007. Sudhindra, my lord, first petitioner therein, first appellant therein is the second petition in the writ petition. Ramrao, my lord, was the father of petition number 2 and father of first respondent, husband of petition number 1 before your lordships. Sudhatai, my lord, is petition number 1 in the writ petition, who is the wife of Ramrao. And Kumari Arundhati, my lord, is the first respondent. So all of her together, my lord, this court, my lord, decreed, allowed the appeals by the judgment.
Something wrong with this cost title, Mr. Shastri.
Please,
Respondent number 3, Sudhabai, wife of Ram Rao, 65 years. Kumari Arundhati, daughter of Ram Rao, age 65 years. Mother and daughter are the same age.
Lord, your lord's eyes are very sharp, my lord. Exactly correct. Sudhat Abai is old, my lord. Now she is 83 years. She is the mother of respondent number 1 and appellant number 4 there. The age is, how is it? Generally High Court office doesn't miss these objections. Office makes us to trial and correct all such mistakes.
Yes, please.
Please, my lord.
But
Milord,
Arundhati is daughter of Sudhabai.
Correct. Now, my lord, this judgment is dated, my lord, 19th December 2008. So decree came to pass, my lord, granting 1/4 share, my lord, in certain schedules, my lord, so far as suit properties are concerned. That is, my lord, in A schedule and D schedule, 1/4 share is granted, my lord, to the plaintiffs, first defendant there. Anyway, my lord, that is one, my lord, cause where we were all together. Now, my lord, with properties coming, my lord, the equations change. Now, the first respondent who was all along together, my lord, has set up a will, my lord, annexure B. Annexure B will, my lord, is from Ramrao. There's page 59, my lord, your lordship sees.
A schedule properties are exclusive properties of defendant number 1. Excuse me.
Now, my lord, they are ancestral
portion
property.
is para 44, alva?
Please, my lord.
In the RFA, operative portion is para 44.
In RFA, my lord, operative portion is at page 46, my lord. Para 44.
46, para 44.
Para 44.
A schedule property, exclusive property of defendant number 1.
Correct.
Will have equal share of 1/4. The claim of plaintiffs in B schedule and C schedule is rejected. Sale of item 2 of A schedule by defendant. Now, which item are we concerned with in this?
No, my lord, we are concerned with all items here, my lord. We may just your lordship need not go through that, my lord, because all items are we are concerned. Yes. Now, annexure B, my lord, is the will on which the first respondent seeks a probate. Annexure B, my lord, page 59, my lord, your lordship says, Father Ramrao Desai, my lord, he is stated to have executed a will in favor of the first respondent. Now, my lord, the list of items, my lord, your lordship says, properties at Kelgeri, Lakmanahalli, Dandinkoppa, Saptapur, my lord, a large number of properties, everything is given, my lord, to the first respondent alone, and neither to the son nor to his wife, anything. My lord, in this will. It is a simple will, my lord, where we can reading of it,
most of it to his
everything
daughter.
to the daughter. Now, my lord, first respondent files a petition for seeking probate. My lord, in P&SC, my lord, 17 of 2014. There, my lord, with the double comes. P&SC 17 of 2014. It was initially dismissed in the year 2014. An appeal came to filed. It was remanded. And after remand, my lord, annexure C order, page my lord, 65, dated 4/2/2017.
Yes.
Page 65, my lord, annexure C. There, my lord, your lordships is respondents is nil. So, my lord, the first respondent was along with us, files this petition without impleading any one of us, and obtains a probate for all the properties, my lord, including
Public notice citation was taken.
my lord, of course, my lord, there will be a citation how far it is legal, illegal. My lord, is a matter, my lord, which is again, my lord, a subject matter of a petition for revocation. Now, my lord, I am before your lordships on a small issue. Now, in this P&SC 17 of 2014, my lord, came to be allowed. A petition, my lord, for revocation was filed, my lord, by the respondent number 2, 3, and 4. Their petition, my lord, your lordship says, annexure D, my lord, is their petition at page, my lord, 77. Page 77, my lord, is the petition in miscellaneous number 130 of 2021.
Yes.
This petition is filed, my lord, by the respondent number 2 to 4 for revocation, and we got impleted. The present petitions got impleted ourselves as respondent number 2 and 3. Your lordship sees the cause title. Respondent number 2 and 3 are the present petitioners before your lordships 1 and 2.
They are also supporting the petitioners.
They are supporting the petitioners. They filed objections, my lord, supporting the petitioner's cause. They said this will is not justifiable, and the petition has been obtained behind our back. It is liable to be revoked.
Naturally,
Then, my lord,
petitioners are your children.
Truly. And my lord, the will is by my father and husband of petition number 1.
Yes.
Then, my lord, what happened is we filed a petition, my lord, under Order 1, Rule 10(2), my lord, for transposing us as petitioners because it is a common cause. At page 162, my lord, the trial judge was pleased to reject the said petition agreed by which, my lord, the present petition is before lordship. Page 162, my lord, your lordship may kindly see. The order dated 27/11/2024. Counsel for respondent number 2 and 3 submits his IA number 14 for transportation of respondent number 2 and 3 as petitioners is pending, and order has to be passed on it before evidence. It is observed that it is a miscellaneous application filed for revocation of probate, and the scope is very limited to this court to decide only on merits of the case for revocation. And when the respondent number 2 and 3 have already appeared and filed objection admitting the claim of the petitioner and denying the claim of respondent number 1, hence considering this application does not arise in revocation application, this is a miscellaneous application only. Hence, said application cannot be considered in miscellaneous application, and same is rejected. Advocate for respondent present who submits no further chief. Case is posted for cross of RW1. Now, my lord, my submission to your lordship says, when a plaintiff has not objected, when, my lord, the respondent number 2 and 3 before the learned trial judge supports the cause of the plaintiff also. In addition, they also claim, my lord, interest in common with the plaintiffs. My lord, the court, my lord, in the ordinary circumstances, my lord, shall not reject the transposition. My lord, I am placing a decision of the Supreme Court, my lord, in the year 1965 Supreme Court, my lord, page 1812.
Who appears for respondent number 1?
I am appearing, my lord.
Any objection for the transposition?
Yes, my lord.
What objection?
My lord, as far as the petition that is filed by the petitioners is for revocation of probate, my lord. That was filed on 3/12/2021. So any application for revocation of probate is to be filed within 3 years from the date of the granting of the probate. Now the present petitioners, they file a transposition application, they file impleading application in the year 2022, which is beyond 3 years. Thereafter, after one year, they file an application to transpose themselves as petitioners, my lord. My respectful submission is, what cannot be done directly cannot be done indirectly, my lord. Now that they have not challenged the probate, by way of transposition, they cannot now challenge and say that the probate that has been granted should be revoked, my lord. So this is a main objection.
You can complete your submission, Mr. Shastri. 1965 SC 1812.
Page, para 15, my lord, para 15. Para 15, my lord. Now regarding the second point, this objection is purely technical. The plaintiff sued for partition of the suit properties upon the ground that they were inherited jointly by her and by the first defendant, and claimed possession of her share from the other defendants who were wrongfully in possession of the properties. She also alleged that the first defendant did not cooperate in the matter, and so she had to institute the suit. The first defendant admitted the plaintiff's title to half share in the properties and claimed a decree also in her own favor to the extent of remaining half share in the properties. She could also have prayed for her transposition as a co-plaintiff, and Order 1 Rule 10.2 of CPC, the court could have transposed her as a co-plaintiff. The power under this provision is exercisable by the court even suo motu. As pointed out by the Privy Council in Bhupendra versus Rajeshwar, the power ought to be exercised by a court for doing complete justice between the parties. Here, both the plaintiff and the first defendant claim under the same title, and though defendant number 2 and 8 have urged special defenses against the first defendant, they have been fully considered and adjudicated upon by the High Court while allowing her.
Noted, Mr. Shastri. Indian Succession Act, Limitation Act. Yes, go ahead.
Your Lordships are hearing me now?
Yes, please. We are hearing you.
Please, my lord. So, my lord, the power under Order 1 Rule 10.2, my lord, is at any time by the court suo motu or an application, my lord, by the parties. Now, to do justice, persons, my lord, claiming similar rights. Now, even the petition, my lord, that way, if we claim the manner in which my learned colleague is arguing, P&SC, my lord, we were not aware, my lord, of the P&SC which they have obtained. That was behind our back. We got ourselves implemented supporting the petitioners. Then ours is a common cause. So, my lord, we wanted to put ourselves, my lord, along with them.
Where the impleading application filed by you?
Please, my lord. That is, my lord, annexure
G in 109 to 113 euros.
Yes, 109 to 113.
5/8/2023. Alla, idu transpose.
Lord, they have not produced
There
that.
is your 1 Rule 10 application.
Oh, 1 Rule 10.
Order 1 Rule 10.2 application.
Alla, idu transposition read with Order 23 Rule 4.
Lord, that application.
Your 1 Rule 10 the first 1 Rule.
Alla, adin madilla.
Kodi nim file alli irbekku.
That was filed on 16/6/2022.
Ibber file alli ello irutte kodu.
Nan kade
illa avara hatra idre patil hatra
idenu illa anbiಡ್ತದೆ.
Because it was filed on 16/6/2022 and allowed on 15/12/2022
with no objection from them.
No, sorry.
What is the government made therein as to knowledge? Date of knowledge. The only argument being advanced is apparently on limitation.
Yes.
Yes.
Date of knowledge pleaded would be important. 3
My
years
lord.
from there.
Yes.
This limitation is a point, my lord, which requires to be argued, my lord, at a later stage.
Question of fact. But the purpose of application ilva, Mr. Patel?
No, Your Lordship, sorry. I'll get it tomorrow.
Full file on the Yes, Mr. Shastri, go ahead.
Please, my lord. My lord, so far as limitation is concerned, my lord, of course, at the stage of pleading, my lord, it need not be decided at this stage. It is always open at the time of final hearing, my lord, to argue these points, the court to take up the same and to decide the same.
Transposition is different. That is why. You are seeking for transposition.
Transposition, my lord, when the plaintiff and the contesting defendants or whatever who are placed together, if they have a common cause, if there is no conflicting interest, if the plaintiff doesn't oppose, my lord, there is no cause, my lord, for there is no reason, my lord, to not to transpose the defendants. Now we are 83 years old, my lord. First petitioner is 83 years old, cancer patient, and under the circumstances, my lord, we all will be my lord, our cause will be proved even by the petitioners therein who had already filed and led evidence. That is how, my lord, the application came to be filed. Now, my lord, learned trial judge seems to be of the opinion that in a miscellaneous application, such an application is not maintainable. Scope is limited. I did not really understand what the learned trial judge says, my lord, by scope is limited.
Even
He
if
says,
even if the petitioners in the 263 application were to prove, the probate will be set aside, you will get the benefit out. Why do you need to become the petitioners?
my lord, your lordship says petitioners are also having rights. The petitioners
Rights
are class 1 has.
Rights are not going to be determined in 263. 263 is only determining whether the probate granted was proper or not.
Right.
If it is
Now, my lord,
proper, it will hold it to be proper and finished.
There, my lord,
Improper, it will be set aside.
I understand. My lord, there, my lord, your lordship say the primary law is the persons who are class 1 heirs, whose interest will be denied, are to be implemented as parties. Nobody is implemented. My lord, I am the son. Second petition is the son. First petition is the wife. Nothing is given to the will.
We are not
Under the will.
Here, Mr. Shastri. You are
Please,
arguing the transposition, rejection of the application for transposition.
That's right, my lord. My lord, what I am submitting before the honorable court is this transposition as petition assist to vindicate the rights, my lord, of the parties. When, my lord, a person has got a right as a defendant, then he will join as a plaintiff because to vindicate his rights.
No, vindication
No, my lord,
of
there
rights
is no
in a suit is different. In a 263 proceedings, it is different. 263 is only concerned whether the probate has been granted properly or not. No rights are going to be determined.
No, my lord.
If the probate is set aside, the probate proceedings will be reopened for all of you to participate. There, the vindication and the rights will be ascertained, but not in a 263 proceedings.
No, my lord. That's right, my lord. I am only submitting, my lord, to the extent of my lord, revocation of the probate. We have interest. We have, it is to be revoked because class 1 heirs are not implemented. Probate, my lord, is a judgment in rem. It will be binding on the whole world. That way, it will affect our interest. Therefore, my lord, as co-petitioners, we want to challenge these proceedings. And we are not at all implemented as parties, my lord, in the probate proceedings. Nobody is implemented as parties. That is where, my lord, your lordships, ultimately, justice requires to be done. If something is allowed to be taken back by obtaining a probate behind the back of persons who we were all together, my lord, your lordship says the previous suit for partition, just, my lord, we were all together, we were co-appellants. Then, my lord, she has stated to have obtained this probate. My lord, the trial judge seems to be under a mistaken opinion, my lord, that this code of civil procedure is not applicable to the probate proceedings. My lord, actually, my lord, it is a mistaken view. I may take your lordship, my lord, to section 268 of the Indian Succession Act.
268.
Indian Succession Act.
Yes.
Proceedings of district judges court in relation to probate and administration. The proceedings of the court of the district judge in relation to the granting of probate and letters of administration shall, save as hereinafter otherwise provided, be regulated so far as the circumstance of the case permit by the code of civil procedure.
Yes.
Not all sections, my lord, make this CPC applicable there. My lord, section 299, my lord, section 299.
Yes.
Appeals from orders of district judge. Every order made by a district judge by virtue of the powers hereby conferred upon him shall be subject to appeal to the High Court in accordance with the provisions of Code of Civil Procedure 1908. Now, my lord, district judge is defined under the Act, my lord, in section 2 BB. Section 2, my lord, BB.
Yes.
Definitions. District judge means the judge of a principal civil court of original jurisdiction. So, my lord, it is a civil court. Then, my lord, you ask me kindly turn to section 141, my lord, of this Code of Civil Procedure also.
Yes.
Lord, section 141 of the Code of Civil Procedure says, my lord, miscellaneous proceedings. the procedure provided in this code in regard to suits shall be followed as far as it can be made applicable in all proceedings in any court of civil jurisdiction. District judge is a court of civil jurisdiction. CPC also says, my lord, the procedures are under the, so far as courts are concerned, CPC has to be made applicable in all the proceedings other than the suits also, miscellaneous proceedings. This is a miscellaneous proceeding till it is registered as a suit, my lord, by contest after revocation. Then, my lord, the provisions of Succession Act also says, the learned trial judge says, my lord, this application is not maintainable on the probate side.
You filed this application 10 rule 2, read with 23 rule 4.
23 rule 4?
How is 23 rule 4 applicable?
23 rule 4, my lord, may not be applicable prima facie.
So apart from one rule 10, what is the other provision that you rely upon?
Order 1 rule 10, my lord, for transposition, my lord, it is only order 1 rule 10, my lord. Section 150 can also be adopted, but it is order 1 rule 10(2). In essence, my lord, is the that is the power of the court coupled with the right of the party, my lord.
22 rule 4. What is that? Application like
Order 23 rule 4 is proceedings in execution of decrees. That is,
Yes.
my lord, something.
23 rule
totally
1A is attracted if the plaintiff abandons, then the defendant can
abandons.
That is there in 23 rule 1A.
Correct.
What is the provision under which you get a right to transpose as a, from the defendant?
Not
to the
order 1
plaintiff?
rule 10(2), my lord. The procedure to be adopted, the power is under order 1 rule 10(2).
Yes.
That, my lord, your lordship says, the court shall, or the court may strike out or add parties. The court may, at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just, order that the name of any party improperly joined, whether as plaintiff or defendant, be struck out, and that the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court to effectually and completely to adjudicate upon and settle all the questions in order suit, be added. So the power is wide, my lord, with the court, with no, my lord, with no rather, my lord, fetter, either as regards limitation or otherwise. All questions of limitation are to be decided, my lord, at a later stage, not, my lord, at the stage of impleading. Even, my lord, when a person is impleaded in a suit, my lord, at a later stage, now the law says limitation will commence against him from the date he was impleaded. That way. But this calculation of limitation is a wider issue, my lord, is altogether a different context. The same, my lord, cannot be adjudged at this stage. It all, my lord, depends upon the facts and evidence on record. Whether we had a notice, whether we had deliberately kept out and the like.
Yes.
But there is no reason, my lord, having regard to the common interest, having regard to the fact that all of us were living together, aiding together, fighting together, as against third parties, to save properties and to take share to ourselves. And
you're not living together, you have been fighting together.
We are fighting together now, my lord. Now, my lord, once my lord, property comes, now, my lord, even now, my lord, our wives are not given rights, my lord, in our country. If they are also given rights, my lord, I am sure.
Anything else?
That's all. That's all.
Yes, Mr. Sangram.
My lord, the objections which have been filed are in page number 115, my lord. The main petitioners who had filed the miscellaneous, they are not the class 1 heirs.
Yes.
And therefore, the specific objection that was taken up by the respondent, saying that they have no locus standi to challenge the probate which has been granted. Now, by indirectly, they want to get themselves transposed, and they want to challenge what they have not done within time. They want to do it by way of transposition, my lord, and that's the reason why the application filed by the.
That if it is barred by limitation, that is
So
a
on
ground that
that,
you can take after that, not now to decide whether that transposition
No, my
should
lord,
be
as
allowed
far
or not.
as that contention, my lord, saying that on the date of their transposition, if now this honorable court allows them to get themselves implemented as petitioners, then as far as the limitation point is concerned, my lord, that would it cannot be considered the day
That is
on
not
which
the ground which has been considered by the trial court.
it is not
But
considered by the
court has
trial.
only said that they already filed entered appearance, they filed their objection
Yes, my lord.
supporting the petitioner. Therefore, there is nothing to transpose them
Yes.
and rejected the application. It's a very innocuous order which has been passed without going into the merits of the matter at all.
No, but as far
Nor
as the
river
limitation,
contains.
as far as the limitation point is concerned, my lord, since that aspect is required to be considered as to from which day they will be considered as petitioners,
That
because
will be considered during course of trial. You will always be entitled to file your objections to that. Trial would have to be held for that.
yes, for that. So
When did I get knowledge? When you got knowledge?
no, but
All those things are something which cannot be determined now.
but that is a order that has been passed by the competent court, my lord. So as on the date of filing, passing of the order,
We are not making any comment on that order. Otherwise, you will be in trouble. So we'll refrain from doing
Yes.
anything. Both of you can litigate the matter there. Expressly, what Ms. Shastri says is right.
yes.
But we are not exercising jurisdiction on that. We are refraining. Petitioner is before this court seeking for the following reliefs. Respondent number 1 had filed a proceedings under section 276 of the Indian Succession Act for grant of probate in respect of a will dated 26/10/2012 executed by her father in respect of the properties scheduled to the said will. The said petition came to be allowed by order dated 4th February 2017 in P&SC number 17 of 2014. Challenging the same, respond number
2 to 4.
2 to 4 herein filed proceedings under section 263 of the Indian Succession Act 1925 for revocation of probate, which came to be numbered as civil misdemeanor number 130 of 2021. In the said petition, the petitioners had been impleaded by order dated 16/6/2022 as respond number 2 and 3. Subsequently, the petitioners moved an application for transposition as petitioners in civil miscellaneous number 130 of 2021, which came to be rejected by the impugned order dated 27/11/2024 on the ground that the respond number 2 and 3 having already appeared and filed objection, admitting the claim of the petitioner and denying the claim of respond number 1, the said application for transposition cannot be considered.
It is a miscellaneous case, not a suit. Observation then.
Ah,
It is a miscellaneous case.
miscellaneous 130 of 21.
But the observation of the trial court
Ah.
rejecting, because it is not a suit, it is a miscellaneous
Yes,
case.
ಅದಕ್ಕೆ ಬರ್ತಾ ಇದೀವಿ. The trial court further held that the application ಇದು miscellaneous 130 ಏನಿದು?
That
What
is
is
the
130?
petition for revocation, Lord. This
Revocation.
130 of 2021 is for revoking PS&SC 17 of 2014, the order
trial court
dated 4
further
to
held
2017.
that considering the application for transposition would not arise for consideration in a revocation application on the ground that the same is a miscellaneous petition. It is challenging the same, the petitioners are before this court. Shri G. Balakrishna Shastri, senior counsel appearing for the petitioner, would submit firstly as regards the relationship between the parties, by contending that the first petitioner is the mother, second petitioner and the first respondent are the son and daughter respectively. The second and third respondents are the children of
second petitioner.
The fourth respondent is the wife of second petitioner. Second and third respondents are the children of petition number 2 and respondent number 4. His submission is that all of them belong to the very same family and a revocation of the probate granted has been made by a family member. His further submission is that earlier there were certain suits which had been filed. There was a suit filed for partition in OS number 60 of 1999, which was partly decreed on 21/4/2007. Two regular first appeals have been filed in RFA 1463 of 2007 and RFA 1782 of 2007. The
Trial court judgment was modified. Annexure A is the order.
That is the reason why the will was executed. You know what we mean, Ms. Shastri? Who are the plaintiffs against whom it was filed? ನೀವೇನೋ ಟುಗೆದರ್ ಅದು ಇದು ಅಂತೆಲ್ಲ ಹೇಳಿದ್ರಿ. ಆ ಟುಗೆದರ್ ಎಲ್ಲಿ ಬರುತ್ತೆ ಕಾಸ್ಟ್ ಟೈಟಲ್ ನೋಡಿದ್ರೆ?
ಸರ್ ಆಸ್ತಿ ಬಂದ್ಮೇಲೆ ಟುಗೆದರ್ ಇಲ್ವೇ ಇಲ್ವಲ್ಲ ಸರ್? ದುಡ್ಡು ಬಂದ್ಮೇಲೆ
ಆಸ್ತಿ ಬರ್ಬೇಕು ಅಂತ ಮಕ್ಕಳ ಕೈಯಲ್ಲಿ ಹಾಕ್ಸಿದ್ರಿ.
ಆವಾಗ ಭಾಗ ಸರಿ
ನೀವೇ ನಿಮ್ಮ ಮಕ್ಕಳ ಕೈಯಲ್ಲಿ ಮಕ್ಕಳು ಆಮೇಲೆ ವೈಫ್ ಕೈಯಲ್ಲಿ ಹಾಕ್ಸಿದ್ರಿ.
ಸರ್ ಆವಾಗ ಥರ್ಡ್ ಪರ್ಸನ್ಸ್ ಮೇಲೆ ಅವರು ಪರ್ಚೇಸರ್ಸ್ ಇದ್ರು, ಪರ್ಚೇಸರ್ಸ್ ಮೇಲೆ ಎಲ್ಲ ಕಾಮನ್ ಕಾಸ್ ಆವಾಗ.
You did a shortcut for using the legal process and abusing the process. Now it is coming back to you.
Backfires. Lord, something bad against third persons will sometimes ultimately we should not teach wrong things to children. It comes back to us.
It's come back. They were the purchaser specific performance.
ಅದು ಅವರು ಪರ್ಚೇಸ್ ಮಾಡ್ಕೊಂಡಿದ್ರು, ಅದು ಬೈಂಡಿಂಗ್ ಇಲ್ಲ, ಅದು ಸೇಲ್ ಬೈ ಎ ಪರ್ಸನ್ ಹೂ ಹ್ಯಾಸ್ ನೋ full rights, absolute rights, joint family rights. Now this is very commonly adopted, my lord, in Dharwad, North Karnataka side. They are very great litigants.
Innovative.
Very innovative, and beyond our, my lord.
What goes around comes around, Mr. Shastri. The balance sheet is during this life only. No 7 generations.
That we forget, my lord. While we do the acts, that we forget ultimately.
That is why your father executed a will in favor of the daughter, not
all properties. No, my lord. No, all properties, not one or two.
Anyway, that all these are to be established. We are not going to observe anything because that is not our. The two RFAs in RFA 1463 of 2007 and RFA 1782 of 2007 came to be filed, which came to be decreed on 19th December 2008. On that basis, it is submitted that when the parties were together during that period of time, the petition for probate in P&SC 17 of 2014 had been filed without arraying the class 1 heirs as respondents. And it is in that background that the probate having been granted ex parte, virtually ex parte, proceedings in civil miscellaneous number 130 of 21 had been filed seeking for revocation of the probate. The submission of Sri Balakrishna Shastri is that the wife of respondent number 3 in civil miscellaneous number 130 of 2021 and the children of respondent number 3 being the petitioners in miscellaneous number 130 of 2021, the petitioner, the respondent number 3 and his mother, respondent number 2, who do not have any conflicting interest with the petitioners, had sought for transposition. They are anyway supporting the case of the petitioners, and as such, the trial court ought to have allowed the said application. His submission is also that the rights of respondent number 2 and 3 in miscellaneous number 130 of 2021 would also have to be decided. And in this regard, he relies upon the decision of the Honorable Apex Court in AR 1965 SC 1812, more particularly para 5 and 15 thereof, which are reproduced hereunder for easy reference. By relying on the decision in Madanappa's case, his submission is that the Honorable Apex Court in that matter had held that there was a possibility of a respondent seeking for transposition to agitate the right of the respondent, of the defendant. The defendant not having sought for transposition could not agitate the rights subsequently. And it is on that basis we submit that the petitioners have erred on caution and have sought for transposition, so that no such defense is held taken against the petitioner. And on this ground, we also submit that the transposition application was required to be allowed. Shri Sangram Kulkarni, Learned Counsel, appearing for.
As far as the present petitioners, before miscellaneous petitions are concerned, my lord, they do not have any right, and their right is not common.
You will deal.
Yes, and there is one judgment of the
Body.
Apex Court. Para number 13 and last two lines of para number 12.
This is that demolition of the building.
No, my lord.
A modification of sort.
What cannot be done?
That is a general principle. Not transposition will this is a general principle of law. Anyway, we'll refer to it, but that won't help you as a general principle. Shri Sangram Kulkarni, Learned Counsel for respondent number 1, submits that the petition in civil miscellaneous number 130 of 2021 was filed by persons who are not class 1 legal heirs and as such was not maintainable. And it is in that background that the petitioners wanted to seek to be transposed, since they are the class 1 legal heirs. On that basis, we submit that the petitioner is seeking to do what could not be, are seeking to do indirectly what could not be done directly, inasmuch as if the transposition is permitted, the petition by respondents would become valid when a fresh petition by them would have been barred by the law of limitation. His further submission is that it was for the petitioners to have chosen to come on record as petitioners initially and not as respondents. Once they have come on record as respondents, now they cannot seek to transpose themselves as petitioners. Lastly, he submits that the proceedings being miscellaneous proceedings, the question of transposition would not arise. Heard so and so, produce papers. The points that would arise for determination, heard so and so, produce papers. Points that would arise for determination are whether an application for transposition could be filed in a miscellaneous proceedings under in a petition under section 263 of the Indian Succession Act 1925. The same being numbered as a miscellaneous proceedings. 2, whether when an application for transposition is filed, the aspect of whether the application being barred by limited, the contentions being barred by limitation would have to be considered at that stage. 3, whether the order passed by the trial court in the present matter is proper and correct, or does it require any interference. 4, what order? First, the trial court in the present matter has come to a conclusion that since the proceedings are miscellaneous in nature, application of transposition could not be considered. The numbering of the proceedings as a miscellaneous proceedings is only on account of administrative necessity and not by terming it as a miscellaneous proceedings by itself. A proceedings under Section 263 of the Indian Succession Act seeking for revocation of a probate is a substantial right and a substantial proceedings. Though the same cannot be numbered as a suit, for administrative purposes, the same is numbered as a miscellaneous petition. Such being the case, it is not a miscellaneous proceeding arising out of a suit, but is a substantial proceeding by itself. If allowed, would result in revocation of a probate already granted, and if dismissed, would confirm the probate already granted. In that view of the matter, I am of the considered opinion that when such substantial questions are being decided by a court seized of the proceedings under Section 263, the entire civil procedure code would be applicable, including the rights under Order 1, Rule 10, bracket 2, and any other provision of the civil procedure code. In fact, the trial court had earlier allowed an application under Order 1, Rule 10, bracket 2, and permitted the petitioners to come on record as respond number 2 and 3. If the provisions of Order 1, Rule 10(2) were not to be held to be applicable, then the earlier order allowing the impleading of the petitioners itself can be brought to doubt. That not being the purpose of the proceedings under Section 263, the trial court had rightly allowed an application for impleading, taking into consideration that the person sought to come on record had an interest in the proceedings, and any order passed therein would probably affect them, and as such held them to be proper and necessary party. The same being the case, in that view of the matter, I answer point number 1 by holding that even in a proceedings under Section 263 of the Indian Succession Act 1925, the Civil Procedure Code 1908, and all incidents thereto would be applicable, including an application under Order 1, Rule 10, bracket 2 of the Code of Civil Procedure. Answer to point number 2. Point number 2, another? 2, 3.
Limitation.
The contention of Mr. Sangram Kulkarni, Learned Counsel for Respond number 1, is that the probate having been granted on 4th February 2017 in P&SC 17 of 2014, an application for transposition being and the same having been challenged in Mr. number 130 of 2021. The petitioners having come on record as respond number 2 and 3 by order dated 16/6/2022, the application for transposition filed on 5/8/2023 in IA number 14 is barred by limitation, and as such the application not being maintainable would have to be rejected. This contention of Sri Sangram Kulkarni is not one which has been relied upon by a trial court in dismissing the application and application in IA number 14. The dismissal of the application is for reasons as indicated above. Though the said aspect has not been considered by a trial court, since the argument is advanced by Mr. Kulkarni before this court, the same is considered. It is tried law that the aspect of limitation is a mixed question of fact and law, and not one of law alone. Unless any proceedings or a suit can be said to be ex facie barred by limitation, the question of passing an order by relying on the law of limitation would not arise. If there is any dispute and there is a possibility of a different conclusion being arrived at, then the parties would have to be relegated to trial so as to establish as to whether the application is within the period of limitation or not. In that view of the matter, the contention of Mr. Sangram Kulkarni as regards the claim of the petitioner to challenge the probate granted would be barred by limitation if a separate application were to be filed is an aspect which would have to be considered by the court seized of civil miscellaneous number 130 of 2021 while passing orders, final orders on the said petition. And at that stage, the trial court would have to take into consideration that the petitioners were impleaded subsequently, and the claim made by them would have to be taken into consideration from the date on which the application for impleading was filed and not from the date of the original proceedings. In that view of the matter, the aspect of limitation, being a mixed question of fact and law, cannot be considered at the time of considering an application for transposition, but would have to be considered at the stage of final judgment in the matter so as to avoid multiplicity of trials. In that view of the matter, I answer point number 2 by holding so and so. Point number 3. In view of my answers to the above points, the finding of the trial court that an application for transposition cannot be considered in miscellaneous proceedings not being correct, I am of the considered opinion that the application filed by the petitioner in IA number 14 under Order 1, Rule 10, bracket 2, it was required to be considered on merits and orders passed. Having considered the same, having considered on 5/8/2023 is allowed the date of the application shall be considered by the trial court for purposes of limitation as and when the same said aspect were to be considered. Next. A peril of the order dated 27/11/24 does not indicate the same to be in compliance with the circular dated so and so. Hence, the additional registrar judicial is direct forward a copy of the circular to so and so court for compliance in future orders.
Opportunity to file additional objections to respondent.
Well, adakku munche, needless to say, once the respond number 2 and 3 are transposed as petition number 4 and 5 in civil miscellaneous number 17 of 2021, the written statement filed by them will be automatically form part of the petition filed by the petitioners therein, as such providing an opportunity to respondent number 1 therein to file additional written statement in respect thereto. Such right to file additional written statement is reserved to respond number 1, which shall be filed within a period of 60 days from today.
28, Shivprasad Shantangowda.
Pay for the petition.
Yes.
There is an interim order granted on 29/1.
Lord, on the Lordship has directed me to assert whether the PDO has the power to cancel the solar, pursuant to which, my Lord, may I pass on the order. Wherein, my Lord, we have taken a note that PDO has no such power, and now he has been suspended.
Is this applicable for the panchayat or only?
No,
for
it
the
is not
village
applicable. It is not applicable.
Mr. Iramat yesterday submitted that the permission granted by you is only for the village, not for the panchayat.
Yes.
That is why he has taken that.
Yes. For that reason, my Lord, may I take it to Lordship at page number 2 of the communication sent by.
Yes.
Second paradale. ಆದ್ದರಿಂದ ಸೋಲಾರ್ ವಿದ್ಯುತ್ ಘಟಕದ ಕಾಮಗಾರಿಯನ್ನು ಸ್ಥಗಿತಗೊಳಿಸಲು ಸೂಚಿಸಿದ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಸೋ ಅಂಡ್ ಸೋ ತಾಲೂಕು ವಿಜಯನಗರ ಜಿಲ್ಲೆ ಇವರನ್ನು ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರಿ ಹಾಗೂ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಇವರು ದಿನಾಂಕ 12/2 ಅಮಾನತುಗೊಳಿಸಿ ಆದೇಶಿಸುತ್ತಾರೆ. ಈ ಮಾಹಿತಿಯನ್ನು ಮಾನ್ಯ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಸೋ ಅಂಡ್ ಸೋ ಬಿಫೋರ್ ದ್ಯಾಟ್ ಮೈ ಲಾರ್ಡ್ ಮೇಲೆ ಪ್ಲೀಸ್ ಮೇಲ್ಕೊಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಉಲ್ಲೇಖ ಒಂದು ಪತ್ರ ಕಡೆ ಗಮನಿಸಲೇಲಾಗಿದೆ. ಈ ಪತ್ರದಲ್ಲಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಪೀಠದಲ್ಲಿ ದಾಖಲಾದ ರಿಟ್ ಪಿಟಿಷನ್ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 29 ನೀಡಿದ ಆದೇಶ ನಿರ್ದೇಶನದಂತೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಪಂಚಾಯತ್ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕೊಟ್ಟೂರು ತಾಲೂಕು ವಿಜಯನಗರ ಜಿಲ್ಲೆ ಇವರಿಗೆ ಸೋಲಾರ್ ವಿದ್ಯುತ್ ಘಟಕ ಕಾಮಗಾರಿಯನ್ನು ಸ್ಥಗಿತಗೊಳಿಸುವಂತೆ ಸೂಚಿಸಲು ಸಮಕ್ಷಮ ಪ್ರತಿಕಾರ ಸರ್ಕಾರದಿಂದ ಮತ್ತು ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ಜಿಲ್ಲಾ ಪಂಚಾಯತಿ ಯಾವುದೇ ನಿರ್ದೇಶನ ನೀಡಿರುವುದಿಲ್ಲ. So based on which, my lord, CEO has taken action and the PDO has been suspended.
Why are they doing like this? They know the law, but they purposely do this. ಏನ್ ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಟ್ರೈನಿಂಗ್ ಕಳ್ಸು ಅಂತ ಹೇಳ್ಬೋದು. ಗೊತ್ತು ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡೋದು?
To stop the proceedings, murder, she did.
Petitioner is before this court seeking for the following reliefs. The submission of Shri Shiv Prasad Shantan Gowda, learned counsel for the petitioner, was that respond number 5, without any jurisdiction, had issued endorsement dated 2/1/2025 at annexure L, calling upon the petitioner to stop the implementation of the solar power project undertaken by them. In that view of the matter, the learned AGA implemented by them in furtherance of the government order dated 8/7/2024 at annexure A. In that view of the matter, the learned AGA was called upon to obtain instructions as to whether the PDO had any jurisdiction or authority to stop the petitioner from implementing a project in furtherance of a government order dated 8/7/2024. Today, a memo has been filed by the learned AGA stating that the Panchayat Development Officer did not have any such powers, has exceeded his powers, and as such necessary action has been taken by the Chief Executive Officer, Zilla Panchayat Vijayanagar, by suspending the said PDO and initiating proceedings against the said PDO. The said memo and the documents which have been produced would categorically indicate that the endorsement dated 2/1/2025 at annexure L issued by the respond number 5 PDO was without any authority and is in abuse of the official powers and a fraud on power. In that view of the matter, I pass the following order. Writ petition is allowed, a certiorari is issued. The endorsement dated 2/1/25 bearing number so and so at annexure L issued by respond number 5 is quashed. A mandamus is issued directing respond number 4 to issue necessary license stroke NOC in terms of the government order dated 8/7/2024 and the circular dated 23/2024 at annexure P within a period of ಎಷ್ಟು ದಿನ ಆಗುತ್ತೆ?
If they have submitted all the documents required,
ಸಬ್ಮಿಟ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿ.
But the circular again once again says that I did not submit any documents. Only government.
You are not submitted.
No. The circular says only the government's approval is sufficient. That is all.
It will be dealt with in accordance with law.
On fulfilling certain conditions.
Within 30 days from the date of receipt of a copy, 15 days from the date of receipt of a copy. 30 days in solar power.
PDO is not there.
PDO illa andre ಇನ್ನೊಂದು PDO appointment. Mr. Shivraj is officiating us.
In fact, my lord,
30 days from the date of receipt of a copy of this order in accordance with law.
Please.
Until then, my lord, I am permitted to carry out my works.
How can you carry out the work without the license?
Lord, I am permitted. Under the circular, I am permitted.
If you are permitted, go ahead. If you are not, they will take action again.
Please.
129, Prakash Javalkar.
My lord, it is in respect of the petitioner is already running an English medium school from 1st to 8th standard. Now it has applied for 9th and 10th standard. And that has been
9th and 10th Kannada.
In Kannada medium. And that has been, it is a non-aided school, my lord.
Yes. Lord, in view of the government circular, it would be treated as a new school and they have to fulfill the certain conditions which has to be as per. Since my 1 to 8th is English medium, they are seeking for a 9th and 10th Kannada medium.
Yes.
So my lord, since the entire and they have the documents which they have submitted with regarding to establishment of 8th and 9th school is with regarding to the infrastructure that has been maintained for the English medium school.
What is the reasoning for annexure B?
Please, page 31, my lord.
25, B. D is
B.
appeal.
Yes, ma'am. Page 25 is the original order.
Annexure B.
Lord,
ಅದೇ ಸ್ಥಳದಲ್ಲಿ ಹಾಗೂ ಅದೇ ಕಟ್ಟಡದಲ್ಲಿ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ. If you say you comply with something, they will comply.
In view of that government circular, this endorsement has been issued.
This circular doesn't say you can't grant.
No, that cannot be.
The circular says you will have to
certain
take
conditions
permission,
has to be fulfilled.
conditions.
Yes.
But your endorsement is saying it cannot be done.
Yes, ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ. But in the appeal, that reasons have been assigned. But however, there is a revisional power under section 131 before the state that is not. But however, they have preferred a writ.
We direct them to file an application.
Yes, along with
all necessary documents, which will be considered by you within a period of 30 days.
Yes.
There's no need for revision again. No need to waste
Documents
paper.
which has been sought for is already uploaded. It is on site. I'll reapply
Allah.
or re-upload once again because the same documents which are already there on record. So I have to upload the same documents. And as regarding all other aspects, fire safety, then stability of the building and premises, the area which is required, it is already uploaded with necessary plans and structure which is there on the record.
It will be treated as a new school,
It
as
is
a
for
new
9th,
application.
9th and 10th.
So you file that and it will be considered.
With that directions, it may be.
Allah, but the reason for consideration may again in future it may not. Since my lord, he is seeking for Kannada medium for 9th and 10th, then it will be treated as a new school itself. So if a new school is treated, then whatever the infrastructure that has been declared, that he has to fulfill. But the documents which he submits, the existing buildings,
Yes. So
that is pertains to English medium school.
You don't need to have two different buildings.
Allah, building ಆದ್ರೂ at least ಆ infrastructure ಇರಬೇಕು ಅಂತ ಹೇಳಿ that is the government.
ಇನ್ನೊಬ್ರು AGA ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿದ್ಮೇಲೆ ಹೊಸ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿ.
Specifically insofar as 9th and 10th ಅಂತ
ಇನ್ನೊಬ್ರು ಅಡಿಷನಲ್ ತಹಸೀಲ್ದಾರ್ ಅಂತ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿದಾಗ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿ. They're running a school. They want to do for Kannada now by encouraging Kannada in a rural area.
That is true, my lord.
How
But
can you make it into a new school completely? They can use the same facility.
But infrastructure has to be.
Infrastructure is there.
Allah, ಅದೇ same existing building ಇದನ್ನೇ ಹೇಳ್ತಾರೆ.
Whether it satisfies, if the infrastructure is good for 200 people,
yes,
is it good for 250 people? If it is not good, tell them that.
Yes.
You do it.
Right, please.
If you can't say for 50 people have separate infrastructure.
No. That is not my lord. But since it
nobody will be able to do it, and children will suffer.
Please.
Petitioner is before this court seeking for the following relief. The grievance of the petitioner has been running a school from 1st to 8th standard in the English medium known as Gnanamatra Rotary English Medium Primary School at Nagaralli village, Hubballi Taluka. The said school is not admitted to any aid from the government, is a private school run by the petitioner from and out of its own resources. The petitioner, with the intention to further Kannada medium, encourage Kannada medium, wanted to start classes for 9th and 10th in Kannada medium, and as such made an application. The said application came to be rejected by respondent number 2.
Please.
Wide order dated
31/8/2023.
31/8/2023 at annexure B on the ground that classes for 9th and 10th in Kannada medium could not be run in the same building and same premises where the English school is being run. An appeal having been filed, the appellate authority also rejected the said appeal on the ground that an application for conducting 9th and 10th standard classes would have to be treated as a separate school and a fresh application would have to be filed. It is challenging both the above orders that the petitioner is before this court. Shri Prakash K. Javalkar, learned counsel for the petitioner, would submit that the petitioner has no objection for filing any application for permission enclosing all the relevant documents establishing compliance with the applicable law, but however submits that the said classes for 9th and 10th standard also being run from the existing premises, the facilities which are provided in the existing premises would also have to be taken into consideration while considering the application filed by the petitioner, and not treated as a completely different new school requiring all the facilities to be made available. There is substance in the submission made by Sri Javalkar inasmuch as there is existing infrastructure which has been set up by the petitioner for students from class 1 to 8 standard, of course, in the English medium. It is only an addition of class 9 and 10 for Kannada medium which is being made. There is no embargo as such for running the 9th and 10th, for conducting classes for 9th and 10th standard in Kannada medium in the said premises, except that it being in Kannada medium, necessary license for the same, necessary recognition and license for the same is required to be obtained by the petitioner. As such, reserving liberty to the petitioner to file a application along with all supporting documents establishing compliance with the applicable law and the rules, as also the circulars issued from time to time. The petition stands disposed. The respondent number
2 and 3.
2 and 3.
2 and 3.
First they are considered. Respondent number 3 is directed to consider the said application by taking into account the infrastructure and facilities already established for class 1 to 8 and not seek for further establishment 1 to 8 ratably to ensure that the facilities are available for all the students.
Let there be some time limit because it has to be an
The submission of Sri Prakash Javalkar that the application would be uploaded onto the website within
I'll do it within 1 week.
Within 1 week from today, having been taken into consideration. The respondent number 3 is directed to pass necessary orders thereon within a period of 30 days from the date of the application being uploaded by the petitioner,
Please, ma'am.
if necessary, by due inspection of the premises within that time frame.
Please.
130, Mallikarjun Swami.
I seek your 2 days time, Your Lordship. I seek 2 days time, Your Lordship.
29/1/25.
Yes.
One thing ಆಯ್ತು.
The reason is that they are confusion with the.
Your Lordship said directed if order is not complied, DC to be present.
What happened, Your Lordship, they are under confusion that in WP number 63891 of 2022, they are under the impression that the records were signed. But it was also regarding KLA society. And that impression, they told that the records are signed.
Application number is in detail ಬೇಕಪ್ಪ.
Afterwards, Your Lordship, I told them it is the case number. So, Your Lordship, have it on Tuesday, Your Lordship. Even they are confusion.
How can they be confused when the application number is there? Then, see, if that is the instructions that they are giving you, then that means they are acting mala fide.
No, not like that. But you
Only to delay this.
if that case number is also by the KLA society, that they are under the impression.
KLE Society has filed only one application in 624059. Nobody else can file an application with that number.
Not that Your Lordship, WP number. In that
WP number alla.
Adralli, that WP was filed KLA society. Under that impression, they are.
Ask your officer not to take it lightly.
Yes.
If required, we'll have to pass orders.
Tuesday, Your Lordship, I have Tuesday.
Third time,
yes,
they can't be doing this. Then AGA once again seeks for and is granted a 3 days time to comply with the order dated 29/1/2025. If needful is not done by Angbada. This court, while order dated 29/1/2025, had directed the learned AGA to secure the file pertaining to the applications mentioned therein. Thereafter, when the matter was listed on 6/2/25, learned AGA sought for a short accommodation to comply with the same. When the matter was taken up on 10/2/2025, again, time was sought for and granted. It was made clear that second respondent, if the file was not made available, the second respondent would be personally present before this court. Today, the second respondent is neither available in person nor the file has been placed on record. Though this would be a fit case for issuance of a bailable warrant, at the request of the learned AGA, it is not done on the specific assurance made by him that the file would be placed for consideration on 18th
Yes.
February. Relist on 18th
2:30.
at 2:30 p.m.
On 31, K.R. Anand.
Milord, I appear for the
Well,
respondents in
I
this
appear
case,
to be petitioner in this matter.
Yes.
Milord,
How long will you
this
take,
repetition-
Mr. Chinanda?
Milord,
Mr.
it will
Anand?
not take, Milord, sole ground urge is, Milord, that.
And how long will you take? Sole ground,
Milord, it's about
dual
10,
ground,
15
triple
minutes,
ground?
Milord.
I may take
10, 15 minutes, Milord. It will not take more than 10,
15 to
15
20
minutes. It will not take more than 10 minutes, Milord, to convince your
10 minutes
lordship.
by you. Mr. Anand,
Yes.
The same, on 15 ನಿಮಿಷ.
your time starts now.
Please, please.
Please start your stop clock.
Yes.
Yes, Mr. Anand.
Please, Milord. Milord, the petitioner is a mining activity. On 16/9/2019, it had to stop or discontinue the mining activity because the lease license had not been renewed from
You are appearing for
16/9/19.
the employer and Mr. Chidananda is appearing for the labor.
No, Milord,
Yes,
that
yes.
is a pro bono. Those workers came and requested me, Milord. I am appearing
Yes,
pro
Mr.
bono.
Chidananda.
Yes, Milord.
Yes.
It's pro
Yes,
bono
go ahead, Mr.
appearance,
Anand.
sir.
Please. No, my lord, the license had to be renewed at the state government level. And however, the license was not renewed. Nevertheless, from April 2020, up to April 2020, full salary was paid to all the workmen. That is September, October, November, December, January, February, March, April. From 16/9/19 to April 2020, full salary was paid. This is one aspect of the matter.
License expired in September 19.
16/9/2019. That was the last date.
When did you file a renewal application?
1 year prior to it.
Date?
Almost 1 year prior to it. And the renewal happened only, I think, only recently.
Now it has been renewed.
Now, only recently it is renewed. No, my lord, in these circumstances, the petitioner informed all the statutory authorities with regard to the stoppage of the mining activity as required in law, the ESI, not ESI, sorry, PF, the Inspector Factories, the Mining Authority under the Payment of Wages Act, who is the Regional Labour Commissioner, and a few other authorities were informed. Now, my lord, in the meantime, after payment, because we thought initially the license would be renewed in about 6 to 8 months, since it was not renewed, we did not also pay any wages. Thereafter, my lord, all the workmen numbering around 250 or so, they come to Bangalore Regional Labour Commissioner's office, complaining against the petitioner, alleging that they have not been paid wages. And when we were also called, we appeared before the authority, explained the situation. Then the authority gave a choice of finding out if there is any possibility of an amicable settlement, since license renewal might take some time. 158 workmen took their settlement and went away. Full and final settlement. They got their settlement and left. These
150 out of 2 or 250.
Around 250. These respondents, my lord, numbering around 72, they approached the Regional Labour Commissioner Ballari under the provisions of the Payment of Wages Act, claiming wages on the allegation that I have illegally closed my factory in violation of Section 25O of the Industrial Disputes Act, and also allege that I have violated 25M of the Industrial Disputes Act, and therefore they claim full wages for the period of for around 31 months. Now, my lord, my preliminary objection before the Regional Labour Commissioner was that the application would not be maintainable. Nevertheless, he passes an order holding that I have closed my factory without seeking approval and permission of the appropriate government, and therefore the workmen are to be paid full wages for the period. Now, that order is appealed against before the appellate authority under Section 17. The appellate authority also confirms the order.
Yes.
Now, the point for my lord's consideration is, in a given situation, admitted situation where a unit is stopped, discontinued, where it does not amount to closure, it does not amount to retrenchment in law, it may amount to layoff, it might amount to layoff, or it might amount to lockout also. Now, under such circumstances, the contention of the petitioner has been that the workmen have to approach the appropriate industry tribunal to eke out their reliefs, and the authority and the Payment of Wages Act has no powers.
Now that the license has been renewed,
please,
can they come back and work with you?
They can. Now, my lord, what has happened is, many of mining settlement ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. These workmen, they work in the workshop and the factory. Now, the workshop and the factory will take some time for its commencement, probably another 2-3 weeks or 4 weeks. Now, in this background,
after 3 weeks, you'll take them back and pay
we could work out. Yes. If not all in one stroke, in a phased manner, we can certainly work out. We will certainly need experienced hands. We can certainly work out.
What about back wages?
Payment of that has to be adjudicated by the Industrial Tribunal. Now, authority under the Payment of Wages Act, under the provisions of the Payment of Wages Act, he totally gives a go-by. Section Chapter 5B of the Industrial Disputes Act has become redundant. He says closure is illegal. I have not complied with the requirement of seeking prior permission, and therefore he grants wages, full wages, which is impermissible in law, my lord. My lord is very well aware.
They are not laying, Mr. Chidanand,
Please, my lord.
They are not laying you off, or they are not sending you home. They are taking you back.
They have not laid me off. They have not closed. Our wages have not been paid, my lord. Therefore, we have approached the authority under 15(2). My lord, the sole contention urged before the authority and before.
And now, are you ready to go back to work?
Yes, my lord. We have been requesting them to give us the work. That is the reason why they wanted us to resign, my lord.
Now the wages have not been paid from April 2020.
Yes.
Till now, from May 2020.
Yes, my lord.
So that is nearly around 4 years, 5 years.
I'm sorry. This court directed, my lord, deposit 50% of the amount and also directed to pay 50% of the bank guarantee. We have not been paid the wages, my lord. My lord, if they don't have the work, my lord, my learned friend has rightly submitted, my lord, we are working in the factory and workshops, my lord. So workshop and factory is not closed. They have been running by taking the granite blocks from other quarry leases. Now, my lord,
we'll go to the merits later.
Yes, my lord.
Now, Mr. Anand is saying that they can take back to you. You are saying you are ready to go back. So
Yes,
that is
very
one issue sorted out.
Yes, my lord.
Now the issue is only as regard wages from May 2020 till now.
Yes, my lord.
Do you want full wages, or any settlement can happen on the terms of wage?
My lord, law requires, my lord, them to pay full wages.
Law requires, but
yes, my
lord. We are looking at, if there is a settlement, instead of you both litigating, your employer and workman.
Yes, sir.
If there is some possibility of you giving up something and Mr. Anand's client coming halfway,
Very well.
This could be resolved instead of litigating.
Very well, my lord. I'll put it across them, my lord. Let him take them back to duty, my lord, immediately. That is the one prayer, my lord.
That way, Mr. Anand has categorically submitted.
So, my lord, let them
In
take
3
back
weeks'
the
time,
duty.
they'll start taking you back in
My lord,
phases.
let him pay, my lord, 50% of whatever now it is the wages, my lord. And then, my lord, then I can put it
Why
across
don't
to
both
them.
of you talk to each other?
Yes.
Why don't you both have some coffee and
Yeah, no, I can, my friend Anand, I can talk to him. Always I can talk to him.
Anytime,
talk to each
anytime.
other
Yen ತೊಂದ್ರೆ ಇಲ್ಲ.
and see what it is?
Yes,
There's a very small thing for both of you to sort.
Please, man.
Unless there are some other issues in the background.
No, no, no. There are no other issues, Millet. In the background, it is very, very clear, Millet, that these people, they want their employment back because at this age, Millet, they will not get employment.
Employment, Mr. Anand guarantees.
Yes.
It's only the
Very well,
amount of
Millet.
money that is
They will,
required.
I'll ask them to report even tomorrow only. If my learned friend is ready to take them, Millet, I will telephonically tell
First,
them, Millet, to be
amount
there
close
in the
ಮಾಡಿ
bank
ಆಮೇಲೆ
premises
take
tomorrow.
back ತಗೊಂಡು ಅಲ್ಲಿ ಗಲಾಟೆ ಆಗದ್ ಬೇಡ. Both of you, this weekend you sort it out. We'll have it on Monday.
Please, Millet.
One war, because the employer is in Chennai, my lord. I will have to, I may be kindly granted just 1 week, next Friday.
We'll have it on Monday. Both of you talk and hammer out something. Then later your employer, your client can approve it. What is reasonable, both of you can work it out. And once you advise your client, Mr. Anand, your client will accept it.
Please. I'll find
More
out.
or less, there may not be any issue once you advise.
ಈಗ ಚಿದಾನಂದ I'm sorry, through my lord. My lord is advising us or directing us that we meet and try to resolve with regard to wages for this 4 years
No,
and
no,
all,
first you should
and
take
also
them back to
employment.
work. That is what important. First, you should take them back.
Insofar as taking back, you are saying you will do it in phases. So
Yes.
as phases you will have to work out.
Please.
Two is the wages which are pending from May 2020 till now. What is the settlement that you can arrive at? In what manner? In what percentage of it you are willing to pay? What percentage they are going to give up? ಇಲ್ಲಾದ್ರೆ ಇಬ್ಬರಿಗೂ ಬರಲ್ಲ litigation ಆಗ್ತಾ ಇರುತ್ತೆ. You won't have the workmen, they won't have employment. This will go on for another 5 years.
Yes, it's true, man.
ಅದುವರೆಗೂ tomorrow reporting won't happen if you don't agree for this.
Yeah. But I'll talk to him, Millet. I will, whenever they want, Millet, I'll instruct them to be there and join the duty, Millet. Let him give the employment first.
ಅದು ಫಸ್ಟ್ ಇದೀರಾ ನೀವು
Yes.
ಅದರಲ್ಲಿ ಫಸ್ಟ್ you sort out the wages.
Yes.
Wages sort out ಮಾಡೋಣ.
Reporting we'll direct whenever.
Please, Millet.
Sort out the wages so that they can get the money and continue work.
Yes, I will ask all of them to come to one or two people to come to Bangalore on Saturday. I'll talk to Anand and then we will arrange a meeting, Millet, with them. This thing. Let my learned friend also call their authorized representative who will take a decision so that the decision can be taken up on Saturday.
Yavattu, when do you want this matter to be listed?
Next Friday ಆಗ್ಬೋದಾ ಚಿದಾನಂದಯ್ಯ?
Tuesday, your lordship, have it on Tuesday.
ನೀವು ಯಾವತ್ತು ಹೇಳ್ತೀರೋ ಅವತ್ತು. If it's settled, we are very happy with that.
Yes.
18.
Because some of them they don't have any money. Virtually, they are starving.
That is why sort it out before. Otherwise,
Yes.
you'll be here for 5 years.
Yes. That's the reason. Yes.
Mr. Anand clients have deep pockets. They'll be litigating.
Yes, they will definitely.
Writ petition, writ appeal, Supreme Court.
ಇಲ್ಲ. Now they are broke, almost broke, my lord.
No, in fact,
5
I
years.
think my learned friend may not be knowing. I know this granite block they sold at the rate of $1,200, $1,300.
ಅಲ್ಲ
ಅದೇ ಸರಿ.
ನೀವು ಇಬ್ಬರಿಗೂ ಎಲ್ಲ ಗೊತ್ತಿದೆ, ನಮ್ಗೇನು ಗೊತ್ತಿಲ್ಲ, ನಮ್ಗೆ ಗೊತ್ತಾಗೋದು ಬೇಕಾಗಿಲ್ಲ. You sort it out. We don't want to hear any commercials. You sort it out.
Therefore, your lordship's observation of deep pocket made me to say so, because they have quite capable of paying this wages, Millet. That's all I am saying.
Yes, you sort it out.
Yes.
After arguing for some time, both counts. After arguing for some time, after hearing the counsels for some time, I have the considered opinion that this is a fit case for settlement. The present impasse which has been arrived at cannot be blamed on either the petitioner or the respondent, but is a circumstantial event which has led to this situation. Hence, on inquiry with the counsel for the petitioner and respondent as to whether the matter can be settled, both of them submit that they'll explore the possibility of settlement with an open mind. To facilitate such discussion and to report settlement if possible, relist on 20th February at 2:30 p.m.
Please, sir. Please.
We made it an order of the court so that you can tell both of them.
Correct. Obliged, my lord. Grateful.
132, Chetan Manoli.
Lords, on the last occasion, your lordships had directed me to produce the original sale deed, my lords, the petitioner. Lords,
Yes.
as per my instructions and as per the records, my lords, the petitioner had produced the original sale deed in the LAC proceedings, my lords, and also he had filed an application before the executing court for calling for records from the LAC. Lords, I could not ascertain what happened to the application because the order sheet wasn't legible, my lords.
So again, Madam.
Lordships may consider calling for records from LAC, which states that a review was pending, my lords, on that.
Take its own sweet time.
Belgaum alli. Otherwise, my lords may.
Amount is held from past 20
They
years.
have withdrawn, my lords. That is, executing court has.
The amount I have withdrawn, my lords. But till half portion of my amount is held up because I'm the owner of
2012 matter.
I agree, my lords. It was not listed for.
Yes, that is why you got it listed.
I agree.
All the
One,
old
my lords,
matters are listed.
petitioner may be granted some. My lords, he is also making efforts to get the copy of it. Lords may grant me 1 week's time, my lords.
And where is the LAC? LAC na special SLA na? Where are the
LAC, my lords, on the LAC 153 of 1982, it appears that the decree holders had filed review in miscellaneous, my lords.
History is directed to secure the records, forthwith secure the records in LAC
Miscellaneous.
number 153 of 1982.
Miscellaneous, my lords. These LAC records were further called for in miscellaneous
Then
21.
pending on the file of the second additional civil judge senior division, Belgaum, as also the records in
miscellaneous number 21 of 1992, same, my lords, court.
miscellaneous number 21 of
1992.
92 pending before the same, then
Second
pending
addition.
before the same court. Considering that the above writ petition is of the year 2012, the additional registrar judicial is requested to secure the same as early as possible, if necessary by messenger. Relist on 19th February.
Yes, obliged.
List 2, 230 matter. 1, KL Patil, Arvind D. Kulkarni.
Lord, yesterday I have produced the photos.
Ms. Chandrasekhar.
I'm appearing, my lord, for the respondent.
Now you are the right Arvind Kulkarni in this matter, Mr. Mr. Patil, Mr. Desai, Anand Bandi. Yes. Yes.
Photos I have produced yesterday, my lord.
You are appearing for the petitioner.
Yes.
You are appearing for Ms. Chandrasekhar. You are appearing for whom?
Respondent plaintiff, my lord.
Respond number 1. Yes. Mr. Desai. Yes.
And photos I have produced, my lord, if your lordship permits me.
Michael.
If your lordship permits me, that way, in laptop it will be clearly seen. CD is made. I will try to show that position what is there exactly. And if your lordship is pleased to see these photographs, this was the condition. Last.
Only the photographs.
Page number 9, I have produced photographs. Day before yesterday I have produced. Page number 9 may be seen.
Yes.
This was the condition of that original Nala. And again, therein the slab has been put, it is brought under this thing.
So Nala is below the slab. Nala
Yes.
continues.
Yes. And on that slab only, my lord, that is Rajkalve, slab only beautification is being made by these petitioners.
And people are residing next to the Nala.
They were earlier next to the Nala, they were passing by keeping one stone and other things there. That has been made this thing.
Yes.
And thereafter, if your lordship please to see the photographs at page number 6, the way in which we are trying to do it, that is there, and there is ample space between their shops and this road Nala also. Nearly 10 to 15
What
feet.
is under challenge here first, Adeli?
They claim that they have got the easementary right over this Nala, and they want to use this as a parking place and others. And there we should not make any beautification and other these aspects. The lordship may find the plaint. Plaint at plaint prayer at page number 20, my lord. Sorry, plaint prayer at page number 40. 40.
Yes, what happened in this suit?
They have filed temporary injunction application, IA number 1.
Yes.
And that IA number 1 came to be allowed, restraining us from proceeding. We have nearly done 60 to 70% of the work.
Page?
Our application is at page number 44, my lord.
Application 44, order 72. You did not file objections.
WS.
Written statement.
This page number 82 is the order of the trial court. Here were restrained by way of temporary injunction.
File written statement 1 and 2.
What? Written statement is not filed. Only objections to the IAs are filed. And then, my lord, we filed
Para 3 defend number 1 and 2, though appeared through their counsel, did not choose to file objection to the application. Defend number 3 filed written statement containing that he is nowhere concerned with the proposed construction.
Defend number 3. Defend number 3 is the executive engineer KUW.
Where's your objection?
To this IA, my lord.
You have filed written statement. Prativadi number 4, the written statement is that.
Prativadi number 4 is before this court now.
Yeah. Neevu yarge?
4. Page number 53 is our written statement.
Defend number 1 and 2 where?
Defend number 1 and 2. 1 is the deputy commissioner, 2 is the commissioner of municipalities. Work is being carried out by defend number 4.
Yes.
Para page 62 on page 62, para 31 onwards, my lord. 30
So
onwards.
when was this slab put up?
To that 2022.
22. 22
17,
ಮೇಲೆ easement right
18.
claim ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
17-18.
22, 17-18 ಇಂದ easement right claim ಮಾಡ್ತಾ ಇದ್ದಾರೆ. Yes.
And para 29 onwards is our written statement contentions. Because it is surrounded by slum area and backward class area. For the children to play there, we are making that provision. Government has sanctioned 1 crore rupees, which we are utilizing and making that for the public purpose.
Yes.
And we are not closing their way also. There is nearly 10 to 15 feet way is there in front of their shops also.
Yes.
2 minutes, if I display that video, my lord, it makes clear the situation of what is going there.
A pen drive lidre will play it here so everybody can see. Not only separate ಇದು ಬೇಡ.
Pen drive ಇದೆ sir.
ಬಡಿ play ಮಾಡಿ ಅದರಲ್ಲಿ. ಇವ್ರ ಕರೀರಿ play ಮಾಡಿ. Let everybody see what is there.
Yes.
ಅದರಲ್ಲಿ play ಮಾಡಿ share ಮಾಡಿ. ಅದಲ್ಲ ನಿಮ್ಮದು. In the meanwhile, you can make your submissions.
Yes, bro. Your lordship may please to see the prayer in the plaint is regarding easement. Whether he is entitled for the easement over this Nala this thing.
Raj Kalwe.
And Raj Kalwe itself is a point to be considered because this is hardly used for the public purpose and they cannot claim easement right over this. That too when we put the slab on near 2017-18. And their prayer for easement right will not survive at all. If the suit itself does not survive, there is no question of interim injunction also. And more than that, what they claim is their right of way is obstructed. There is no space left. There is a space nearly 10 to 15 feet space is left between this Raj Kalwe and their shops. That is a way made for them. Even we have made ways for that road to this
road. That space has come because of making this slab. Otherwise, that space was not there.
Yes. And then we have made each CDs we have put, even here what we are grill we are putting, every 15-20 feet we are making, giving the way for them. So way to move from this side to that side. Therefore, it is a public purpose, my lord. When we are doing it for the public purpose, 1 crore rupees sanction, we have spent nearly more than 60 to 70% of the money. And we have done nearly 60 to 70% of the work where there is no obstruction at all. Now, only because of these shop holders, they claim that this is the obstructing us and they have restrained us from doing this. Therefore, I filed objections to the IA that it was confirmed. And thereafter, I filed miscellaneous appeal before the trial court, before the first appellate court. First appellate court dismissed by appeal. Therefore, I am before this honorable court. And in my humble submission, my lord, they cannot restrain us from doing the infrastructural work, which is beneficial to the public at large, even for them also. What the observation made by the trial court and the first appellate court is matter to be trial. And then what we are doing is, it is not a permanent structures also. They are doing in such a way that anytime they can be removed also. They are not permanent structures. Therefore, my humble submission, my lord, grillu idu haki, and then we are making some play this thing and other things. So if they restrain us, unnecessarily the public money itself will be wasted even we are doing this. We have collected all the materials on the way to do this. And therefore, my humble submission is the injunction order may be modified and the stay may be granted and we may be permitted. If they succeed in the suit, yes, we will remove all those things from there itself, subject to result of the suit. And easement right, first of all, I submit that suit itself is not maintained.
Share ಮಾಡಬೇಕು ಈ ಚಂದ್ರಶೇಖರ್ ಅವರು ನೋಡಬೇಕು.
Lord, as far as the construction is concerned, my lord.
Just a moment, Mr. Chandrasekhar. Complete.
Lord, there is no dispute with regard to, my lord, the nature of the property and the construction that is. Lord, I am aware of it, my lord. The question is whether the plaintiff has, my lord, whether the petitioner before your lordship has any right to put up such a playground and the swimming pool over the Raj Kalwe. That is the question that is required to be considered. My lord, one way is, my lord, your lordship will kindly see page number 1, my lord. Just now your lordships have seen, my lord, the memo, the photographs produced.
Yes.
Now kindly see, my lord, there is a road. There is a road, my lord, in opposite to the shops. Earlier, my lord, what is shown, my lord, in page number 9, my lord, it was, my lord, open drain.
Yes.
My learned friend has said, my lord, that they used to put some stone, hard stone, to cross over the my lord, the nala and reach my shop. Therefore, from the road to the shop, there was always a way, my lord, meant for their shop. People used to cross, my lord, the nala and reach my shop. So right of easement is there right from the day, my lord, the road is existing, my lord, in that place. In that way, my lord, it is not the nala that, my lord, which determines the period of limitation to ask for right of the easement. That is not the case. Now the question that is required to be considered is whether the petitioner before your lordship belonging to an irrigation department has any right to put up, my lord, playground or the infrastructure for my lord, for making the beautification, or my lord, for the gym equipment and a swimming pool over the my lord, this nala, or
The
my lord,
petitioner is only a contractor. You very contractor alam.
Nirmiti Kendra is a contract.
Who is the employer?
Nobody knows.
No, Nirmiti Kendra, it is a society registered in the Societies Act, working executing the government work. Government
ಇನ್ನೊಂದು ಮೈಕ್ ತಗೊಂಡ್ ಮಾತಾಡಿ ಅವ್ರು ಕೇಳಿಸಲ್ಲ ಆಮೇಲೆ. ಅಲ್ಲಿದೆ ಇನ್ನೊಂದು ಮೈಕ್ ಇದೆ ಗಂಗಾಧರ್. ಇನ್ನೊಂದು ಮೈಕ್ ಇದೆ.
Your lordships are aware, my lord. There is an act called Parks, Playfield and Open Space Act.
You won't come under that, Mr. Chandrasekhar.
Lord, my lord, what I am trying to say, my lord, is the parks, playfield and my lord, open space is regulated under this act. This
Which is
not a
designated
park.
to so and so. This is something that they are trying to form over the Raj Kalwe.
My lord, it is
So
not
that act
permissible.
will not apply to this
My
particular.
lord, it is not permissible, my lord. May I request your lordship kindly see, my lord, section 7 of this act.
Let us find out who is doing this first.
The petitioner
Nobody
is a
knows, my lord,
society.
who is doing it.
That is why we are asking the additional advocate general.
My lord,
If he doesn't know, nobody will know.
But all the Nirmita Kendras in the districts are created under the societies. This working
that
under
is the
the
reason,
deputy
Lord, I would-
working under the deputy commissioner, executing the government projects.
So this
Construction of the
project has
government.
been approved by whom?
It is a fund given by the irrigation department.
Fund, yes. Is there a project report?
This is a project approved by the deputy commissioner with the consent of the municipality. So in the year 2019, the canal was being constructed. Earlier it was an open canal, there is no drainage at all. It was constructed 2019. Till then, there is no objection from anybody.
So where is the project report?
You have produced yesterday only.
You filed the project report. Where is it?
KNN.
ಇದು ಕರ್ನಾಟಕ ನೀರಾವರಿ ನಿಗಮ್ ಲಿಮಿಟೆಡ್.
park ಮಾಡಕ್ಕೆ ಏನ್ ಸಂಬಂಧ? Lord, they are not concerned with Lord, developing a infrastructure of establishing a park playfield. They are spending the public exchequer money, my lord, over this project for which, my lord, they are not at all concerned. Your lordship will again kindly see, my lord, the funds are being
Mr.
drawn
Chandrasekhar,
from.
we are asking some questions to the AG. If you keep on interrupting, then we can't ask.
I am only assisting your lordship, my lord.
Not by interrupting, please. Not by interrupting.
The fund
is a project approved by the deputy commissioner.
The fund is given by the Niravari Nigam to the petitioner society. The petitioner society, chairman of the petitioner society, all the deputy commissioners are the chairman of this Nirmiti Kendra.
They may be, the chief secretary may be the chairman.
Please, ma'am.
But that won't make this into a government organization. It won't make it the government. It's only a government organization. So where is the government approval for this? Government ಅಂದ್ರೆ deputy commissioner ಇರಬೇಕು ಇಲ್ಲ secretary urban development ಇರಬೇಕು. It's only the government authorities, government who can do this.
Niravari Nigam taking the after authorization only given the fund to this society, Mirat.
Fund you can get CSR funds.
Please.
Funds is not a major issue.
Please.
Funds, there are plenty of funds. Is it being done in a proper manner is the question. Is this project approved by the concerned authority who has the power to approve it? Tomorrow KNL will come and say they'll form one road here before the High Court because they have the money.
For this, yes, for the consent, these are the coming under the area of the municipality, my lord. Municipality has given approval for this.
So where is that approval?
They have given
KNL
approval.
fund approval is not.
No, municipality has my lord, the fund is aided by the KNL, my lord.
KNL seems to have all the money except for making payment to the land losers. Land loser interest kodu andre avag bartare. Duddilla anta. The SLO's award has been delayed. We don't have money. Nenne alla ade alla argument agiddu. They seem to have a lot of money for this. How can that money of KNL be used for this? KNL's money was only to be used for the acquisition of land and to make payment to the land losers on time, which they are not doing. Like Mr. Chandrasekhar is saying, this is wasting the money for something else of beautification. But even if it is so,
it is
where's
for
the
not
approval?
for the necessity, my lord. It's open drainage and all those things, my lord. It is not for the.
It is
the
for
major-
the municipality to do
it's
it
public
from the
purpose.
municipal funds
Lord,
by a resolution passed by the municipality in the council,
my lord, in respect
approved
of,
by the commissioner of the
my lord,
municipality.
in respect of the development is concerned, my lord, the funds have been used from the different department also. So sometimes tourism department also give the funds. Sometimes ML and legislative assembly council members
Yes,
will give the
shows
fund.
the approval by the concerned authority, Mr. Gangadhar.
Please, that I will place, my lord.
There is
Tomorrow,
nothing
my lord.
here.
Tomorrow, my lord.
There is self-certification by Nirmiti Kendra, funds being given by KNL.
And the
current state authorities has not passed any swan.
But this project is coming under the deputy commissioner, my lord. See, the project.
ಯಾರ್ ಕೆಳಗಾರ
Please,
ಬರ್ಲಿ?
we will place the, please.
The permissions
tomorrow.
have to be, if all the permissions have been taken, then the civil remedy would not be available. They'll have to challenge that.
Please. Have it tomorrow, my lord.
But if you have no permissions, then a civil remedy under this court would be maintainable. Writ petition, they can't come.
Otherwise, on 18 to 30 minutes, I will submit all that.
A memo along with the estimate and the consent of KNL to make payment of the amounts towards the implementation of the project, as also photographs have been placed on record. The same does not indicate any approval either by the municipality or by the state. The mere acceptance to fund cannot be treated as an permission by the state authorities.
Municipality permission is there. But
Place it.
I will produce all the things together.
In that background, the counsel for the petitioner has also
Government
9
deputy commissioner
are directed to place the necessary documents on record. Relist on yavattu?
on 18th, my lord, 2:30
at 2:30 p.m.
Please.
ಅದು ಪ್ಲೇ ಮಾಡ್ಬಿಡೋಣ ಹೆಂಗು ಹಾಕಿದಾರಲ್ಲ.
Yes.
ಇನ್ನೊಂದ್ಸತಿ ಅವ್ರಿಗೂ ಶೇರ್ ಆಗ್ಬೇಕು. ಚಂದ್ರಶೇಖರ್ ಅವರು ನೋಡ್ಬೇಕು.
ಅಲ್ಲಿ ಬರ್ತೈತೆ.
ಕಾಣಿಸ್ತಾ ಇದೆಯಾ ಮಿಸ್ಟರ್ ಚಂದ್ರಶೇಖರ್?
Not yet, my lord.
ಇಲ್ಲ, ಶೇರ್ ಮಾಡ್ಬೇಕು.
This was previous, prior to doing it.
You are appearing for whom, Mr. Desai?
Municipality.
You will have to place. Mr. Bundy? Or yaarge? Who is
It
Mr.
has
Bundy?
come on record it has come on record, my lords permit me. It has come on record that municipality has opposed and they have given a letter to stop the construction. When council was in my lord, the helm of affairs, and thereafter the commissioner says you continue the work and complete the work. Subsequently,
Yesterday you got the
5 days notice. Only yesterday, my lord. I will also revert on 18th.
Mr. Bundy. Dayanand Bundy. Aur yaarge?
He is formal party. He is for respondent number
11.
11. KUW.
Who is R11?
Drainage.
KUWS and DB board. Hello, Rahul.
may I request your lordship kind attention, my lord, to two of the provisions. I'm sorry.
Is the video now seen, Mr. Chandrasekhar?
Yeah, I see it, my lord. It is visible, my lord.
This was how it was earlier.
Yes.
Yes. Your lordship may also notice, my lord, this was prior to, my lord, the construction of that slab over it.
Yes.
Just prior to that. So there was an additional digging.
Where are the shops? These are all houses.
My lord, just next to it, my lord. It comes earlier to that, my lord.
Encoded format. Yeah, which is the provision you are speaking of, Mr. Chandrasekhar?
Lord, section 7 of the Karnataka Park, Playfield and Open Space, my lord.
Parks.
The entire park, my lord, in the state, my lord, is regulated under this act. Now they say, my lord, they are going to make a park, my lord, over the Rajkalve. The competent authority, my lord, to regulate the maintenance of park is, my lord, the commissioner, my lord, of a division. Divisional commissioner.
We don't have the book here, not as you are instructing counsel, so.
Lord, may I just read, my lord? It is only 4 lines, my lord. I will.
Yes, please.
The government may, at any time, either so moto or at the instance of the local authority concerned, or any person interested, including the new land in the list. Before including such new lands, the government shall publish in the prescribed manner a draft notification proposing such inclusion together with a notice specifying the date on or after which such draft will be taken into consideration, and shall consider any objection or suggestion which may be received in respect of such drafts from the local authority concerned or any person interested before the state so specified. If they want to, my lord, make it this as a park and regulate it and spend the my lord, public money over it, my lord, they will have to specify that this is going to be the park. They will have to give a notice, publish in the newspaper, and we will have an opportunity to either to oppose it or to accept it. And thereafter, my lord, they can spend money, my lord, on the establishment of the park and playfield and maintain it, my lord, by the corporation. This is not a venture, my lord, by the corporation. Some ST, my lord, corporation funds were there. They have drawn these funds, my lord, from that corporation and hand it over to the Nirmiti Kendra, and they want to spend this 1 crore of rupees.
And this fund is coming from KNNL.
No, my lord. Let them state it, my lord, on oath whether it is coming from KNNL. My instructions are, my lord, they have stated so, my lord, in the written statement. It is for their benefit. This, my lord, park is being established. I am also instructed to state, my lord, there are, they say, my lord, in the name of scheduled caste, scheduled tribe and backward class. I am instructed to state, my lord, that there are no dominant resident of SC/ST, my lord, in this area. It is dominated, my lord, by the shops and establishment. Further, my lord, there are some houses. Otherwise, my lord, it is a main road from railway station, and people are residing, my lord, doing business, my lord, on this road. Just because some funds were available, they want to spend this money, my lord,
So
on this road.
you want this drain to be demolished now?
No. My lord, this was done, my lord, much prior to the proposed thing, my lord. There is a road, my lord. There is an existing road, which was there from time immemorial.
You want the drain to be there, but no park to come up on it.
Yes, my lord, people are parking, my lord, on the drain.
So you want one benefit, not the other one. You want to take the benefit, but not the
park. Lord, because it obstructs, my lord, entry into my shops.
Yes, you want to take the advantage, but not the
Kindly
disadvantage.
see the road, my lord. There is a road. Abutting the road, my lord, this canal is there. And people are parking their vehicle and walking to the, my lord, my shops.
ಒಂದು ಯಾವ್ದಾದ್ರು ಪ್ಲೇ ಮಾಡಿ ಕರೆಕ್ಟ್ 2-3 ಪ್ಲೇ ಮಾಡಿ ಸೀಕ್ವೆನ್ಸ್ ಅಲ್ಲಿ ಉಂಟು.
Lord, that is the road, my lord.
Yes.
That is the existing road. Lord, there is a temple, my lord. People have not objected there. They have put up construction. Now there is a barricade, between the road and, my lord, the houses and the shops and establishment. They have created a barricade, my lord, the compound wall over the.
Now the playground is coming on the road or on the slab?
On the slab, by putting up, my lord, the barricades around the slab. People cannot cross, my lord, the slab.
Yes. So if there are areas which are demarcated for people to cross, then there is no problem.
My lord, there cannot be, my lord. They have put barricades, my lord. There are photographs, my lord.
We can direct the removal of barricades. In Bangalore, the entire Gandhinagar thing was done in a proper way. Now it's come out so well.
Yes.
Again, all the shop owners had the same issue.
There is no playground, my lord.
That the
There
shop
is no
access
playground.
is
There is no
stopped.
swimming pool. There cannot be swimming pool. There cannot be a playground.
Swimming pool is also for people. It's an amenity, Mr. Chandrasekhar. If your clients don't want to swim, they are not required to.
Lord, it is to be established, my lord, in a park and play field, my lord. An area where it is specified, my lord, by the under the act.
Once we have the act, we'll go through it. You can always make your submission. We are trying to understand the facts right now.
Kindly see this photograph, my lord.
Yes.
Now there is an obstruction, my lord. They will put barricades, my lord, around this slab.
Yes.
And people cannot walk to my shop.
So your problem is as regard to barricades?
Yes, my lord. That is what we have pleaded, my lord.
Any other problem you have?
My entry into the shop, my lord, is obstructed. People are parking their vehicles.
Your entry is through the road. That is not obstructed.
My lord,
only the slab is the issue.
Public used to park their vehicle, my lord, on the slab. Vehicle used to be parked,
That
my lord,
easement
on the
cannot
slab.
be done from 19 to 22, Mr. Chandra. Public used to park in the slab means they should have parked it in the drain before that.
It was not part of. It was not part
You
of
can't
the
claim
process,
easement right on that basis, and not on behalf of the public.
Easement right is not through, my lord, the slabs, my lord. slab over the
Chandrasekhar,
canal.
when
The
you are
easement right
appearing,
is
you would
from the
expect a
road.
little better, that the development should be permitted. And you should
My
come
lord,
up
it
with
is to be done.
solutions
My lord,
as
my
to how
respectful
this could be
submission is,
done
my
rather
lord,
than obstructions.
my lord, it should be, development must be, my lord, in a place which is earmarked, not in a place where it is not meant to be used as a park.
Then we'll direct the removal of the slab, continue to remain next to the drain.
My lord, the drain was made, my lord, to see that, my lord, the
Yes,
pandemic,
so
my lord,
we'll put back the clock to
constructed, my lord, during
2019
the
as what
pandemic.
you want, that the drain cannot be covered, nothing can be done on the drain.
Drain was
We'll
covered,
accept
my
that.
lord, to avoid pandemic, my lord, diseases. It was done during that period, my lord.
Yes. So you
2019
want to
and
take the
2020,
advantage of the
my lord, was
drain,
the period.
the money being spent on it, you want to take advantage, but the disadvantage of it, you don't want to take. Or you want everything for your benefit. That cannot be sustainable.
Lord,
Apart
the
from
question
this,
is, my lord, whether
we
they
are
have right to do
presuming
it.
for now that you have all the permissions and this one. If it is not there, we'll demolish everything. Number one. Two, if those things are there, presuming that all the permissions are there, the main issue is as regards the access. So you should make available certain.
But already before that, my lord, my instructions are that the 10 pathways were existed before the construction of the drainage. Those are continue to be there.
So you show us where it is,
Even
what
under
is
the
the
project
width?
report also, even under the project report also, those
Page?
pathways were existed.
Page.
Sir, the map is also map.
Last page of the
Where is the pathway is not shown.
last page. Even in the photograph, page number 5 also it can be seen. Last page.
The last page, Miller.
Page number 70.
Road is there.
Other Pakkakela is.
What is CD5, CD6, CD4?
They are the ways.
These are the ways.
They are the cross.
They are for crossing.
Usually crossways.
2, 3, 4, 5, 6, and 7. And what is the distance between each pathway? 68 meters. Idella meters alla? 68, 38. They're pretty close. What is the width of each pathway?
Width of between the pathways, Miller.
Pathway width.
The pathway.
4.75.
5 feet also is there, sir. 15 feet
5
also
feet,
is.
15 feet, 18 feet, different ways.
But in fact, in file number 3, my lord, we could see the pathway.
Document ಬೇಕಲ್ಲ, make it part of it. ಇನ್ನ ನಿಮ್ ಸ್ಟ್ಯಾಂಡ್ ಗೊತ್ತಿಲ್ಲ. Mr. Chandrasekhar is making you in no man's land. You are with the petitioner or with the state.
They were with the, my lord, the plaintiff earlier. Now they have changed the side, my lord. They want to shift to the respondent number 4 side.
So
Public
when the arguments happen, whose side will you be on? We'll have to see on Tuesday.
On page number 64, my lord, it shows that the municipality has granted permission.
You make your submission.
Please.
A pen drive with videos of the location prior to the construction of the slab and after the construction of the slab were produced. The same was played in open court to be viewed by all the counsels for the respective parties, including Sri S.M. Chandrasekhar, who appears through the senior counsel, who appears through video conferencing.
Please.
All the counsels have also, by pointing out the videos, explained the location and the status of the matter which has been taken into consideration.
May I produce this pen drive with this to the court?
Played and seen.
Please.
ನೀವು ಅವ್ರಿಗೂ ಕೊಟ್ಬಿಡಿ.
Yes.
List on 18th at 2:30 p.m.
2 Anandar Kolli.
For the petitioner.
The dictation ಆಗಿದೆ ಅಲ್ಲ ಇದು. ಶ್ರೀರಾಮ್ ಡಿಕ್ಟೇಷನ್ ಆಗಿದೆ ಅಲ್ಲ ಇದು. ಆಗಿಲ್ವಾ? ಎಸ್. ಇಲ್ಲ. told.
That is the requisition submitted by the members.
24/12.
12/2024, based on which, my lord, Form 2 has been issued on 3/1, fixing the date on 18/1. Separate, Adhyaksha has been given separately and Upadhyaksha declarations have been given two separate.
You enclosed it also.
Yes. And we have also individually served to them and they have also endorsed that.
Here also, my lords, the same, my lords, the PDO.
Really the PDO.
Please.
Where is the PDO?
Where I had been produced along with the memo, my lords.
It is not there here.
Yes. On the top, my lords, the signature of the assistant commissioner, same, my lords.
Is original illa PDO signature.
Certified ಮಾಡಿದ್ದಾರೆ. Where they have been issued the same.
Certified those.
Yeah, I had been produced, my lords, along with the memo. That is the office copy that has been submitted.
This is being given by the assistant commissioner.
Please, miss.
Assistant commissioner's office.
Yes, ma'am. This is the assistant commissioner.
But the original available in the assistant commissioner's office is completely different. One of the signatures of serial number 19 is not there.
19, my lords.
Signatures are also different.
Where, my lords, this is the, my lords, the requisitions has been provided by the certified when I had been applied.
There are 20 names here, there are 19 names there.
One, my lords.
What is happening, Mr. Kalsurmat?
Please.
19, my lords,
What's happening at the assistant
Hanmantappa.
commissioner's office.
Signature same, my lords, Hanmantappa and 21 not signed, my lords. Here only the 19 members signed.
Lord, I have gone through the entire original file, but the document which they have produced along with the memo, it is not part of the record.
So, have you seen the memo that they have produced?
Yes, yes. Just now I have gone through.
Yes.
Idರಲ್ಲಿ
Where
there
did
is
this come from?
Please. List 19 candidates idare.
Dhrudikitra.
By the PDO anta ide.
No, this is certified copy.
Yes, my lord.
Given by the Upavivadhikarigala Parvagi.
Yes, ma'am. That is the concern.
Whose signature is this?
Lord, one. I don't agree. This is the signature of the grade 2 Tahsildar anta ಹೇಳ್ತಾರೆ. As grade 2 Tahsildar, signature of the grade 2 Tahsildar.
So from where did he give this certified copy?
But original file ಅಲ್ಲಿ ಇಲ್ಲ ಅಲ್ಲ. As
ಸರಿಯಾಗಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಳ್ಳಿ.
ಅಲ್ಲ, please. He says that this document which is produced by the they have maintained a separate second file But the notice has been issued based on this requisition which has been submitted in the original file. That is that file. This on this requisition they have not acted upon.
Then why is certified copy of that being
Allah,
given?
either the certified copy or kotidare. But the notice which has been issued, Form 2, is acted on that requisition which has been submitted in the not on this. But they would have submitted the certified copy of that. They should have not issued this.
Why do you have two of these requisitions?
Andre, my lord, as per his instruction, he says that, my lord, when the members came to submit this requisition, the assistant commissioner instructed that since already we have instructed not to take any receive endorsements. So
This is 24/12.
yes, same day, ಎಲ್ಲ ಅದು ಸೇಮ್ ಡೇನೆ, ಟೈಮಿಂಗ್ ಇಲ್ಲ ಇದರಲ್ಲಿ, ಸೇಮ್ ಟೈಮಿಂಗ್
Our order. This
ಹೌದು.
is.
So that was already brought to the notice of the assistant commissioner that there is a observations and the inquiry has been initiated not to take any signature of the PDO. Straight away they have to requisite. But on this requisition they have not acted upon. Thereafter, my lord, again the members given that requisition on the same day. So on that basis, the assistant commissioner has acted upon and issued form number 2. This instruction is on the basis of the assistant commissioner. This has not been acted upon.
Same date.
Allah, ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ
Date
ಇರೋದು.
same.
The members have given again a second.
File an affidavit of the assistant.
Yes, ma'am. Yes. To that effect, we will file affidavit.
That AG seeks fund is granted 2 days time to file the affidavit of the assistant commissioner as regards the certified copy produced by the petitioner along with the memo dated 6/2/2025. Released on 17th at 2:30 p.m.
Please.
No, on, my lords, on 19th, 17th, my lords, we are all moving to Bangalore. Allah.
ನಾವು ಬರ್ಬೋದು.
19th, my lords.
19th.
Please.
ಹಾಗಾದ್ರೆ 17th ಏನು ನಡೆಯಲ್ವಾ?
ಸ್ವಲ್ಪ ನಡೆಯಲ್ಲ.
18th ನಡೆಯಲ್ವಾ?
Welcome. 17th.
ನಾವು ರಜೆ ಹಾಕ್ಬಿಡೋಣ.
We all
ಅಧ್ಯಕ್ಷರ ಪರ್ಮಿಷನ್ ಇಂದ ರೆಸಲ್ಯೂಷನ್ ಇನ್ ಶಿಲ್ವನ್
majority are going.
Majority are going.
Allah, except the lordships and the state government advocates have to be there.
17th we have got 75 matters, 18th we have got 91 matters right now.
On 18th?
No,
Allah, that is the only point, my lord, on 17th.
No, other points.
Please.
19th.
Please.
At 2:30. ಇನ್ನು
233 matter. Sadiq Gudwala.
Page 14.
This
is Adhyaksh Amalvara. Representation is given for no confidence motion. On page 15, on the bottom, ಈ ಮೇಲೆ ಸಹಿ ಮಾಡಿದ ಎಲ್ಲರೂ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಸದಸ್ಯರ ದೃಢೀಕರಿಸಿದೆ. ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಚಬ್ಬಿ.
ಅಲ್ಲ, ಜಸ್ಟ್
ಅದೊಂದೇ ತೆಳಗೆ.
Lord, by tomorrow I will get instruction and make say 17th can go election.
and AG accepts notice for respond number
1 and 2.
1 and 2. 3 ಯಾರು?
3 ಧಾರವಾಡ ಪಂಚಾಯತ್ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಚಬ್ಬಿ. ಧಾರವಾಡ ಯಾರು? ಗ್ರಾಮ ಪಂಚಾಯತ್.
ಶಿವರಾಜ್ ಬಳ್ಳೊಳ್ಳಿ ಜೂನಿಯರ್ is from Chabbi.
ರೋಷನ್ ಚಬ್ಬಿ.
Roshan Chabbi.
Yesterday the copy is issued to me.
Notice to respond number 7 to 12 is deferred from now, for now. That AGA seeks fund is granted a day's time to make a submission as regard the endorsement of the PDO.
Please.
At page 15 of the petition. Released tomorrow at 2:30.
Please.
My presence may be disturbed. My friend, my colleague will
ನೀವು
ನಾಳೆ ಬೆಂಗಳೂರಲ್ಲಿ ಪಾಲ್ಟಾಡಿ. Mr. Dharwad will appear.
Our persona non grata, not acceptable.
It is the case for my lord interim order.
Disposal. Sir, copy ಕೊಟ್ಟಿದೆ. Number.
10-11-02.
So all the matters will.
My lord, one submission.
Serial number 78, my lord. Serial number 78, it's regarding that council submission, my lord.
Monday.
In fresh list, my lord, along with the council submission.
ಇವಾಗ ನಮ್ಗೆ ಆಪ್ಷನ್ ಇದೆ ಮಂಡೇ ಆರ್ ಟ್ಯೂಸ್ಡೇ ಅಂತ ಹೇಳಿ.
ಮಂಡೇ ಅಲ್ಲ, ಮಂಡೇ ಆಗಲ್ಲ.
Serial number 71.
ಏನ್ 78 ಏನಪ್ಪ?
ಅದು 78 regarding that council submission, my lord. As per annexure G, my lord, I am not made as a party. Who is the respondent?
ಇವೆಲ್ಲ ಹೊಸ ಮ್ಯಾಟರ್ಸ್.
ಅವಾಗ ಹೊಸ matter, my lord. 78 fresh matter, my lord.
70 to 78 release tomorrow.
In fresh.
ಫ್ರೆಶ್ ಬರಲ್ಲ.
preliminary hearing.
ಬರಕ್ ಆಗಲ್ಲ ಅದು.
It's already
ಏನನ್ನ
already reach ಆಗಲ್ಲ ಸ್ವಾಮಿ.
71,
kindly overrule their office objection.
my lord. Office objection has been overruled.
ಯಾವುದು?
71 serial number 71. ಅವರಿಗೆ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಆಗಿದೆ. ಅವರು I learned that they have appeared in this matter, my lord.
71 learned counsel for the petitioner submit that the office objections have already been overruled. Emergent notice have been issued. Respondents have entered appearance. Registry to verify. Release tomorrow.
Passed over.
Serial number 75 minutes.
Passed over.
Serial number
My lord, 68, my lord. 68.2, my lord.
ಹೇಳಿ.
Ali, my lord, there was an interim order, my lord. Last occasion, my lord, it was listed before the Kotal 7. Lord, interim order was not extended, my lord.
Your process fee ಕೊಟ್ಟಿದ್ದೀರಾ?
Process fee I paid, my lord. Today I paid, my lord.
68 learned counsel for the petitioner submit that process fee has been paid. Registry to verify if needful has been done. Issue notice to the unserved respondents. Returnable by 22nd April. What about deceased 6 and 20?
My lords, both are the same respondents, my lord. I'll by next.
ಅದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
ಯಾವ್ದಕ್ಕೆ, my lord?
Deceased respond number 6 and
ಇಲ್ಲ, my lords, I'll file it, my lord. Today, my lord, this it is.
Today only interim order to be extended.
ಅಲ್ಲ, ಇವತ್ತು ಅದು ಬಂದಿದೆ. Today it is showing first time, my lord.
68.1L learned AG accepts notice for respond number 1. Released on so.
68.2 only interim order.
Earlier granted is extended till next week.
Serial number.
Please, my lord, much obliged.
Serial number 75.
The
office has raised the objection that, my lords, the prayer is not correct, but prayer is correct.
To correct everything.
Serial number 1, my lord, it was passed over.
Preliminary hearing.
ರಿಪೋರ್ಟ್ ಹಾಕ್ಬೇಕಂತ ಹೇಳಿ ಅವ್ರಿಗೆ my lord said direct
ಆಗಿದೆಯಾ?
ಅದು AG ಬರ್ತಾರೆ ಅಂತ ಹೇಳಿ.
I requested that AG will appear in morning.
Report file ಆಗಿದೆಯಾ?
No, I have no instruction insofar as that.
File ಆಗಿದ್ರೆ we'll have it tomorrow.
My lord, I had to see.
If you want time to file it, we'll give you that time to file. Otherwise, ಸುಮ್ಮನೆ ಲಿಸ್ಟ್ ಮಾಡಕ್ಕೆ.
A date may be given. My lord, I will ascertain, I will make submissions.
May I request on, my lord, 24th.
Bond is granted 3 days time to file, to verify and file the report by the Principal Secretary Revenue Department. We list on
May I request on 24th, my lords?
24th.
Please.
Serial number 75 request for Tuesday.
Tuesday ನೀವು ಇರುತ್ತಲ್ವಾ?
Tuesday.
ಸರಿಗೊಂಡು ನಿಮ್ಮ ಪಕ್ಕದಲ್ಲಿ ನಿಂತ್ಕೊಂಡು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಟ್ಯೂಸ್ಡೇ ಅಂತ. ಎಷ್ಟು ಧೈರ್ಯ ನೋಡಿ. 75?
75. Wednesday.
Tuesday. Wednesday.
Serial number 67. Last occasion, your lordship direct the government to secure the records and file it.
ಏನಪ್ಪ ಮೆನ್ಷನಿಂಗ್ 5 ಕಾಲ.
Tomorrow ಇದು declared.
ಯಾವುದು?
67.
67 writ of mandamus sought for. And now deputy commissioner has asked.
Without any accusation, utilize the land of the petitioner.
Declaration suits have been filed not owner of the property. That declaration suit has been to dismiss. RA dismiss. RSA dismiss.
Mr. Mandgani, if you are such a good case, it will get dismissed. ಸೋಮವಾರ ಮಂಗಳವಾರ ಅವ್ರಿಗೆ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಸೊ ನಾಳೆ ಇಲ್ಲ ಬುಧವಾರ ಹೋಗುತ್ತೆ. 67 at the request of counsel for respond number 7 released on released on 20th.
Serial number 11, lords.
Serial number 76, my lord. Compared with the office objections, there's only one objection. There's one objection regarding payment of court. I've complied with it. Kindly have it tomorrow, my lord.
Tomorrow, it will be repeating tomorrow.
76 ನಾಳೆ.
Serial number 11. 11, my lord, passed over matter.
I am here.
ಏನ್ ಹೇಳಿ?
My lord, it is regarding compromise. We both filed compromise petition before the trial court, my lord. Even we filed the joint memo.
File wakalat. We'll pass orders.
Please, my lord, it may be taken on Monday. Tomorrow I will file the wakalat.
Monday idira?
Lords.
Tuesday, my lords.
ಇದ್ರೆ ಫೈಲ್ ಮಾಡ್ತೀವಿ.
Tuesday, my lord.
ಇನ್ ನಾವು ಹೇಳಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮಾಡ್ದಂಗೆ ಆಗ್ತಾ ಇದೆ.
Yes, sir.
11 released on Tuesday, na? 18th.
Please.
Serial number 111. Serial number 111. Wherein I have filed my memo stating that alternative appeal is provided. And I have also submitted, served a copy of memo to the my land friend. Burji is also there.
Yes, Mr. Burji.
My colleague appears in this matter. I request on some other day.
On last 2 occasions, I have also submitted.
111 at the request of counsel for the petitioner, released on 20th.
Please, Serial number 125 minutes. This is for final hearing. I appear for respondent number 3.
Yes.
Lords, it's a 321 notice that has been issued. Petitioner are agreed by that. It's an initial order. Short matter, my lords.
321-1.
Yes, my lords.
Not 3.
No, my lords. One. Agreed by that order, they have before
Mali.
your lordships.
Where is he?
Chandramalli.
Reach I got doubt. 125 released on 20th.
Oblige.
Serial number 98. I request for Monday or Tuesday.
98.
Respondent.
Monday. ಯಾರ್ಯಾರು ಮಂಡೇ ಬೇಕು ಹೇಳಿ ಮಂಡೇ ಆಗ್ತೀವಿ.
ಅಲ್ಲ ಅದಕ್ಕೆ ಮಂಡೇ.
98 ಮಂಡೇ.
Serial number 14. 74, my lord. Yesterday also it reached, my lord. When matter reached, file was not there, my lord. 74.
74 ಮಂಡೇ.
My lord. 14, my lord.
ನಾಳೆ ಬರ್ತೈತೆ ಅಂತ ಹೇಳಿದ್ರು.
Serial number 14. Sir, urgent, sir.
They were supposed to file an affidavit, they have served it. 73.
May I please, my lord?
In 73.
Serial number
73 ಏನಪ್ಪ?
70, my lord.
230. Lordship directed my lord respondent number 2 commissioner to file affidavit. So far as my lord to ascertain on what ground my lord annexure G was issued.
ಇಲ್ಲಿ ಎದ್ದೊಂಡರು ಮುಗಿಸ್ಯಾರ
ನಂಬರ್ ಪಾಸ್ವರ್ಡ್ ಹೇಳಿ ಲಾಗಿನ್ ನಂಬರ್ 24903
ಪಾಸ್ವರ್ಡ್ ಗೊತ್ತಿಲ್ಲ ನನಗೆ ಲೀನಸ್ ಆಗಬೇಕು
Respondent number 2 commissioner is filing affidavit my lord stating that.
What is the affidavit?
My lord, it has been stated my lord that there was a complaint my lord subsequently given by the complainant. Pursuant my lord, earlier inspection was conducted based upon the complaint given by one person. My lords, after inspection, my lords, he gave one more representation stating that in his absence, my lords, that inspection was conducted and he will bear all the expenses to conduct the second survey. My lords, only on that ground, my lord, we have issued an intimation letter, my lord, stating that survey is, my lord, is fixed on so and so date.
So when are you carrying the survey?
My lords, it was on 3rd of February. Lords, your lordships had stated that impugned intimation letter. And your lordships had directed us to file an affidavit asking us to state the reason on what ground.
Your order was demolished, not
No, my
survey.
lords, the order is not to demolish. Order is only to my lord conduct survey. Construction, my lord, is we are not halting the construction.
So when are you going to conduct the survey?
Lords, on 3rd of February, my lords.
Now when are you going to? 3rd ಆಯ್ತು.
Yes, my lord, I will ascertain, my lords.
73. Learned counsel for respondent number 2 has filed an affidavit of respondent number 2. He submits that given a week's time, necessary survey and measurement would be carried out and a report filed.
Serial number
Survey
14.
to be carried out commencing from 10:30 a.m. on 20th February. Report to be submitted
Lords,
by.
one submission. Earlier, my lord, survey was conducted and report is also filed. My lords, that was submitted, my lord, to the complainant. He has raised an objection. He has other remedy.
ಇವಾಗ ನಿಮ್ಮ ಸರ್ವೆ ಪ್ರಕಾರ everything is okay?
Yes, my lords, it's okay.
Then what is there?
Yes, my lords, I leave it to lordships, my lords. Let me be.
Serial number 14, my lord.
73. Petitioner is before this court seeking for the following reliefs. That counsel for respondent number 2 has filed an affidavit of the commissioner indicating that the construction which has been put up by the petitioner is proper and correct and there is no violation. Though there is a objection raised by the complainant. In view of the fact that the commissioner has filed an affidavit that the construction which has been put up by the petitioner is proper and correct, I pass the following order. Writ petition is allowed. A certiorari is issued. The endorsement dated 27/1/25 at annexure G is quashed.
My lord, serial number 14. My lord, 74. Before the execution court, my lord, Monday, they have date, my lord.
Before naale repeat.
My candidate 230. Possession. execution court has directed to hand over the possession, my lord.
40 AM 74 ivalu.
74, my lord.
Yes.
My lord, petitioner has filed the suit for partition and separate possession, my lord. And that came to be disposed of in terms of the compromise, my lord. Petitioner and respondents are the brother and sisters, my lord. My lord, as per the terms of the compromise, my lord, both the sisters, that is respond number 1 and 2, are agreed to hand over the possession of the suit property after 5 years, my lord, from 2020-21 Dasara festival to 2024-25 Dasara festival, my lord. And again, the brother and sisters agreed orally, my lord, and the sisters leased the property, suit property to the petitioner, my lord. And now they, after this all things, they have filed the EP, my lord, stating that they have not handed over the property to the respond number 1 and 2.
3 was only till October 24.
24-25, my lord.
24,
Dasara
25,
festival.
that's of
Please, my lord.
October. October, Dasra Mugitu.
Please.
Your lease, there's no document that you have produced.
It is oral lease, my lord.
Oral lease, how
But
can
I have produced the documents, my lord, which I paid annually 3 lakh rupees, my lord. Annexure C series, my lord.
But that cannot be a ground unless you have a document to establish.
No, my lord. But
We'll have to
the
go by
terms of
the-
the agreements are, my lord, the sisters will relinquish their right over the suit property after enjoying the suit property for 5 years, my lord.
Yes.
Now, to get the benefit out of that, my lord, they have illegally, now they file, after 3 years, they have filed the EP, my lord.
Like 24, 25, Dasara is what you agreed upon.
Please, my lord.
That is come and gone.
No, now the sister, themselves have filed the EP, my lord.
Yes.
After a lapse of 3 years, my lord, compromise decree. Sister has to enjoy the
Shows the compromise decree.
My lord, annexure B25, my lord. And 30 are the page number 30 terms.
ದಾವದಲ್ಲಿ ದಾವದ ಆಸ್ತಿಯನ್ನು 2021 ದಸರಾ ಸಾಲಿನ 5 ವರ್ಷದ 2020 ಸಾಲಿನವರೆಗೂ 1 ಮತ್ತು 2 ಯಾರು?
Sisters, my lord. Respond number 1 and 2.
ರಾಜೇಶ್ವರಿ ಅಂಡ್ ಸೌಭಾಗ್ಯ ನಮ್ಮ ಕಬ್ಜೆಯಲ್ಲಿ ಇಟ್ಟುಕೊಂಡು ತಮಗೆ ಮೂರನೇ ಪ್ರತಿವಾದಿ is ವೀರೇಶ್, is the brother.
Now to gain the unjust enrichment at the cost of petitioner, now they have filed the EP, my lord. Because, my lord, after the Dasara festival of 2024-25, the petitioner and the respond number 3 will become the full owner of the suit property.
So they want to delay it.
Please, my lord.
Further proceedings.
My lord, the execution court has directed me to, they have filed an IA, my lord, under order 21 rule 35.
21/2025 order.
Please.
Further proceedings. In execution petition number 29 of 2023, pending on the file of the senior civil judge and JMFC Bhadgi, as also the order dated 21/2025 passed therein at annexure A, is stayed till the next date of hearing. Issue notice to the respondents 1 and 2, 1 to 3.
Lord, 3 may be
by
dispensed.
12th March, process fee and copies to be furnished by end of day 15th February acknowledgement for service on the counsel appearing for the respondent before the trial court, before the execution court to be filed on or before 19th February, failing either of which, the interim order will stand automatically
My
vacated.
lord, notice to respond number 3 may kindly be dispensed.
Let him come.
Please.
He is also important.
No relief.
Serial number 103.
Serial number
on
70,
Wednesday.
interim order may kindly be
103. Serial number 103 taken up on Wednesday. Wednesday.
103.
Please.
22, no urgency.
Since
Lords kindly.
respondent is aged 80.
Just a moment, please.
Respondent is aged more than 80 years, my lords. Say, the commissioner report, my lords, that is filed in execution.
And ಹೇಳ್ಬಿಟ್ಟು ನಮ್ಮ ಬೇಜಾರು. Yes.
Serial number 120 madam. I am for the respondent number 1 madam.
120. ಏನಾಗ್ಬೇಕು?
Date 19th date be fixed madam. 19ನೇ ತಾರೀಕು.
ಇಲ್ಲ 2024 ಬರುತ್ತೆ.
ಅದ RSA ಒಳಗೆ
Serial number 100, my lord. BRTS acquisition matter of 2020.
Serial number
100. BRTS acquisition matter acquired in the year 2012 and not paid any amount, and they are not
paid compensation.
Not paid any compensation.
100 Tuesday idira?
Yes.
Tuesday.
It may be posted 2:30.
Serial number 115. Lordship directed the respondent to file a report. It may taken up on Tuesday, my lord.
115 Tuesday.
The Lordship, serial number 94.
Interim order.
The petitioner's land has been acquired in the year 1996. No compensation is paid, my lord.
94 Tuesday. Tuesday idira?
It is.
Interim order.
Interim order.
Please.
Serial number 64, Lords. There is one more connected writ petition. It has to be
64
listed.
connect with so and so and relist on?
Lords, after 25th, any date.
Relist on 11th March.
Lords, there is an interim order in this matter.
Interim order.
Please.
75, I am for respondent, seeks accommodation to file the objection.
75, the counsel for respondent seeks for and is granted 2 weeks time to file a statement of objection. Objections.
My lords kindly.
28th February, relist on 11th March.
My lord, serial number 66, my lords. Serial number 66, my lords. We have filed an acknowledgement for having served the counsel for respondent
They
before the
won't
trial.
come. Notice has to be served.
My lords, there was an order, my lords, before.
Yes, and after the amendment happens, we'll take that into account.
Please,
Until then, no.
interim order may kindly be extended.
66 interim order extended, relist on,
In-
relist on 11th March.
Okay.
My lords.
Yes, on the VC.
My lord, even at 131, serial number 131, interim order extend ಆಗ್ಬೇಕು sir.
131 interim order. Yes.
Please. Serial number 70 also, my lords. 70.
70, yes, extended.
Interim order, please.
Yes, Mr. Gopal.
14, my lord, it was passed over. I'm sorry, I was not present at that.
ಇವಾಗ ಆಗಲ್ಲ.
ಅಲ್ಲ.
Maybe
That is
tomorrow.
with regarding to formation of road 3 feet forest area.
Not forest area, my lord, because the forest area, they have given the endorsement that there is sufficient.
It appears to be a private dispute between both of you. It's not a public dispute.
Ilasami, no private dispute because there is no other private person holding the land. Only it is a petitioner. Petitioner has given up his 18 feet of
We'll have it on Monday.
Please, my lord,
11
please.
on Monday.
Because the entire land belongs to the petitioner.
Huh?
Entire land, the private land belongs to the petitioner.
Yes, 14 on Monday.
Please, my lord, please, my lord.
One submission. 115, they made a submission that they want to file a report. There, my lord, the petitioners are unauthorized cultivators and they have filed applications under 108(c). Now their applications have been rejected, stating that the entire land is a forest land and their underhand 8th application has been rejected.
15 Tuesday.
Please.
Sir, ಅದು 70.
ಸರ್ ನೀವು ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನಲ್ಲ 75
Sir.
ಅಂತ. 70.
ಅದೇನ್ ಡೇಟ್ ಏನು ಮಾಡಬೇಡ್ರಿ ಏನು ಬೇಡ ಅದು ಅರ್ಜೆಂಟ್ ಆಗಲ್ಲ ಯಾಕಂದ್ರೆ ಅವ್ರದ್ದು ಅಬ್ಜೆಕ್ಷನ್
70 ಬೇಡ ಮೇಡಮ್ 70 ನಾಟ್ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಬಿಡ್ರಿ ಬೇಡ ಅದು ಈಗ 75 ಅಂತ ಹೇಳಿದ್ರು ತಪ್ಪು ಹೇಳಿರೋ ಸೀರಿಯಲ್ ನಂಬರ್ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಕಷ್ಟ ಬೇಡ ಅಂತ ಬಿಡ್ರಿ ಅವ್ರು. ಇಲ್ಲ ಬೇಡ ಅಂತ ಬಿಡ್ರಿ ಅವ್ರು ತಪ್ಪು ಹೇಳಿದಾರ ಅವರು
81 for dismissal.
Dismiss.
ಬೆಳಗ್ಗೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ಸ್ ಕೇಳಿದ್ರಲ್ಲ
Dismiss.
89 ಏನ್ ಬರ್ಕೊಂಡ್ರೆ ನೋಡ್ರಿ 89
The serial number 37 ಏನಾಗಿದೆ?
80 ಏನಾಗಿದೆ 80 ತೋರಿಸಿ
Sir, ಒಂದೇ.
ಅದೆಲ್ಲ ಇದೆ 89 ಅಂತ ಬರ್ಕೊಂಡು
ಹಂಗ ಬರ್ಕೊಂಡ್ರೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಅದೇ dismissal ಇದ್ದಿದ್ದೆಲ್ಲ ಸರ್
ಮೇಡಮ್ ಒಂದೇ ನಿಮಿಷ. ಸರ್ ಹೇಳಿ ಪಾಟೀಲ್ ರೇ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹಾ ಹೇಳಿ.
ಸರ್ 69 ಏನಾಯ್ತು ಸರ್ ಇದು 69
69
69 ಏನಾಯ್ತು
ಕೋಟಿ ಬರ್ತೀರಾ ಜಗದೀಶ್ ರಿಲೀವ್ ಮಾಡಕ್ ಬಂದ ಕೋರ್ಟ್ ಕೆಲಸ ಕರ್ಕೊಳಕ್ ಬಂದಿದ್ದಾರೆ
69 ಅರ್ಜನ್ ಆಗುತ್ತೆ.
ಅರ್ಜನ್ ಆಗುತ್ತೆ ಓಕೆ ಸರ್ ಥ್ಯಾಂಕ್ ಯು
ಹಾ ಆಯ್ತು.
ಸರ್ 37
ಮೇಡಮ್ ಸರ್ ಒಂದೇ ನಿಮಿಷ.